number 150.
Survey number 1.
150, serial number 1, survey number 150. That is area in square meters, 505 square meters.
Correct.
Then serial number 2, in survey number 151/1,
Ah,
there is 1115 square meters.
correct.
And then there is
Total
400
comes to 2020.
and 400 square meters which went to the road portion. If my lord would see annexure E at page 51, which is the JMC's survey sketch.
No, what is meant by it goes to road portion?
So in the conversion, my lord, in the conversion order, the road portion is not converted because that is government land, the road portion.
Please.
So
I
in the-
stand corrected. Please, I'm
At
sorry.
extent of land and a survey number, they may seek for conversion, my lord. But conversion is given only of the freehold land, not of the
Because that portion of the property belongs to the government itself.
road portion, whatever is, it would amount to,
Where is that?
my lord.
After conversion.
When conversion is granted, because I've just,
When conversion is granted,
my lord,
they have to leave certain portion
my lord,
for public use.
my lord,
Whether that portion becomes government land is the question.
my lord,
If it is the government land, question of paying compensation will not arise.
my lord.
On what basis you are saying that it becomes government land?
No,
The order of conversion.
I think they produced it along with their.
Have you produced order of conversion?
My lord, now, my lord, along with my synopsis, I have produced it. Synopsis
You have
was filed on.
produced it?
Yes.
Conversion order produced ಮಾಡಿರಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ. Annexure
ಅಷ್ಟೇ
R4
case.
ಅಂತ ಹೇಳಿ.
Sir, I don't have a copy. Do you have an extra copy with you?
Which one? ma'am?
Yours and upstairs.
ಅವ್ರಿಗೊಂದು ಕೊಡಿ, ಅವ್ರಿಗೊಂದು
ಆಯ್ತು.
ಅದು conversion order, brother, where is that?
Fine. My lord, Annexure R4, page 8.
Or 4 page 8.
Page 8, my lord. 5/8/2024, I have produced it. This is the conversion order.
In view of above, it is request to call written explanation.
I think
Sir,
it is
R3,
page
my lord.
6. sir.
R3, page 6.
annexure.
R3.
R3. Entire extent of 2020 is converted.
Correct. That is not the question. After conversion, have you given up certain property in favor of the state?
My lord, I have not given up anything.
My
Where
lord
is the-
would- my
where
lord
is-
would
Kindly
see-
see
my
the
lord would
annexure.
see-
It is their case now, which they are trying to make out before your lordships now for the first
So-
time.
My lord would see paragraph 8.
Huh?
Paragraph 8 on page 2,
Paragraph 8 on page 2.
serial number 8, the conditions of conversion.
Page 2 ದಲ್ಲ.
Andre, overleaf.
Internal page 2.
Internal page 2 of the order.
Page 7.
7 of his.
Running page.
ಸಾರ್ವಜನಿಕ ರಸ್ತೆಗಾಗಿ ಅಗತ್ಯವಿರುವಷ್ಟು ಜಾಗವನ್ನು ಮೀಸಲಿಟ್ಟು
ಎಲ್ಲಿದೆ ಅದು?
8ನೇ paragraph.
8.
serial number
Page
8,
eight.
ಷರತ್ತುಗಳು,
Page.
the conditions of conversion.
ಅದರಲ್ಲೇ ಇದ್ಬಿಟ್ಟಿದೆ.
ಅದೇ
It is there in the, Yeah.
page, conversion order
ಅಲ್ಲಿ
is an
page
election.
ಪ್ರಾಬ್ಲಮ್ ಏನು ಅಂದ್ರೆ 3 ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ. ಯಾವ್ದ್ರದ್ದು 7 page 7 ತೊಳಿ ತೋರಿಸ್ಕೊಡಿ.
Page 7 of my, please, ನಾನು ತೋರಿಸ್ಕೊ.
If it is left for government, you are not entitled to
My
compensation.
lord, I only say this.
ತೋರಿಸಿ.
ಆಯ್ತು.
ಕೊಡಿ.
First of all, my lord, there is no demarcation of that extent of land. What is the one? ಅಲ್ಲ, ನಾನು ಹೇಳ್ತಾ ಇರೋದು, I have not left it. It is only one of the conditions ಅಷ್ಟೇ. Conditions ಅಲ್ಲಿ, ಅಲ್ಲ, that is fine, my lord. What I say is, my lord, all along, kindly see annexure 2, annexure 1.
ಸಾರ್ವಜನಿಕ ಹಿತದೃಷ್ಟಿಯಿಂದ ಕರೆಕ್ಟಾ?
ಹೌದು. ಸಾರ್ವಜನಿಕ ರಸ್ತೆಗಾಗಿ. Serial number 8.
ಸರ್ಕಾರ 25 ಮೀಟರ್ಗಳ ಅಂತರವನ್ನು ಕಾಯ್ದಿರಿಸತಕ್ಕದ್ದು ಹಾಗೂ ಖಾಲಿ ಪ್ರದೇಶದಲ್ಲಿ ಯಾವುದೇ ಕಟ್ಟಡವನ್ನು ಕಟ್ಟಬಾರದು.
Not that. Problem is page, Lord, page 7,
number 8,
serial number
ಅದು
8, my lord.
6
That is
of
what
this
is the
one.
one.
ಸಾರ್ವಜನಿಕ ರಸ್ತೆಗಾಗಿ ಅತ್ಯವಷ್ಟು ಜಾಗವನ್ನು ಮೀಸಲಿಟ್ಟು ಸಂಬಂಧಪಟ್ಟ ಸ್ಥಳೀಯ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಕಡ್ಡಾಯವಾಗಿ ಹಸ್ತಾಂತರಿಸುವುದು.
Yes.
Now,
Now, my
I
lord,
bring
this
my
is,
lord.
this is one of,
May I just complete my submission on this? If I may draw my lord's attention to annexure E along with my review petition.
Annexure E.
Annexure E. This is the JMC sketch
Page
at page 51 of my review petition.
one.
Your Honor sees, my lord sees survey number 150.
Your Honor, ಅನ್ಬೋದು. ಏನ್ ನಮಗೆ
Yeah,
ಅದ್ರ ಬಗ್ಗೆ ಎಂತದೇನು?
My,
You also, you can say.
Right.
You also. No.
my survey number 150 is demarcated, then 151 bar 1 ನಲ್ಲಿ 1515 square meters was acquired. Adnally, my lord sees the demarcation which shows a road going there. And on the right side, it says 505 square meters, then 151 bar 1, 1515, 400 square meters is for road portion.
Yes.
So therefore, compensation was not awarded only for that 400 square meters of land. But the order was passed. The order under review, my lord, was passed
On the assumption that it is also, it continues to be whose ownership.
Illa. It was passed on the submission made by the petitioner in the writ petition that the arbitral award was never complied with. In fact, they do not bring it to the notice of this honorable court that payment was made in accordance with the arbitral award and was taken well before the order that was passed in the writ petition.
May I make this submission, please? Now
Please be
kindly,
seated. Please be seated. If I need assistance, I'll call you.
my lord, my submission to your lordship says, initially the writ petition, my lord, was filed by me, saying that the differential amount as calculated by the petitioner himself is not paid to me. Kindly see the,
All right, we agree with that.
Please.
Now tell only ಇಷ್ಟೇ case.
ಅಲ್ಲ ಇಷ್ಟೇ ಕೇಸಲ್ಲಿ
compensation ಕೊಡಬೇಕು.
ಆ ಪೋರ್ಷನ್ಗೆ ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ದೇ ಸೇ ದಟ್ it is only a general condition, my lord, which has been stated there. It does not say ಸಾರ್ವಜನಿಕ ರಸ್ತೆಗಾಗಿ ಅಗತ್ಯವಿರುವಷ್ಟು ಜಾಗವನ್ನು ಮೀಸಲಿಟ್ಟು ಸಂಬಂಧಪಟ್ಟ ಸ್ಥಳೀಯ ಪ್ರಾಧಿಕಾರ
ಹಸ್ತಾಂತರಿಸಬೇಕು.
ಇಲ್ಲ ಕಡ್ಡಾಯವಾಗಿ ಹಸ್ತಾಂತರಿಸುವಾಗ ಕರೆಕ್ಟ್. Now, my lord, now what happens is, who will pay the compensation, my lord, insofar as admittedly it is not a Kharab land, so as to say that or contend that this property, whatever I am going to give it, belongs to the government.
To whom you are giving, you take up that issue with them.
My lord, now kindly see, I have produced two documents before your lordships along with my objection statement. Now, annexure R1 and R3, my lord, R2, page 10 ಅಲ್ಲಿ, they themselves on 6/12/2019, my lord, they calculate the exact amount of
For entire-
compensation based on the arbitral award passed by the learned by the arbitral tribunal. Now kindly may I request your lordships to
It is
kindly
for-
turn to
for-
that
For complete land.
for the complete land, and they take the approval also.
Correct.
They take the approval for this amount.
All that, how
Then,
can,
my lord,
all right, what is your right in respect of that which you are going to, you have to part away that land to the public, local body as the land of the local body. If you have any grievance, work out that elsewhere. That liberty will give you. But they cannot be asked because you are going, why they should pay money for that?
my lord, it is not like
Which
that.
they are not going to use at all.
Now kindly see annexure R1 for a minute, my lord. This this review petition, my lord, is a result of, my lord, this R1 being issued to them.
Yes.
All along, my lord, they kept on
But-
contending that it is 2021 which has been
The writ
acquired.
petition was disposed of by this court-wide order dated 22/10/2021. On the premise that the review petitioner was liable to pay compensation in respect of totally 2020
21,
square meter, 20 square meter.
21,
Huh?
21,
2020
2021 square meters.
actual acquisition.
21 square meters. Whereas they have the meters. First, learned counsel appearing for the review petitioner notifies to the court that in terms of the conversion order dated 12/2/2016, a copy whereof I will set annexure R3, a certain portion of land, converted land, needs to be handed to the local authority in terms of condition 8 of the said order. First order, and therefore, her client cannot be asked to pay compensation for that, regardless of what has been stated in the award. First, next paragraph. Kutkali, please. Learned counsel appearing for the writ petitioner, who happens to be the respondent herein, opposes the said contention, contending that once award is passed, comprising an extent of 2021 square meters, comma, the compensation has to be paid for the entire land, and anything less than that would be offensive of Article 300 capital A of the Constitution of India, as expansively interpreted by the Apex Court in KT Plantations versus State of Karnataka. First. Secondly, he submits that merely because there is such a condition in the conversion order, comma, it is not that the landowner ceases to be the owner of that portion of the land, and therefore compensation has to be paid. So, lastly, he argues that why citizen should be asked to part away of his land free of cost. First, next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, I am inclined to grant indulgence in the matter for the simple reason that the compensation is payable by the review petitioners only in respect of land which they acquire and which avails in terms of that acquisition for actual use. Simple. In other words, regardless of what the acquisition documents, including the award, would say, comma, if there is cogent evidential material to show that what actual extent of the acquired land is, comma, the compensation is payable only for that land. First, of course, it would be ideal if all that has been reflected in the award itself by making appropriate application if need be. First, next paragraph. The vehement submission of learned counsel for the respondent, respondent, who was the writ petitioner, that once award comprises of a certain extent of land, comma, the landowner ceases to be landowner after accomplishment of the acquisition process, and that land vests in the government or the beneficiary, as the case may be. And therefore, full compensation has to be paid in respect of land which has been so described in the acquisition documents, records, appears to be very attractive at the first blush. First off, however, a deeper examination thereof shows the truth, which is otherwise. Seven, the government cannot be asked to pay compensation for the government's land. Seven, in terms of, first off, in terms of condition 8 of the conversion order aforesaid, comma, 400 square meters of land according to entire measurement JR
400.
Yeah,
square-
400 meters, how you have arrived at?
400 square meter, JMC sketch.
James, joint measurement sketch where he also participated.
ಇಲ್ಲ,
Illa.
ನಾನ್ ಪಾರ್ಟಿಸಿಪೇಟ್
JMC is usually done with notice to the land losers
no.
by the.
What you have done ಬೇಕು ನಾವು. ಅದು
Annexure
usually
E.
ಯಾರ್ ಮಾಡ್ತಾರೆ? Government correct
Annexure
ಮಾಡ್ತಾರೆ.
E.
Annexure ಇಲ್ಲಿ 400 ಚದುರ ಮೀಟರ್ ಕಳೆದು ಅಂತ ಇದೆ.
ಇಲ್ಲ ಅವಡ್ನಲ್ಲೇ
Annexure E.
ಅನೆಕ್ಷರ್ ಇ ಅಲ್ಲಿ
Sketch.
ಕಳೆದು
What is
ಅಂತಾನೆ
the
ಇದೆ.
JMC?
Annexure E.
ದಟ್ ಈಸ್ 54, page 54 ಅಲ್ಲಿ
51.
51
51 is it? Annexure
51's.
last portion.
51.
Yes.
There's a taluka surveyor deputed to the NHAI's office who would carry out
Annexure
the.
E.
400 ಚದರ ಮೀಟರ್ ಕಳೆದು
ಕಳೆದು
115 ಚದರ ಮೀಟರ್ ಅಂತ ಬರ್ತಾ ಇದೆ.
ಏನ್ ಬರ್ತಪ್ಪ?
ಅಲ್ಲ ಅದು ಮೇಲೆ 500 ಅದ್ರದ್ದು ಬರುತ್ತೆ. 505 ಸರ್ವೆ ನಂಬರ್ 150.
For the government lands is the principle which all standard books like V.G. Ramachandran on law of land acquisition and compensation say. On paragraph quote ಮಾಡಬೇಕಾದ್ರೆ.
No, this my lord, they have not issued any notice to me. Before
You are-
the big
anyway,
date.
you have accepted
This-
condition, you have not challenged. Otherwise also, it's only extent. Work. In fact, the JMC, a copy whereof avails at Annexure E to the review petition at page 50, specifically mentions exclusion of 400 square meters of land. First. Next paragraph. The contention that even for this 400 meters of land, compensation has to be paid amounts to countenancing a claim for compensation in respect of land which would not eventually belong to the ownership of claimant. First up. That amounts to acquiring the property of the government, to say the least.
Lord, it is my land, my lord, it is not
You have
government.
said that, we are saying that. I may be wrong, is it not? We may be wrong, we have right to be wrong also.
No, no, it is not like that, my
Subject to
lord.
be
I am only-
corrected.
I am only saying that, my lord, all along, my lord,
Next.
it is my land. They have,
In the above
either of them,
circumstances,
my lord, have illegally acquired my land
this
to an extent
petition
of.
succeeds, review petition succeeds to the effect that what is payable by way of compensation to the landowners who happened to be the writ petitioners is in respect of an extent at measuring 1,621.
1615.
Right?
Totally it
Page
is 1000,
59 if my lord would.
Total ಎಷ್ಟಾಗ್ತದೆ?
total 1621.
2020 ಅಲ್ಲಿ 400 ಕಲ್ದು
ಹಂಗಾಗಿ
1615. ಅದು ಅಲ್ಲಿ page
21.
59 ಅಲ್ಲಿ ನೋಡಿರ್ಬೇಕಂದ್ರೆ.
21 ಹೌದು, ಹಂಗಾಗಿ.
21 ಅಂತಾನೆ ಬರೋದು.
Sorry, my maths is wrong. My maths let me down. I'm so sorry.
There is a-
600.
There is a Shruti, there is allegation after Jayalalitha's case. There is an allegation against the Karnataka High Court that it does not know elementary arithmetics. But it is against court.
No, but this is a.
Not against the
bar has. I'm so, my
Thousand,
sincere
that would
apologies.
be
6,000.
1,661 square meters. 21 square meters.
My lord would see in the JMC it says 505, not 506. Ali 150.
ಕೆಳಗಡೆ 400 ಅಂತ ಬರ್ತಾರೆ.
Correct. ಅದು 505 plus 1115.
500,115.
621 ಆಗುತ್ತೆ.
505 plus
Oh, why
1115.
this much of confusion in.
621 ಆಗುತ್ತೆ.
It is 621 only, my lord.
ಅದು page number 59 ಅಲ್ಲಿ ಅದು 150
So
Admitted fact.
1,620. 20 ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಿ, 21 ಆಗ್ತದೆ.
ಅದು ಏನಾಯ್ತಂದ್ರೆ ಇವರು ಇದು 150 ಅಲ್ಲಿ 505 ಸರ್ವೆ ನಂಬರ್ 150 ಅಲ್ಲಿ
ಹಾ.
505 ಸ್ಕ್ವೇರ್ ಮೀಟರ್ಸ್ ವಾಸ್ ಎಕ್ವೈರ್ಡ್ 150
All right, 1 meter bit, yeah, that it may be wrong. 1,621 ಅಲ್ಲ?
ಹೌದು.
21 square meters. Full stop. Ordered accordingly and the review petition is disposed.
Lord, at least let there be a liberty, my lord, to
Ah,
make a
correct,
claim
correct.
against,
Correct, correct.
because this is not a government land.
This
my lord.
order shall not come in the way of petitioner working out the landowner working out his remedy in respect of the said 400 square meters of land elsewhere in accordance with law, and in that connection, all contentions are kept up. Because he may take benefit of Justice Chandan Gowda's judgment.
ಹೌದು, very close.
ಅಲ್ಲಿ ಮಾಡ್ಕೊ.
To the extent, my lord, to be more specific before the concerned local authority himself. ಅಲ್ಲೇ ಮಾಡ್ಬೇಕಾಗಿರೋದು ನಾನೀಗ. Because they say that,
ಅಲ್ಲಿ ಅಲ್ಲ, ಅಲ್ಲಿ ಹೋಗ್ಬಲ್ಲ ಹೈಕೋರ್ಟ್ನೇ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಅವ್ರನ್ನ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇ. ನೀವ್ ಯಾರು ರೆಸ್ಪಾಂಡ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿಲ್ಲ ನಾನು.
ಆಯ್ತು.
You have to work out proceedings elsewhere. All contentions you have kept up.
I have to make a representation to the concerned authority.
I
and
do
they-
not know.
ಅಲ್ಲ,
You always-
ಯಾಕಂದ್ರೆ
you
concerned
remit
authority ಗೆ
fees. No, brother, you remit fees today. I will give advice also. Because his land also cannot go that way. Justice Chandan Gowda has said,
yes,
you can't ask the citizens to part away with the land. So now he has parted away because of condition 8.
My lord.
He is entitled to seek compensation for that.
this order should not come in the way.
I have said that.
Please.
Hoದ್ರೆ last ಹೋದ್ರೆ?
Please,
Last ಹೋದ್ರೆ, what you have written, because he should not be put to prejudice.
please,
You
much,
have written the same.
much,
thing.
much.
Compensation.
Oblige me.
And ಸ್ವಲ್ಪ little differently structure ಮಾಡ್ತೀನಿ.
ಆಯ್ತು.
Operative portion will remain that way.
Please,
Okay, I will
Please.
just go through because you do not, ಯಾಕೆ assist ಮಾಡಲ್ಲ ನೀವು? VG ರಾಮಚಂದ್ರನ್ದಲ್ಲಿ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಇದೆ ಇದ್ರ ಮೇಲೆ. Actually, government need not pay compensation for taking government land
yes,
ಅಂತ ಇದೆ ಅಲ್ಲಿ.
ಹೌದು.
ಹಾ, ಮತ್ತೆ ಯಾರು ನಂಗೆ ನೀವು ಮಾಡಲ್ಲ ಬಿಡಿ, ಯಾಕಂದ್ರೆ ನಿಮ್ದು you are opposite side. You should have done that.
No, it is basically my case that it is not government's land. my lord. I have lost my site now. I have lost my land to the extent of 400 square meter. It's not 1 or 2 square meters.
Correct.
400 square meters is too much.
Correct, brother. ಆ ಕಂಡೀಷನ್ ಒಪ್ಕೊಂಡು ಕನ್ವರ್ಷನ್ ಮಾಡಿ
ಆಯ್ತು.
ಸೈಟ್ಗಳನ್ನು ಮಾರ್ಕೊಂಡು
ಇಲ್ಲ, ಸೈಟ್ ಮಾರಿಲ್ಲ, ಅದು ರೋಡ್ ಅಂತ ಹೇಳ್ಕೊಂಡಿದ್ದಾರೆ. ನನ್ ಸೈಟ್ ಅದು.
ನಿನ್ ಸೈಟ್ ಕರೆಕ್ಟಾ? ಅಲ್ಲಿ ಆ ಕಂಡೀಷನ್ ಪ್ರಕಾರ ಲ್ಯಾಂಡ್ ಕೊಡ್ಬೇಕಲ್ಲ ನೀವು ಅಥಾರಿಟಿಗೆ.
Very well, if they have formed a road there, my lord, somebody has to pay me my compensation. my lord.
ಇಲ್ಲ, ಅದನ್ನ ನೀವು I agree with that, but not here. You should work out it elsewhere.
No,
Therefore,
because
we
it's
say-
based on their own submissions, my lord. It is that this petition was, it was in fact, it is a no objection brief which came to me, my lord, thereafterwards.
One submission, my lord, the amount has already been paid for that extent.
Full stop. If already not paid, last year. Okay. Four. Shashikumar. This I posted because there was a criminal case against you.
Please, my lord.
Which you preferred criminal petition.
Please, my lord.
What happened to criminal petition?
My lord, even we had produced the copy, criminal petition has been allowed, my lords.
That criminal
And
petition
even
is
we
up-
had given the details, my lords.
Subsequent to filing of this petition.
It is allowed.
Allowed.
Both, there was some confusion as to what happened to the criminal case registered against the return candidate. First. Now, both the sides submit fairly that the said criminal petition number so and so, having been favored by a coordinate bench of this court, wide order dated so and so, the criminal proceedings have been quashed. First, learned counsel for the petitioner is justified in telling that this happened after the filing of the election petition, and therefore obviously it could not have figured in the pleadings.
Correct.
Okay, all right.
And you are also produced a recent judgment subsequent to Lokpari judgments also.
ಯಾವುದು?
Kanimoli case.
Honeymoon. I have seen. Okay.
They are clarified, the issue, what is the effect of Lokpari.
Correct. All, okay. For orders. Reserved for orders. On that IS, those two IS,
Much.
for the striking of pleadings and for dismissal of the
Then
petition.
we had filed the detailed synopsis also, my lords. Much obliged.
Yes, some of the That order, we could not find that one anyway. ಅದು ಡೇಟ್ ಇವನ್ನೆಲ್ಲ ಕೊಡಿ. ಯಾವತ್ತು ಕ್ವಾಶ್ ಆಯ್ತು, ಯಾವ WP, ಯಾವ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಇಲ್ಲಿ ಕೊಡಿ.
ಅದು ಈಗ ಬರ್ದು ಕೊಡ್ತೀನಿ. ಆಲ್ರೆಡಿ ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಅದು ಮೆನ್ಷನ್ ಮಾಡಿ.
ಇನ್ನೊಂದ್ಸರಿ ಕೊಡಿ.
ಈಗಲೇ ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಮುಗಿದೋದು.
ಈಗಲೇ
ಸಿಂಪಲ್ ಇರ್ತಾವೆ.
ಈಗಲೇ
ಟೈಮ್
ಕೊಡ್ತೀನಿ.
ವೇಸ್ಟ್ ಮಾಡ್ಬಾರ್ದು. Okay.
ಸಾರಿ,
ನಮ್ಗೆ ಈಸಿ ಆಗ್ತದೆ ಅದಕ್ಕೆ.
ಈಗಲೇ ಕೊಡ್ತೀನಿ.
ಓಕೆ. ಎಸ್ ಮಿಸ್ಟರ್ ಹೊಳ್ಳಾರ್ದ. ನೀವೇನಾರ ಹೇಳಲಿಕ್ಕಿದೆಯಾ?
Yes.
ನಿಮ್ದಾದ್ಮೇಲೆ ಅವ್ರು ರಿಪ್ಲೈ.
I will only try to add to the points made already by the learned additional advocate general so that I don't take up too much time of this honorable court.
ಬಟ್ ನೋ ಇಶ್ಯೂ. ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇಲ್ಲ, ಇನ್ನು ಮಧ್ಯಾಹ್ನವರೆಗೆ ಫ್ರೀನೇ.
This list
But
of
they were-
dates I had already furnished. I am just giving another copy just for the sake of convenience. And a memo of citation.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ, ಹೊಳ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ.
Give another copy. I gave last time itself the same thing. Idu memo of citations which I wish to rely upon. This list of dates I had given on the last occasion. Give. Necessary, give one more date. Give me one more copy to sir. He'll tell you.
ಕಾಫಿ ಎರಡಕ್ಕೂ ನೋ ಅಂತ ಹೇಳ್ಬಾರ್ದು.
And any number of them.
ಅವು
I can-
ಎರಡಕ್ಕೂ ರೆಸ್ಟ್ರಿಕ್ಷನ್ ಅಪ್ಲೈ
Yes,
ಆಗಲ್ಲ.
yes. Now, my lords, coming first to Srigandha Kaval lands, I need not repeat. Already my learned friend, Additional Advocate General has pointed out.
Correct.
On 11/10/1994 was the Village Chowdi publication.
Correct.
That being.
ಅದು ಬಿಡಿ, facts ಎಲ್ಲ
I-
ನಾನು
I-
ತೆಗೆದ್ಬಿಟ್ಟೆ.
Then
ನೀವು
there was a.
proposition
interim-
ಹೇಳಿ.
Yes, I will just complete the narration, just to complete one aspect of
Okay.
it. Then my lords, final declaration was made. Then my lords, we deposited a sum of rupees 9,14,14,837, which is an admitted fact. Then my lord, stay of further proceedings was ordered at the behest of one Rajajinagar House Building Cooperative Society on 16/9/98,
To which they were also part.
to which they were also a party. Then another stay was granted in 3884, this instant writ petition, 3884 of 98, at the instance of the petitioner. Stay of dispossession was granted. And then these two stay orders continued until the writ petitions were disposed until 24/6/2014. Now, 24/6/2014, the learned single judge of this honorable court held that the acquisition had lapsed, and therefore the 65 acres, 19 guntas of land had to be given back to the petitioner. Therefore, even after the passing of that order, there was no question of any award being passed when the learned honorable court has already held that the acquisition has lapsed. Then we preferred a writ appeal. We preferred a review petition. In both those matters, we were unsuccessful. Therefore, the declaration by this honorable court that the acquisition has lapsed and nothing further needs to be done about the matter continued. Finally, we approached the honorable Supreme Court. Before the before the honorable Supreme Court, there were order of status quo, just to make the factual narration complete. Status quo order. And during the pendency of the SLPs, status quo was directed to be maintained by both parties.
ನಿಮ್ಮ ನೋಟ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿದಿರಿ?
Yes, Manoj. Notes, I have not included it. I will just give the order in the file C. File C, status quo order. Yes. My lords, I may furnish a copy. There were two SLPs. In both the SLPs, delay condoned, issue notice, and status quo as on today was to be maintained by the parties. And this is the order dated 2/3/2000.
4 ಅಲ್ಲಿ ಆಡ್ ಮಾಡ್ಕೋಬಹುದಾಯ್ತಾ? ನಿಮ್ಮ
Yes, yes,
synopsis
yes.
ಅಲ್ಲಿ
My mistake. I should have included it.
ಅಲ್ಲ, ಏನ್ ನೋ ಪ್ರಾಬ್ಲಮ್.
Copy.
Interim order dated
2/3/2020. And another interim order in the other writ petition dated 6/12/2020.
no, not writ petition.
SLP, I'm sorry.
SLP.
SLP,
Date ಏನು?
6/12/2019.
6/12/20.
2019.
That was status quo.
Status quo.
Status quo is generally construed as belonging to the possession.
Yes.
All right.
Then, my lords, the said interim orders continued until the Honorable Supreme Court finally disposed of the matters on 22/3/2022.
Correct.
Which is then the list of dates. So only on that date, for the first time Honorable Supreme Court held, there is no lapsing. There is no lapsing under 24(2). Matter is remanded back for consideration of the other
All
issues.
other ಅಲ್ಲ. all issues.
Yeah, I will humbly beg to differ, my lords. I will point out the relevant paragraphs.
Is it?
My humble submission is it's only other issues. It is a limited remand under Order 41, Rule 23, which I will try to impress upon my lordships. Now, assuming, my lords,
order note.
no,
First contention ಮುಗಿಸ್ಕೊಂಬೋದು. It's a limited remand.
it's a limited remand ಅನ್ನೋದ್ರ ಬಗ್ಗೆ kindly
All
see
issues ಅನ್ನೋ word ನೋಡಿದೆ ನಾನು. ಅಲ್ಲೂ
ಇಲ್ಲ.
2 ಸರಿ ಓದಿದ್ರು.
the other issues ಅಂತ ಇದೆ. My
ಹೌದಾ?
humble submission is
But
the other issues ಅಂತ ಇದೆ.
other
Kindly
issues
see,
means
yes,
all issues other than lapsing ಅಂತ.
other than lapse, other issues framed here in above ಅಂತ ಇದೆ.
ಹೌದಾ?
Kindly see, my lords.
But
Kindly see the order.
ಅದು ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇದೆ.
My lord, additional
Copy.
statement of objections 21, 2023, which we filed. Twenty-one, 2020.
January.
Yes, yes. Illi, my lords, if my lordships will bear with me, kindly come to para 3.13 first.
Page number.
Page number, internal typed page 12 at the bottom. My lord gets.
Those some observations were made ಅಂತ begin ಆಗ್ತದಾ?
Above that 3.13,
13.
that the learned single judge framed the following points for consideration. Then
A, B, C, D, E.
Then 3.14, that though some observations were made on the proceedings under the Act 1894, thereafter, without further finally deciding any other point framed for consideration, as reproduced here and above, the learned single judge has allowed the writ petitions by holding that respective acquisitions have lapsed under Section 24(2) of the Act 2013.
Correct.
So I would invite my lordship's kind attention to the fact that at one stage 3.13, their lordships extract all the issues.
Correct.
Then they repeat that exercise again. Kindly see para 4.8.
A number of submissions are.
A number of submissions are sought to be made. However, for the reasons stated here and above, and as the High Court has not at all considered any of the submissions issues on the validity of the notifications and so on, there, my lords, middle of the paragraph to decide the other issues raised afresh in accordance with law and on merits. Other issues raised anta bantu. Then at the bottom of that paragraph, hence we have restricted the consideration of the present appeals to the impugned judgment and order passed by the High Court, declaring that the acquisitions have lapsed under subsection 2 of Section 24 of the Act 2013. The other issues raised anta ಹೇಳಿದ್ರು. ಮತ್ತೆ my lords, kindly come to para 6.2.
Other issues ಅಂದ್ರೆ ಯಾವ other issues raise ಆಗಿದೆ?
The other issues raised are the ones which are extracted at para 3.13 in our humble submission.
3.13.
And our humble endeavor would be, my lords, to convince your lordships that this is not an open remand. It's a limited remand where the apex court has framed issues and directed disposal on those issues only as per Order 41, Rule 23.
Para 3, ನೀವು ಹೇಳೋ 3.1
3.13.
13. ಅದೇನ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಏನ್ ಮಾಡಿದ್ರು
Yes,
ಅದು?
he has extracted the issues.
ಇವೆಲ್ಲ issues. ಇದನ್ನ
ಅದನ್ನೇ refer ಮಾಡಿದ್ರು. Otherwise, there was no need to repeatedly extract those issues again and again. And again, it is extracted at para 8.2. Kindly see 8.2.
ಅಲ್ಲ ನಿಮ್ ಕಂಟೆನ್ಷನ್ 3.13 ಇಲ್ಲಿರುವಂತ issues ಅನ್ನ ಡಿಸೈಡ್ ಮಾಡಬಾರ್ದು ಕೋರ್ಟ್ ಅಂತನಾ?
ಇಲ್ಲ 3.13 ಇರೋದನ್ನ ರೇಸ್ ಆಗಿತ್ತು. ಇದನ್ನ only one issue was framed, that is issue number E. Other issues have not been touched upon. Therefore, we are remanding the matter to decide the other issues which were framed but not
That is
decided.
A, B, C, D.
Yes.
ಅವುಗಳನ್ನ ಮಾತ್ರ ಮಾಡ್ಬೇಕು,
ಮಾತ್ರ ಮಾಡ್ಬೇಕು,
ಬೇರೆ ಯಾವ್ದನ್ನು ಮಾಡಬಾರ್ದು ಅಂತ
ಇಲ್ಲ.
ಅಲ್ಲಿ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಬರೀ ಲರ್ನಡ್ ಪ್ಯಾನಲ್ ಕೌನ್ಸಿಲ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ದಿ APMC ಅಲ್ಲ?
ಹೌದು.
Panel appearing for the APMC submits that the text of the apex court order dated ಏನಿದು?
My lords, 22nd March 2022.
22 March 2022 at paragraph 3.13,
3.14,
comma, read with 3.14
and paragraph 8.2.
Paragraph 8.2 would demonstrate that remand is not an open remand, but a limited remand. And therefore, what the court has to address is The four issues, that is A, B, C, D enlisted in para 3.14
Yes,
and nothing beyond.
nothing beyond.
First, the limitation as to the issuance of final notification and as to passing of the award cannot be the issues at all,
Yes.
and therefore need not be examined.
Yes.
Ah.
Then, my lords, to buttress that contention, kindly see again, their lordships extract the very same issues for the second time at para 8.2 of the judgment, page 23. Once again, they extract it.
Internal page 23, na?
Page 23, para 8.
According to him,
Yes.
Apex Court reprinting the very same issues at paragraph 8.2
8.
supports this contention.
Yes. Then, my lords, finally at paras 11 and 12, which one might say is the operative portion of the judgment. I may just read that. As observed here in above, though a number of other issues were raised on the legality of the acquisition proceedings under the Act 1894, and though other points for consideration were raised framed by the High Court reproduced here in above, since none of the issues are adjudicated by the High Court on merits, we have no other alternative but to remand the matter to the learned single judge for deciding the writ petitions afresh and to adjudicate on all the other issues other than the lapse of the acquisitions under the subsection 2 of section 24 of the Act. At the cost of repetition, we observe that the High Court ought to have adjudicated on all the issues raised and ought not to have decided and disposed of the writ petitions, adjudicating only on one issue which has been found to be erroneous. Then, my lords, in para 12, crucial part.
Para 12 is very important.
Yes.
As you rightly
May I
said.
read, my lords?
Correct.
In view of the above discussion, and for the reasons stated above, all these appeals are allowed. The impugned common judgment and order passed by the division bench of the High Court, as well as the common judgment and order passed by the High Court in WP number so and so and so and so, are hereby quashed and set aside. The matters are remitted.
Slowly.
Yes, I'm sorry.
No, this portion.
Yeah, the matters are remitted back to the learned single judge to decide and dispose of the aforesaid writ petitions afresh and in accordance with law and on their own merits.
On their own merits.
And then might kindly see, my lords.
And afresh it is.
Kindly see the next slide.
Okay.
The learned single judge to adjudicate all other issues which were framed, reproduced herein above, and pronounce the judgment on all the points framed for consideration. This is, according to us, our humble submission is the operative portion. When the Honorable Apex Court has said these are the issues and culled it out twice in the judgment and said you have only answered issue number E, you have not answered issues A to D.
Okay.
It would be beyond the scope of the remand.
He further reads paragraphs 11 and 12 in support of such contention. Okay.
Then, my lords, if I will take your lordships through a few.
ಹಿಂಗ್ ಹೇಳಿದ್ರೆ ನಿಮ್ ಪ್ರಕಾರ the matters are remanded back to the learned single judge to decide and dispose of the aforesaid writ petitions afresh.
Yes, afresh on
Again,
these issues.
eh?
On these issues.
In accordance with law and on
On their
their own merits.
If there was nothing further after that, my lords, I bow down to what has been
But
argued.
now judgments of the court and remand construe ಮಾಡುವಾಗ
Yes,
we cannot apply the principles that are ordinarily applicable to the construction of statutes.
statutes, I bow down.
ಒಂದೇನೋ ಒಂದು ಕಾಮನ್ ಸೆನ್ಸ್ ಇಟ್ಕೊಂಡು
Yes,
ನಾವು ಕನ್ಸ್ಟ್ರೂ
yes,
ಮಾಡ್ಬೇಕಾಗ್ತದೆ ಒಂದು ರೂಲಿಂಗ್ ಒಂದ್ ಎರಡ್ ಮೂರು ರೂಲಿಂಗ್ ಇದಾವ
Yes.
ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್
yes. Here, my lords, if my lords will permit me, in my compilation, I have given a few cases where the Honorable Supreme Court has said as to how its own orders should be interpreted and applied. And it has said, Supreme Court is no doubt not superior to the Honorable High Courts in the constitutional scheme because each have their respective functions. But insofar as the appellate hierarchy is concerned, it is the appellate court in the civil system. And any observation made by it is bound to be followed strictly. And even under Article 144, all authorities in the country are bound to act in aid of the Supreme Court. So even an arbiter observation of the Honorable Supreme Court as to how a matter should be decided is bound to be followed to the letter. And my lords will kindly see the cases of Tirupati Balaji and Bharat Builders. In one matter,
First,
yes,
he also draws attention of the court to certain rulings which throw light on the principles as to how judgments of the apex court should be construed.
yes.
Construed. Okay.
My lords, here I may just quickly refer to two judgments. Tirupati Balaji, the first one.
Yes.
And in that judgment, my lords, at the relevant portion is at para
What it says.
12. Adapting the above said pronouncements of authority as guiding the resolution of the issue in our hands, we may venture to
Yeah,
say,
which page?
para 12, page 15 of the compilation.
ನೀವು ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ ತಿರುಪತಿ ಬಾಲಾಜಿನೇ ಇಲ್ವಲ್ಲ
ಇಲ್ಲ, ಈಗ ಮತ್ತೆ ಕೊಟ್ಟಿದ್ದೀವಿ. ಇನ್ನೊಂದು ಕಂಪೈಲೇಷನ್.
ಯಾವ
Another compilation.
ನೀವು ತಿರುಪತಿ ಬಾಲಾಜಿನ ನಮ್ಮ ಹೊಲ್ಡ್ರಿಗೆ ಕೊಡ್ಲಿದ್ರೆ ಮುಂದೆ ಹೆಂಗೆ ಮುಂದೆ ಅದಿಲ್ದಂಗೆ ನಮ್ಮವೆಲ್ಲ ಆಟ ನಡೆಯೋದು
ಈಗ ಕೊಟ್ರು
ಬಾಲಾಜಿ ಇದ್ದಂಗೆ ಅದೆಲ್ಲ ನಡೆಯೋದೇ ಬಾಲಾಜಿ ಅಂತ. ಸಾರಿ ಏನ್ರ ಹೇಳಿ.
Page 15, my lords. Para 12.
1-5.
Yes. Adapting the aforesaid pronouncements of authority as.
One second.
Yes.
1 second. Adapting.
Yes. The aforesaid pronouncements of authority as guiding the resolution of the issue on our hands. Para 12, page 15 of the. We may venture to say that in spite of the Supreme Court and the High Courts being both constitutionally independent of each other and both being courts of record.
ಅಡ್ಯಾಪ್ಟಿಂಗ್ ಅಂದ್ರೆ ಏನು ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ?
Coming close to affirming.
No. With modifications and all.
With modification. Yes. I board on.
Ah.
And both being courts of record. To the extent of exercise of appellate jurisdiction, certainly the Supreme Court exercises a superior jurisdiction and hence is a superior court than the high courts, which exercise in that context an inferior or subordinate jurisdiction. Then, my lords, I would request your lordships to kindly come to para 21, which is the crucial paragraph. Here, their lordships refer to the decision in Bharat Builders case. My lords, in that case, Honorable Supreme Court had made an observation that the High Court should decide the case without being bound by the technicalities of review petition. Then Honorable High Court said, in review petition, we cannot go beyond order of
So
47.
that violated dicta of the apex.
Yes.
Correct.
That is the observation. So therefore, our humble submission is that the observation of the Honorable Supreme Court would have to be treated strictly. And if the operative portion of para 21 is seen, then they have clearly said the other issues framed reproduced herein above. Otherwise, there was no need to use that sentence at all. I bow down to what your lordships have said, that if they had simply said on merits and afresh, I would bow down, my lords, I would not argue the point.
Next sentences curtail ಮಾಡ್ತದೆ ಅಂತ ನಿಮ್ದೊಂದು ವಾದ.
Ashт. And also, I will just add to that, Order 41, Rule 23. Order 41, Rule 23, my lords. The scope of remand.
ಅದು ಅಪ್ಲೈ ಆಗುದಿಲ್ಲ.
Allah, the appellate court may frame issues.
Correct.
And the lower court is bound to confine itself to those issues. Cannot go beyond the scope of those issues.
But that is not applicable to the apex court ಅಂತ ರೂಲಿಂಗ್ ಇದೆ ಅದಕ್ಕೆ. ನೀವೇನು ಓದ್ತಾ ಇದೀರಿ ಈಗ? That is not applicable to apex court ಅಂತ ರೂಲಿಂಗ್.
Under 142, 141. and
That's why. That's why.
Supreme Court jurisdiction is much wider.
ಇಲ್ಲಿ ಲೀವ್ ಇಶ್ಯೂ ಆದ್ಮೇಲೆ
Yes.
ಡಿಸೈಡ್ ಮಾಡಿದ.
Leave issue grant ಮಾಡಿ decide.
ಹಂಗಾಗಿ ಇಟ್ ಬಿಕೇಮ್ ಎನ್ ಅಪೀಲ್.
Yes. This SLP
But
got
appeal-
converted into a civil appeal.
Correct.
And the judgments of the lower courts merged with the decree of the Honorable Supreme Court. After, because leave was granted.
Correct. Agreed.
Then, my lords, then I will just continue the factual narration. My lords, after the disposal by the Honorable Supreme Court, my lords, on 22/3/2022, matter was remanded. Now I beg to press into the proposition that upon
ರೂಲಿಂಗ್ಸ್ ಅಂತಿದಾರಲ್ಲ ಅಲ್ಲಿ ತಿರುಪತಿ ಬಾಲಾಜಿ ಡೆವಲಪರ್ಸ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ right? 2004 5 SCC 1.
Yes. Okay. Then, my lords, after
Fairness is writ large. Last minute ಅಲ್ಲಿ argument reply ಅಲ್ಲಿ objections, documents, judgments. What we give, they take, my lord, 4 weeks, 5 weeks, 6 weeks, and then, my lord, come back. It's all right.
they were party to the Supreme Court SLP.
Yes.
All right. These are all judgments you have given now.
Yes.
Judgment, I mean, ನಿನ್ನೆ ಅವರು ಒಂದಷ್ಟು documents ಹಾಕಿದ್ರು.
Then, my lords, matter was remanded. Now, technically, it was available for the petitioners to say, since the acquisition has been upheld and revived, and Honorable Supreme Court has remanded the matter, now the time starts running so far as the passing of the award is concerned. Your lordships would kindly note, there was a stay of dispossession there was a stay of further proceedings. I will show the judgments to your lordships to the effect that a stay of disposition is equivalent to a stay of award.
So 11A benefit will be available even for that. That period has to be excluded.
Excluded.
There are
And
judgments.
yes, even after remand, now the interim orders which were granted earlier stood revived after remand, because only the final order of this honorable court was set aside and the matter was remanded.
Next point. Learned panel counsel argues that after remand by the apex court, whatever interim orders were passed in the
Earlier.
writ petitions,
Yes.
stroke writ appeals, would revive, first up.
And
In
for that
support of
matter,
that-
it's a well-established proposition, but still
In support of that.
yes, Amal Mal Sindhi
He banks upon Amal Mal Sindhi
Sindhi.
versus
versus Ram Prakash,
Ram Prakash,
ILR 1979,
ILR 1979, Karnataka,
one Delhi.
Delhi.
And in
one-
that, my
one
lord,
Delhi.
relevant paragraphs are paragraphs 23 and paragraph
Paragraph.
23.
23 and 26. Compilation ಅಲ್ಲಿ ಇದೆಯಾ?
This one, page 1,
Compilation page number?
page number 133.
Page number 133. ಅದ್ರ ಮೇಲೆ Supreme Court judgment ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಇದೆ.
I will only read the operative portion, my lord.
Not necessary.
Okay.
In fact, I have my own notes
Yes,
on
yes.
this lot. I have
Therefore, my
compiled
lords,
judgment.
and now, my lords, two further judgments, because my learned friend had already pointed out.
Supreme Court.
ಅದೇ Supreme Court ಇದೆ. Correct. ಹೀಗಂಕೋ ಅದು ಲಾರ್ಜರ್ ಬೆಂಚಿಗೆ ಹೋಗ್ಬಿಟ್ಟದ. ಈ ಇಶ್ಯೂ ಡಿಸೈಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬೆಂಚ್ ಫಾರ್ಮ್ ಆಗಿಬಿಟ್ಟು. Anyway, so as you rightly said, there are.
Supreme Court is there.
Yes, I bowed down, my lord.
2004.
Correct.
I bowed down to.
Yes.
Then, my lords, two more judgments to say.
Even that, my lord, proposition, if there is a stay of dispossession, then, my lord, the award also can't be passed ಅನ್ನೋದಕ್ಕೂ Supreme Court judgment ಇದೆ.
ಅದು-
ಯಾವ್ದೋ ಒಂದು
ಅದು-
ILR ಇಂದ
ಅದು
ಹಾಕಿದ್ದಾರೆ.
I've seen.
ನಾನು I don't want to say.
V.G. Ramachandran, in his law of land acquisition and compensation, has referred to that apex court judgment.
ನಮ್ಗೆ ಏನಾಗಿದೆ, ನಮ್ ಗುರುಗಳೆಲ್ಲ we are learning from them. So you should please
ಅವನ್ನೆಲ್ಲ
allow some.
ಆ ಬಾಣಗಳನ್ನ ಅವ್ರ ಮೇಲೆ ಬಿಡ್ತಾ ಇದ್ದೀವಿ ಮುಂದೆ ಅವ್ರಿಗೆ ಸಿಟ್ಟು ಬಂದದ ಈಗ.
ಇಲ್ಲ ನನಗೆ ಬಹಳ ಬಿಡ್ಲಿ, ಅವ್ರ ಲೇಟೆಸ್ಟ್ ತಂದು ತಮಗೆ ಕೊಡಬೇಕು, ಕೊಡ್ತಾ ಇಲ್ಲ ಅಷ್ಟೇ ನನಗೆ ಬೇಜಾರಾಗಿ.
Another matter, in fact, I am briefing, sir. So it is a bit odd. One day we are opposing, one day we are briefing.
That's the beauty of the profession.
War is like that.
Yes. Then, my lords, two judgments. Government of Tamil Nadu versus Vasanta Bai, page 137 of the compilation.
ಏನು for proposition?
Proposition that a stay of dispossession is equivalent to a stay of the award.
He also adds that the stay of disposition in a proceeding laying challenge to the acquisition would amount to an order staying all further proceedings
Yes.
for the purpose of
Section
section
11A.
11A of 1894 Act. ILR, the
1995, supplement 2 SCC 423.
1995 supplement to ACC
423
423,
at paragraphs 6 to 8.
paragraph 6 to 8.
May I read, my lords, or?
Well, not this.
Then in the same vein, my lords, another judgment of Honorable Supreme Court, Municipal Corporation of Delhi versus Lichwa.
ನಾನು prevent ಮಾಡಲಿ ಅಂತ ಇಟ್ಕೋಬೇಡಿ. If you want to read,
ಇಲ್ಲ, ಇಲ್ಲ.
many youngsters are also
ಇಲ್ಲ,
here.
ಇಲ್ಲ.
But I am familiar with those.
ಇಲ್ಲ, ಇಲ್ಲ, then I
those
did not trouble my lords.
Yes, yes.
Municipal Corporation of Delhi versus, after all, we have to say.
And
of the
I'm like
judicial-
myself conceding.
That's what.
My lord, Municipal Corporation of Delhi.
ಎಲ್ಲ ಎಲಿಮೆಂಟ್ರಿ ಇದೆಲ್ಲ. Land ಏನಾಗ್ತದೆ, ನಾವು ಬಹಳ ನಮ್ರವಾಗಿ ಇದನ್ನ ಹೇಳ್ತೀನಿ, ತುಂಬಾ ನಮ್ರವಾಗಿ 35,000 ಕೇಸ್ಗಳು ಡಿಸೈಡ್ ಮಾಡಿದೆ ನಾನು. ಅದರಲ್ಲೆಲ್ಲ ನೀವೆಲ್ಲರೂ ಸೇರಿ ನನಗೆ ಇಷ್ಟೊಂದು ಲಾ ಕಲಿಸಿರಿ. ಐ ಆಮ್ ಗ್ರೇಟ್ಫುಲ್ ಟು ಯು. I can write, I feel at times.
ಇಲ್ಲ,
Ah.
we must also tell your lordships, when your lordship poses questions, we go and learn and then come back.
ಅದು ನಮ್ಮ ಮ್ಯೂಚುವಲ್ ಇರ್ತದೆ.
ಹೌದು,
ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡಿದಾಗ ನಾವು ಕಲಿಯೋದು ಇರ್ತದೆ. ಪ್ರೊವೈಡೆಡ್ ವಿ ಹ್ಯಾವ್ ದಟ್ ಮೈಂಡ್.
ಹೌದು.
ನಾವು ಕಲಿಬೇಕು, ಏನೋ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಉಪಯೋಗ ಆಗತ್ತಿದು ಅನ್ನೋ attitude ಇದ್ರೆ
Correct.
ಮಾತ್ರ ಸಾಧ್ಯ.
In fact,
ಹೌದು.
when we sit here, somebody gives a citation. Even now at this age, I write down.
I always keep it, seeing you, all that doing, like a child you will do, every note you
ಆಮೇಲೆ
will
ಹೋಗಿ
do,
ಚೆಕ್ ಮಾಡಿ.
a
I will-
certain ಮಾಡಿ.
My lord, that
That's
way-
how Mr. Holla is made up. Yes, Holla is made up not in a day or two. He is made up in the,
ಅಲ್ಲ,
in the
this is my lord, what the
decades.
youngsters must do.
That's true, that's true.
My lord, even when we go for briefing, we are astounded. Even on Sundays, he will be ready always.
Not just say Sunday.
Yes.
Once I wanted to go and in fact, I tell you why I should hesitate. I wanted to have his blessings because my guru is not there. His father was my guru. Therefore, I felt Guru is not there, Guru Putra is there, he is also Guru only. So I wanted to go after my appointment as ASG. I just called one of his close friends, to me also friend. He told Mr. Valla, whether Mr. Valla is available. Sir, he is available, but he is available in office. And by the time I had called him, it was 11:45. At 11:45, Valla is in office. No, he will be there up to 1 a.m. I have seen him working that way.
ನಮ್
That's
ಈ
how he
ಜನರೇಷನ್ ನಲ್ಲಿ ನಮ್ಗೆ ಅದು ಡ್ರೈವೇ ಇಲ್ಲ. We don't have that
It
kind
is
of
something
drive and
unique.
energy.
I tell you, it is something unique.
Yes.
ಏರ್ಪೋರ್ಟ್ ನಾಗ ಅಡ್ಡಾಡೋದು ನೋಡ್ಬೇಕು ಅವ್ರು. ನಮ್ಗೆ ಇಷ್ಟು ಟಕ 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 ಅಲ್ಲಿಂದ ಇಲ್ಲಿಗೆ, ಇಲ್ಲಿಂದ ಅಲ್ಲಿಗೆ, ಆ ಕೋಟಿನಿಂದ ಈ ಕೋಟಿ ಬಂದು ಎಕ್ಸಾಕ್ಟ್ ಪಾಯಿಂಟ್ ಅನ್ನೇ.
Yes.
It's a great thing. We should
Great,
learn- we should-
great learning from experience for us.
We should learn. We should learn. And his humility.
Yes.
If we say, no, I could not see it, I'm very sorry, I have not seen it. ಯಾರು have seen it? Okay, so of course, ನಮ್ ಬಾರ್ ಬೇರೆ ನಮ್ನಿ ಇದೆ. That's a great thing.
Yes, I bowl. I
Yeah.
fully, my lord, whether we win or lose, we are very happy to be having Mr. Holla opposite us. Then, my lord, Municipal Corporation of Delhi versus Licho Devi, same proposition at para number 3.
Same proposition.
Same proposition, para number 3, page 140.
Citation.
Citation 1997, 7 SCC 430.
ನಿಧಾನವಾಗಿ 1997 7 SCC
430.
430. 439,
430.
430. Okay.
Therefore, my lords, there being two stay orders, one disposition order, another status quo regarding further proceedings, they are both to be treated as stay of further proceedings under section 11A,
Understood.
which continued till the end and which got revived even after remand and which till today exist. And therefore, they cannot raise section 11A and take any benefit from that argument. Then, my lords, kindly see just one more point. Even in the order sheet, because their lordships of the Honorable Supreme Court had directed that the matter be disposed of within 12 months because of the urgency of the acquisition proceedings. Now, even when an adjournment was sought by both sides, just prior to the expiry of that 1 year
And
period,
some adjournments by the court
yes,
itself.
then your lordships have noted without prejudice to the contentions of the parties to show that the time, because the time is running. So that also has been noted in the order sheet.
ಅದೇ ಅದಕ್ಕೆ ಏನ್ ಕಂಟೆನ್ಷನ್, ಏನ್ ಪ್ರಪೋಸಿಷನ್ ಏನು?
The proposition is that because, my lords, after remand, again, technically it was open for them to raise the contention that time is running, you should pass award.
No, they have
They
said,
stayed,
what they will say, it is.
stayed.
Stay orders are revived according to you.
Correct.
Then how they will go before the authority?
Allah, I just want to point out that wide order dated 15/3/2023, this honorable court adjourned the matter without prejudice to the contentions.
Correct.
Because I had engaged learned senior counsel, Mr. Raghavan.
Always.
ಆವಾಗ 1 year ಇಂದು ಪ್ರಶ್ನೆ ಬಂತು.
But ಅವರಲ್ಲಿ ಹೋಗ್ಲಿಕ್ಕೆ ಬರ್ತಿರ್ಲಿಲ್ಲ.
ಇಲ್ಲ.
ಅಥಾರಿಟಿಗೆ ಹೋಗಿ ನೀವು ಪಾಸ್ ಮಾಡ್ರಿ.
ಇಲ್ಲ.
They will go and who will care them? If
Yes,
they
yes,
go and
yes,
tell this.
Yes. My lords, that's all so far as Srigandha Kaval is concerned.
Correct.
So far as Hero Halli is concerned, just a few points I will make. Firstly, kindly see, with all respect to learned senior counsel,
ಅದನ್ನ ನೀವು ಯಾಕೆ ಹೀರೋ ಹಳ್ಳಿ ಮಾಡಿರ? ಅದು ಹೇರೋ ಹಳ್ಳಿ.
ಹೇರೋ ಹಳ್ಳಿ ಇದೆ. ಅದು ಯಾವ ಹಳ್ಳಿನೂ ನಮಗೂ ಕರೆಕ್ಟ್ ಆಗಿ ಗೊತ್ತಿಲ್ಲ.
ಯಾರನ್ನ ಹೀರೋ ಮಾಡ್ತೀರಿ ನೀವು, ಯಾರನ್ನ ಜೀರೋ ಮಾಡ್ತೀರಿ ಗೊತ್ತಾಗಲ್ಲ. ಯುವರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ನೆಕ್ಸ್ಟ್ ಕೆಳಗೆ ಅಷ್ಟು ಹೇರೋ ಹಳ್ಳಿ ಲ್ಯಾಂಡ್.
Yes.
ಅಂಡರ್ಲೈನ್.
There, my lords would kindly see, even assuming for the sake of argument that the arguments made by the learned petitioners counsel is correct, that the 65 odd acres of land possession was taken without complying with the requirement of section 17(3)(a), and therefore, as per the decision in Delhi Airtech, the land needs to be restored back to the landowner. That is the argument made. Even assuming that that is a valid argument, that argument will only inure to the benefit of 65 acres, 19 guntas, of which possession was taken under 17(3)(a). The total extent of land in Hero Halli is 100 acres. So 100 minus 65, in 35 ಎಕರೆ ಇದೆ.
Learned panel council submits that the land at Herohalli as notified had measured 100 acres,
Yes.
of which 70 acres,
65 acres,
65 acres
19 guntas.
was taken possession of. 65 acres, 19 guntas was taken possession of
On 6/10/2000.
on 6/10/20,
2000.
6/10/2000.
Yes.
So therefore, at the most, the decision of apex court in Delhi
Delhi Airtech.
Delhi Airtech, Bopana Saver judgment.
Yes, yes,
Bucket nalli
yes.
Justice Bopannas. Maybe invoked. So if that is done,
Yes,
for remaining land, that principle is not invocable.
yes. And for the remaining land, just as there are stay orders in Srigandha Kaval matter, there were stay orders in Herahalli matter also. So then there also our hands were tied as acquiring authorities because the petitioners themselves had approached this honorable court and taken stays.
No,
Yes,
no, not that.
yes,
Legal position is,
Yes.
if you want to take possession of the land,
yes, yes,
this payment is like this.
yes,
1 second.
Yes.
There is final aspect
yes,
where you notify 100 acres. But we want to take only 1 acre possession. Therefore, we will make payment only for that.
yes,
I don't think that that is sustainable.
please.
It has to be, it's one common package.
Yes,
You notify Madi
yes,
because notification is under that section,
yes,
section 4.
yes.
Read with the
Section 17, subclause 3A.
ಹಂಗಾಗಿ ಅಲ್ಲಿ ಸ್ಪ್ಲಿಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ ಅಂತ ನಂಗೆ ಐ ಡೋಂಟ್ ಫೀಲ್ ಲೈಕ್ ದಟ್ ಅನ್ಲೆಸ್ ಯು ಶೋ ಸಮ್ ಜಡ್ಜ್ಮೆಂಟ್.
Yes, my lords,
Split is
yes.
possible.
The split happened for this reason, my lords. 30 odd acres is put kharab. Sarkari put kharab.
With the greatest respect,
Nam
it is not
jameen
so.
illa?
It is not so. fact,
That's a disputed question.
ಈಗ ಬರ್ತಾರೆ.
ಅದು
ನಮ್ದು
ನಮ್
ಅದು
ಜಮೀನನ್ನ
ಏಕರ-
ನಾವು ಹೋಗಿ ಸ್ವಾಧೀನ.
ಖರಾಬ್ ಇದ್ದದ್ದನ್ನ ಆಫ್ಟರ್ ಐ ಫೈಲ್ ದ ಕಂಟೆಂಪ್ಟ್ ಆಫ್ಟರ್ ಮಲಾಡ್ 5 years after the ಮಲಾಡ್ ಎವ್ರಿಥಿಂಗ್ ಗಾಟ್ ಓವರ್. ಯಾವ್ದ್ರಲ್ಲಿ ಆ ಲ್ಯಾಂಡ್ ಇಕ್ವಿಸಿಷನ್ ಅಲ್ಲಿ ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್ಸ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಆಮೇಲೆ ತಗೊಂಡು ಹೋಗ್ಬಿಟ್ಟು ಪೂಟ್ ಖರಾಬ್ ಅಂತ ಮಾಡಿದ್ರೆ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿ ಇಟ್ಟಿದೀವಿ. ಅಲ್ಲಿ ಅವ್ರು ಹೇಳಿದ್ರು ಇದು ಇಟ್ ಇಸ್ ಆಫ್ ನೋ ಕನ್ಸಿಕ್ವೆನ್ಸ್ ಅಂತಾನೆ ಹೇಳಿದ್ರು.
My lord, my learned friend, Additional Advocate General says, the Akar Band which has been taken out, which he can produce before this honorable court, would show that 33 acres is Sarkari put kharab. It is a, we can.
Is it part of the record here?
The record is,
Not part. ಇಲ್ಲಿದೆಯಾ? ಇಲ್ಲ. Part of the record ಏನಿದೆ unless you have taken leave to produce it, etc. We
Yes,
have
ma'am.
entertained, but
Yes,
not
ma'am.
at this stage.
yes, my lords.
Okay.
Then last few points, my lords, regarding Indore and Delhi Air.
But if it were to be so, why did you notify? Even
Yes.
once you notify,
Yes,
these arguments you cannot use
yes,
to show that there is no violation of prescriptions.
yes,
ಅಂತ ruling ಇದೆ ಒಂದು.
yes. Allah,
felt that
we
way.
notified it, but if it is our own land, then the question of
Why
paying,
did-
paying ourselves does not
Why did
arise.
you notify? Why did you notify?
I bowed down, I bowed down. Then, my lords, just briefly on Indore and Delhi Airtech, final few points. My lords would kindly see their argument
But
is,
Delhi Airtech refers to Indore also.
it refers to Indore. But our humble submission is that the proposition which has been laid down and affirmed in Delhi Airtech is only this, that if possession of land has been taken from the land loser without tendering 80% of the compensation under section 17(3)(a), and if no award has been passed within a period of 2 years under section 11(a), then the acquisition will lapse, not otherwise. It is a twin requirement, which is obvious from a reading of all the paragraphs of Delhi Airtech.
Then the panel council submits that. In terms of ratio in Delhi Airtech, which considered Indore development also,
Yes,
there is a twin test,
yes,
namely taking possession of the land and making payment of 80%,
80%
80% of the compensation
under section
in
17(3)(a).
terms of section 17(3)(a),
Yes,
3A of the 1894 Act. ಮುಂದೇನು?
and there should be the acquiring authority should
And further, the acquisition should be accomplished, award should be passed
passed within 2 years.
within 2 years.
No,
failing
the
which-
award is not passed within 2 years. Award is not passed within 2 years, then it lapses.
First, further, if such award is not passed within 2 years, then section 11A becomes invocable.
So therefore, our humble submission, my lords, is that the Honorable Supreme Court has not said, contrary to the ruling of Indore development, where their lordship's constitution bench has categorically held that once possession is taken under the scheme of the Land Acquisition Act 1894, if it is a regular possession under section 16, moment possession is taken, title vests. If it is a possession under section 17, subclause 3A, even then, if possession is taken, albeit with irregularities, title vests, the only recourse of the land loser is to get penal interest between sections 31 and 34 of the Act. Because under section 17, 3A, there is no mandate that just because you have taken possession illegally, the acquisition lapses. This is the ruling of Indore development.
No, suppose that will be an extreme proposition, brother.
My lords, that is the proposition in the Indore. I will take my lords through the paragraphs because their lordships, the earlier land acquisition law was very clear. The moment possession is taken, right or wrong, title will vest in the state. Now the land loser,
Exclude challenge. Suppose if the, what
Yes,
is the meant by constitutional
because there is
guarantee?
no concept of divesting. There is no concept of divesting.
Divesting, all right. Suppose if the acquisition is set aside on the ground of marked illegality in the acquisition process, still will not be divestation.
My humble submission, my lords, my understanding is, if I read the relevant,
English law that can be.
yes, in Indore development,
English law.
yes,
King is the owner of all private properties. There is nothing like private property.
yes, yes.
It's only fee simple.
Just a few paragraphs of Indore.
Hangilla.
Just a few paragraphs of Indore I will rely on, just to buttress this point.
Yes.
In fact, learned senior counsel, Mr. Raghavan had argued it. I'll just point out those paragraphs, just to refresh my notes.
Just for a moment,
Yes.
you are a professor. I have great respect for you.
No.
Really. Suppose, let us take the consequences of your argument.
Yes.
Once possession is rightly or wrongly taken,
By
the
the state.
state becomes the owner of the property.
Correct.
Then only remedy availing to the citizen is to go for recompensate, and not the property at all.
He cannot get the property back because it
That
is,
amounts to
it is eminent domain. My lords, it is the
Hey.
state, right of the state.
the eminent domain, not on English soil, on Indian soil, subject to 300 capital A, subject to provisions of Land Acquisition Act, law relating to land acquisition enacted in various places. It's not that broad as it would have had when the barons in England used to exercise power. That is not our eminent domain. Eminent domain, historically, yes, you are right.
Yes.
But once it is shown by the citizen, the acquisition process is marred by marked illegalities.
Yes.
Though you have taken possession of the property,
Yes.
he is entitled to say acquisition should be invalidated and property should be restored to me. That appears to be broad view of V.G. Ramachandran.
Yes. Yes.
Many
My lords, I
judgments.
bow down, my lords.
One second.
Yes.
No, I have not completed. Now, accepting your contention, once possession of the land is taken, in no circumstance it can be, state can be divested of that.
Yes.
Any proposition, any law to that effect.
My lord, Indore,
And the citizen can go only for recompensate.
my lord, the Indore development constitution bench ruling of the Honorable Supreme Court.
ಯಾವುದು?
Either Indore development, kindly see,
Yes.
in my list of authorities, first batch.
ಆ proposition ತೋರಿಸಿ. Appears to be
Yes.
extreme ಅಂತ ಅನಿಸ್ತದೆ. I may be wrong also. Perhaps if Holla, Mr. Holla, do you subscribe to
No,
that?
my lord. That point-
Independent of this case? Independent of this case?
Independent, my lord. Ultimately, my lord, we have to tell your lordships
Legality
correct
only.
proposition of law before your lordships. ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು.
My lords, I don't know if my understanding is mistaken, but
No, no,
my humble
you-
reading of Indore development is this.
Law always shows its face in mask. This is
Yes.
what Jeremy Bentham used to say. At times, it's my
But my
experience also.
right or wrong
Let us see.
interpretation of Indore is this.
Let us see.
Para 116 of Indore, my lords, at page.
In fact, Apex Court in Abdul Hamid versus HMT versus Abdul Hamid said, you have accomplished acquisition proceedings contrary to law by involving a middleman agent.
Yes,
Therefore,
yes,
you give back land.
yes,
Land was taken by the state.
yes,
It was distributed to the societies.
yes,
Society in turn formed layouts,
yes.
gave the sites to the aspirants. Supreme Court said, give back that land to the state.
No,
To
not
the
only that.
landowners.
Supreme Court also said, give back the compensation which the owners received.
That also.
ಅದನ್ನ ನಾನು ಹೇಳ್ಬೇಕು, ಆಮೇಲೆ ಹೇಳ್ತೀನಿ ನಾನು.
Anyway,
ಜಡ್ಮೆಂಟ್
My lord, with my limited knowledge, I only rely on
ಯಾವ್ದು paragraph?
Indore, para 116.
Page
Page.
number?
I'm sorry, the page number is missing.
ಅಲ್ಲ, ನಿಮ್ದು ರನ್ನಿಂಗ್ ಪೇಜ್ ಇದೆ ಏನೋ?
Running page, you just tell. Page number. Page 130, 137.
137. You are right.
May I read minutes?
ಅಲ್ಲ, ವಸಂತಿ.
It is apparent from a plain reading.
ವಸಂತಿ, 137 is ವಸಂತಿ. ಹೌದಾ? ಅಲ್ಲ.
ನೀವು ಕೊಟ್ಟಿರೋ ಕಂಪೈಲೇಷನ್.
ನಾವು ಕೊಟ್ಟು 116, your lordship. ಇದಲ್ಲಿ
Internal page?
My lord, there is some mistake in pagination. Kindly provide that. I will just show your lordships the copy.
ಅದು ನಿಮ್ಮ ಇರುತ್ತಾ?
Yeah, ಇಲ್ಲ, ಈಗ ಹಳೇದು. ಅದು
ನಾನು
ನಾನೇ
ಕೈಯಲ್ಲಿ ಇಟ್ಕೊಂಡಿನಿ, ಸಿಕ್ಕಿದೆ.
para 116, your lordships.
116.
It is apparent, yes. Internal page 242.
It is apparent.
It
From
is
a clear
apparent
reading
from
of
section
16.
16 that the land vests in the government absolutely when possession is taken after the award is passed. Clearly, there can be lapse of proceedings under 1894 Act only when possession is not taken. The provisions in section 11A of the 1894 Act states that the collector shall make an award within a period of 2 years from the date of the publication of the declaration under section 6. And if no award is made within 2 years, the entire proceedings for acquisition of the land shall lapse. The period of 2 years excludes any period during which interim order granted by the court was in operation. Once an award is made and possession is taken, by virtue of section 16, land vests absolutely in the state, free from all commitment.
No, you are reading something not there. Once possession is taken under section 16 of the 1894 Act.
Yes.
ನೀವು ಬೈ ವರ್ಚು ಅಂತ ಏನೋ ಹೇಳ್ತಾ ಇದ್ರಿ.
ಅಲ್ಲ, ಇಲ್ಲ ಅದೇ ತರ ಇದೆ. By virtue of section 16, land vests ಅಂತ ಇದೆ ಇಲ್ಲಿ. I don't know if there is any change in the wording there.
Paragraph.
Paragraph 116.
Award is taking possession as provided in section 16. Correct?
Yes, madam.
Once possession is taken under section 16 of the 1894 Act, the owner of the land loses title to it and the government becomes the absolute owner of the land.
ಇಲ್ಲ, ಇದು ಬೇರೆ ಇದೆ.
ಹೌದು.
I may just give my copy only. I will just refer to my copy only.
Paraphrasing ಮಾಡ್ತಾರ ಅವ್ರ ರಿಪೋರ್ಟರ್ಸ್. ಇದು ಪ್ರಾಬ್ಲಮ್ ಇದೆ ನಮ್ಮ.
Mine is the same as what the court is reading.
ಇನ್ನೊಂದು ಜಡ್ಮೆಂಟ್.
Indore development, same as what the court is reading.
My lord, I may give this one so that it is, seems to be a different version. I'm sorry.
ಇಲ್ಲ ಪಾಪ ಇಲ್ಲೇ ಹಂಗಿದ್ರೆ ನೀವೇ ಸಾರಿ ಹೇಳ್ಬೇಕು. ಇಲ್ಲಿ ಹಂಗಿದ್ರೆ ಪಾಪ ನೀವು ಓದ್ತೀರಿ ನಾವು.
Yeah, even the highlighted portion, I would just.
No, this is different from what you are doing. By virtue ಅಂತ ಇಲ್ಲಿದೆ.
Once an award is made, possession is taken by virtue of section 16. Land was absolutely in state, free from all element. Vesting of land is automatic. Correct ಇದೆ ಇದು. ನಾವು
Correct.
ಓದಂಗಿದೆ ಇದು.
Then below that also, my lords will see the next paragraph. Their
117.
lordships discuss what is to happen in case possession is taken without complying with the mandate of law.
Payment of compensation of 1898 is provided for by section 31, which is to be after passing of the award under section 11. The exception is in case of urgency 70E, where it has no tender for taking possession. Once an award has been passed, the collector is bound to tender the payment of compensation to the persons interested as found in the award and shall pay it to them unless prevented by contingencies mentioned in 2 of 31. Section 31(3) contains a non-obstantly clause which authorizes the collector with the sanction of the government in the instant interest of the majority with the grant of the mission of land revenue. 117.
Yes, 117. Then kindly come to 118, my lords. What is to happen if the compensation is not paid? It has to be deposited in the court.
Pay such amount to a person interested inside, unless the collector is prevented from so inside. In case some state is prevented from making in the event of.
Then
ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ದೆ. ಈಗ ರಿಪ್ಲೈ ಇನ್ನೊಂದು ಏನೋ ತಿರ್ಗಾ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Section 34 deals with the section. ಅದೆಲ್ಲಿ ಹಂಗಿಲ್ಲ ನೀವು ಹೇಳಿದಂಗೆ.
Allah, kindly come to the last para, my lords, para 120. There is some confusion. Para 120, your lordships get.
120.
Bottom line,
It is
what
apparent
follows is
it
that in the event of not fulfilling the obligation to pay or to deposit under sections 31(1) and 31(2), the 1894 Act did not provide for lapse of land acquisition proceedings.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಿ?
ಇದು para 120. I don't know why there is some.
It is apparent from 1894 Act ಅಂತ start ಆಗ್ತದಾ?
Yes, my lords, there, yes. In that,
That the
after
payment
the
of
fifth line,
compensation is dealt with for so and so, so and so. So and so, taking position under section 30, reduce section 30, position can be taken before tendering the amount except in case of urgency, and deposit of amount has to follow in the case of collector prevented from taking.
what follows
What
is that,
Those is that in the event of not fulfilling the obligation to pay or to deposit under 31 though 1890 did not provide for lapse of land acquisition and only increase interest fall.
with payment.
ಅದನ್ನ correct ಅಲ್ಲ ನಾನ್ ಪೇಮೆಂಟಿಗೆ ಅಷ್ಟೇ.
Yes. And therefore there is no lapse. Then, my lords, kindly see para 134 to 135. Again, repeating of the same thing. I will not trouble my lord. Then para 136 to 140, the same discussions. I will just give these paragraph numbers so that I don't trouble my lords, because in the end, their lordships have summarized it.
ಎಲ್ಲದು?
In the end, kindly come to para 366-4, the operative portion of the entire judgment.
366. What?
Last
The
part,
expression paid.
paid. Then, my lords, kindly come to the sixth line. In case the obligation under section 31 of the Land Acquisition Act has not been fulfilled, interest under section 34 of the said act can be granted. Non-deposit of compensation in court does not result in the lapse of acquisition proceedings. In case of non-deposit with respect to the majority of holdings for 5 years or more, compensation under the 2013 Act has to be paid to the landowners as on the date of the notification for land acquisition under section 4 of the 1894 Act. Therefore, my lords, my limited understanding of this judgment is that these paragraphs which I have culled out, no doubt as learned.
Where in other, what you say is,
Yes,
if 80% of the amount is not paid, on that ground, acquisition cannot be voided. He can seek interest on that.
yes.
Section itself would have said that way.
That is what the section has said. My lords, kindly see section 31 to 34, which is what the section says. Because section 17(3)(a) does not say if you don't pay, it will lapse. In section 11(a), there is lapse. In section 6(1), there is lapse, but not in section 17(3)(a).
Suppose if it is a precondition,
Even so, the statute does not mandate it. Statute does not mandate.
then a penal counsel submits that non-payment of 80% of the compensation when land is taken under section 4 read with 17(3) kept 3A, comma, would not result into lapsing of the proceedings, but it may entitle the landowner to additional interest.
And even at your lordships would note 15%, which is a penal sum under section 34.
Interest.
Or from the second year onwards, it is
Maybe at the
15%
rate of 15% by way of penal interest.
interest.
First, in support of this, he reads out paragraph 366.4 of Indore Development Authority.
And my humble submission, my lords, by no stretch of the imagination, could it be said that this is obiter? Why? Because no doubt their lordships were considering all this in the context of section
He
24(2).
hastens to add that this 366.4 is the law declared under Article 141 of the Constitution. And by no stretch of imagination, it is an obiter.
Obiter.
All right. How this is treated
Yes,
by the
in-
subsequent
yes.
judgment?
Kindly come now to Delhi ATEC.
ನಾನು ತೋರಿಸ್ತೀನಿ.
ಹ?
ನಾನು ಆಮೇಲೆ ತೋರಿಸ್ತೀನಿ.
ಅದೇ. ನೀವು ತೋರಿಸಿರಿ ಈಗ already.
ನಾನು ತೋರಿಸಿದ್ದೆ. ತಿರ್ಗಾ ಅವ್ರಿಗೆ ಅದು ಆಮೇಲೆ ಮಾಡಿದ್ರಿ. ತಿರ್ಗಾ
He wants to say
ಅಲ್ಲ
something.
ಇರ್ಲಿ.
Just a
not
few
feel that
minutes
I have
that
not
I will
heard,
I understand.
ಅದು.
ಯಾಕಂದ್ರೆ ಏನಂದ್ರೆ ಎಂಡ್ ಆಫ್ ದ ಡೇ ದುಡ್ಡು ಕೊಟ್ಟಿರೋರು ನಾವು. ದಿಸ್ ಇಸ್ ದ ಬಾಟಮ್ ಲೈನ್. ಇಲ್ಲಿ 9 ಕೋಟಿ
ಅವ್ರು ಲ್ಯಾಂಡ್ ಕೊಡೋರು ನಾವು ಅಂತ ಅವ್ರು ಉತ್ತರ ಕೊಡ್ತಾರೆ. ಹಂಗೆ ಅದು ಎಂಡ್ಲೆಸ್ ಆಗ್ತದೆ.
ಆಯ್ತು.
ಅದು ದುಡ್ಡು ನಿಮ್ಗೆ ಯಾರು ಕೊಡು ಅಂದ್ರೆ ನಮ್ ಲ್ಯಾಂಡ್ ತಗೊಳ್ಳೇಬಾಡ್ರಿ ಅಂದ್ರೆ ಅವ್ರು.
ಆಯ್ತು.
ನಮ್ ತಗೊಂಡು ನೀವು ಹಿಂಗ್ ಮಾಡಿರಿ ಅಂತ ಅವ್ರ ಕಂಟೆನ್ಷನ್.
Kindly come to Delhi ATEC, page 13,
13 of your
first compilation. There, my lords, kindly see the opening 2 paragraphs, how this case arose. Your lordships would kindly see there was a divergence of opinion in the Honorable Supreme Court,
Correct.
whether If land is taken without complying with the requirement of section 17(3)(a),
A, what would happen?
what would happen? And there was a divergence of opinion.
Ah.
Then kindly see para 4 at the bottom. Hence, respondent number 1 being the appropriate government issued the notification dated so and so, invoking the special
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಿ ನೀವು?
para 4, my lords.
Of page,
Page 13,
ನಿಮ್ಮ compilation
non-compilation.
13 ಅಲ್ಲಿ ಬೇರೆ judgment ಇದೆ.
Delhi airtech, my lords.
ಈ state ಓದಿದ್ದೀರಿ.
Because the state also had given one compilation. We give up this is our company.
ಅಲ್ಲಿ ನಿಮ್ಮ ಅವ್ರಿಗೆ
It's totally so.
ಅದಾ ಅದರ ಇದೆ ಅದಿದೆ. 1 second ಅದಿದೆ.
Okay, okay.
1-3 ನಾ?
Yes, ma'am.
You are right.
Yes, ma'am. Para
Delhi
4.
airtech. Okay.
Now kindly come to
ನಿಮ್ ತೊಳಿ.
the last 3 lines, my lord.
Page number.
Page 13. Page
Three.
13, yes. Last 3 lines. Hence, respondent number 1 being the appropriate government issued the notification dated so and so, invoking the special power due to urgency. The notification was therefore issued under section 4(1) read with section 17(1). So this was a case where urgency clause was invoked.
Correct.
Then at para 5, 5th line, however, it is not disputed that possession was nevertheless taken on so and so. But the grievance raised by the appellant is that neither the initial requirement of tendering and paying 80% under so and so, nor was the requirement of section 11(a) of the Act to pass the award within 2 years from the date of declaration was complied. So this was the question in para 5, twin requirements,
Payment plus timeline.
timeline. So the question really was, if the acquiring authority has not complied with section 17(3)(a), are they not bound by section 11(a)? And can they take their own sweet time to acquire the property?
1 second.
Yes,
Lapsing of a proceeding is one thing.
yes.
Invalidation of land acquisition proceeding is another. ಅಲ್ಲಿ ಲ್ಯಾಪ್ಸ್ ಎನಾಕ್ಟ್ ಆಗಿರ್ಲಿಕ್ಕಿಲ್ಲ. ಅನೇಕ ಕಡೆ ಲ್ಯಾಪ್ಸಿಂಗ್ ಎನಾಕ್ಟ್ ಆಗಿರ್ಲಿಲ್ಲ. ಬಟ್ ಇನ್ವ್ಯಾಲಿಡೇಷನ್ ಇತ್ತು ಅಂದ್ರೆ ಇಟ್ ಇಸ್ ಸ್ಟ್ರಕ್ ಡೌನ್ ಬೈ ದ ಕೋರ್ಟ್ಸ್.
Yes, I bow down, I bow down. I bow down to that, my lords. But my humble submission is only this. Because now one has to reconcile Delhi Airtech 3-judge bench ruling with Constitution bench ruling in Indore development.
No. No question of we reconciling.
Because,
This judgment, how later judgment interprets a particular judgment,
yes,
that becomes to say, to give an
yes, I bow down, I bow down.
extreme example of Upendra Bakshi.
Yes,
Dr. Upendra Bakshi said, if Keshavananda is interpreted by a learned single judge of this court, he did not use the word learned, maybe nobody is learned in his view. He said, if one single judge of the High Court interprets Keshavananda, it becomes the law.
Correct.
Another judge cannot say,
yes.
This is wrong. At the most he can say,
Yes, yes.
let it.
My
go
lord,
to
I will rephrase my
that-
words.
that-
Not to reconcile, but our humble submission is the ratio of Delhi Airtech is only that these two twin requirements have to be satisfied. Now come to para 8, my lords. Para 8 allu, they
Sir,
put,
you agree that 80% has to be paid.
yes,
And if it is not paid, it will not invalidate the proceeding, but he will be entitled to interest. Is your
he will be entitled to interest.
interest.
And if we do not pass award within 2 years,
Then lapse.
lapse. But under no circumstances, if just because we have not paid 80% with the as per
And
17.
acquisition will not lapse.
No. And last portion also kindly see, my lords, para number 17. Para 17.
So hinge ಹೇಳು. Acquisition will not lapse.
Yes.
In other words, 11, because they have not made or tendered payment of 80%.
Yes.
11A does not become invocable by that one.
Yes, yes,
It's only lapse of time.
yes, yes.
But if they do not pay, tender or pay, except in other circumstances, whether acquisition proceeding will lapse or not, your answer is, it will not.
It will not, it will not.
Learned counsel
And in
repeats
any event, Delhi Airtech is not an authority for that
for that
proposition.
proposition. Learned penal counsel adds that the Delhi Airtech is not an authority for the proposition that violation of 17(3)(a) would result into invalidation of acquisition proceedings. That's your proposition.
Yes, ma'am.
Okay.
And my lords, I further rely upon para 12, where they have said, so far so good. The question, however, is as to whether the rigor of section 11A of the Act 1894 will apply when the appropriate government exercises its special power in cases of urgency, which does not contemplate the same procedure as in the normal acquisition process noted above. And then, my lords, para 17, your learned senior counsel had read that if in the case concerned the mandatory prerequisite is not complied, such acquisition will lose its character as being under section 70. Yes. I'm sorry, para 12, your lordship said.
Para 12, ah?
Yes.
Ah.
So far, so good.
11A is applicable to equation and so on, though without detailed discussion. From the provisions of the produced BIPRA, it is seen that the acquiring entity will be entitled to take possession without taking recourse to the procedure which is otherwise provided under section 16, wherein it contemplates passing up the award before taking, but under section 17, possession is permitted to be taken even before the award is passed. Though such power was absolute earlier, subsection 3 was inserted by Act number so and so, whereby the precondition imposed before taking possession
Yes.
is that 80% of stand is to be tender paid. Tendered amount should be paid unless prevented. 80% no award is part will have to be tendered. The word employed in section 3 shall to be tendered paid before taking possession. Cannot be disposed to defrauding any discretion to the acquiring authority. In fact, the last sentence. Thereupon, with respect to estate, this word thereupon is correlated taking possession and payment in terms of price. Sine qua non.
Yes.
For taking possession. Therefore, payment of 80% taking over possession thereafter, the vesting of the land of the absent any one of these in the sequence, the emergency clause provision fails. It is a prerequisite condition to acquire and take possession of the land. Since such acquisition is permitted by exempting the requirement of the precedence 5A, and possession is permitted to be taken prior to an award being passed. It speaks of not only taking possession,
Yes.
it speaks of legality of the acquisition process itself.
Yes.
A sentence hangide illi.
Yes.
Ondsari hange sari ಓದ್ಕೊಳ್ಳಿ.
Yes.
Therefore, ಅಂತ start ಆಗ್ತದೆ ನೋಡಿ.
Yes.
Payment of 80% of taking possession to so and so vesting of land to place it. Absent any one of these in the sequence, the emergency so and so fails. It is a precondition to acquire and take possession. Not only taking possession, even to acquire this is the this of the land. Since such acquisition is permitted by exempting the requirement of procedure under section 5A, and possession is permitted to be taken over. Now, what is Prospective so and so so and so? Your contention that he will be entitled to only higher interest
Yes.
is may not be correct for this. I do not know.
Yes,
I
yes,
have
I
to
wrote down
treat it. Why?
It is only our,
Because rest of the acquisition procedure so. Now, para idನ್ನು ಓದ್ತಾ ಇದ್ದೇವೆ Mr.
Para
Bla.
12.
Para
Para
12 Delhi airtech ನಲ್ಲಿ para 12 which you had read other day.
ಅಲ್ಲಿ ಎನಿ ಒನ್ ಆಫ್ ದೆಮ್ ಅಂತ ಒಂದು ಅದೊಂದು ಬೇರೆ ಸ್ಟ್ರೆಸ್ ಮಾಡ್ಬೇಕು ನಾನು ತೋರಿಸಿ ನಮಗೆ
ಅದು
ಎನಿ ಒನ್ ಆಫ್ ದೆಮ್ ಅಂತಾರೆ
ಕರೆಕ್ಟ್ ಹಂಗೆ ಇದೆ ಅದು.
ಅದಾದ್ರೂ
ಎರಡೂ ಬೇಕು ಅನ್ಕೊಂಡು ಅಂದ್ರೆ ಇಟ್ ಸ್ಪೀಕ್ಸ್ ಆಫ್ ನಾಟ್ ಓನ್ಲಿ ಲಿಗ್ಯಾಲಿಟಿ ಆಫ್ ಟೇಕಿಂಗ್ ಪೊಸೆಷನ್, ಇಟ್ ಸ್ಪೀಕ್ ಆಫ್ ಲಿಗ್ಯಾಲಿಟಿ ಆಫ್ ಎಕ್ವಿಜಿಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ ಇಟ್ ಸೆಲ್ಫ್ ಅಂತ ನನ್ನ ಇಂಪ್ರೆಷನ್ ಐ ಗ್ಯಾದರ್ಡ್ ಆಫ್ಟರ್ ಹಿಯರಿಂಗ್ ಯು. I feel like that, but I have to treat, I have not formed any final opinions on. These are only cursory opinions which arise when we read, such opinions arise when we read novels also.
yes.
But
My lords, then I would beg to show your lordships, para 16 and 17.
you are entitled to argue.
Yes.
There is
My lords,
nothing like that.
I would ask your lordships to kindly see para 16 and 17. May I read, my lords? But it is a different matter. 17.
ಯಾಕೆ ಹಂಗೆ ಅಂದ್ರೆ ಅದಕ್ಕೊಂದು ರೀಸನ್ ಇದೆ.
Yes.
ರೆಗ್ಯುಲರ್ ಪ್ರೊಸೆಸ್ ಏನಿದಾವ ಅದು ಅಪ್ಲೈ ಆಗಲ್ಲ. ಅದನ್ನೆಲ್ಲ ಬಿಟ್ಕೊಂಡು ಸ್ಪೆಷಲ್ ಪ್ರಾವಿಷನ್ ಇದೆ. ಅವಾಗ ನೀವು ಸ್ಪೆಷಲ್ ಪ್ರಾವಿಷನ್ ಫಾಲೋ ಮಾಡಬೇಕು. ಏನ್ ಮಾಡ್ತೀರಿ ಮಾಡ್ಕೋಬೇಕು. ಇಲ್ಲ ಅಂದ್ರೆ ಎವ್ರಿಥಿಂಗ್ ವಿಲ್ ಫಾಲ್ ಡೌನ್ ಅಂತ ಒಂದು ಅನಿಸ್ತದೆ.
Please. My lords, para 16, the fourth line.
Para 16.
My lords get it. Therefore, even if possession is taken, such possession cannot be considered as legal so as to vest the land absolutely if the prerequisite condition for payment of 80% before taking possession is not complied. In such circumstance, by absolute vesting does not take place, it will lapse if the further process is not complied and the award is not passed within 2 years from the date of declaration. So again, they made it a twin requirement that there should be non-compliance with 17(3)(a) and the acquisition should not have been completed within 2 years. The award should not have been passed within 2 years from the final declaration.
ಅಲ್ಲಿ ವರ್ಡ್ ಲ್ಯಾಪ್ಸ್ ಅನ್ನೋ ವರ್ಡ್ ಆರ್ಡಿನರಿ ಪಾರ್ಲೆನ್ಸ್ ನ ಉಪಯೋಗಿಸ್ತಾರೆ.
Yes.
Not concept of lapse
Yes.
enacted in 11A.
Yes. Then, my lords, just last 2 paragraphs, I will trouble my lords. Para 17, last 4 lines. Of course, how to interpret this judgment is if in the case concerned, the mandatory prerequisite is not complied, such acquisition will lose its character as being under section 17. And if the award is not passed within 2 years from the date of declaration, it will lapse and not otherwise.
Correct.
Ali, very categorically, Honorable Supreme Court has said twin requirement. You must have not paid, plus you should not have passed the award within 2 years. Only then they will lapse, it will lapse, otherwise not otherwise. That is our humble submission. Of course, there are bits and pieces here and there. How to interpret this judgment is the question.
In fact, when Keswananda was
Yes.
decided, Shirvai suggested
Yes.
constitute a bench of 3 judges
Yes.
to decide what is decided in Keswananda.
Then, my lords, last point, my lords, kindly see para 26. The decision in this case based on the principle of law settled herein, if it arises for consideration in any other case under Act 1894 or any other enactment relating to land acquisition containing pari materia provisions, shall be applied only prospectively, and cases which have attained finality shall not be reopened. Therefore, even assuming that they can place reliance upon Delhi Airtech, the Honorable Supreme Court under Article 141, 142 has said that this decision is to apply prospectively, in which case we as the acquiring authority, we can't be held to the standard when all the proceedings have been completed by this date. The date of the Delhi Airtech judgment, my lords, is 14th October 2022. It was in fact passed after the remand order by the Honorable Supreme Court. So the judgment is held to be only prospective.
Read again.
Yes, please. The decision in this case, based on the principle of law settled herein, if it arises for consideration in any other case under Act 1894 or any other enactment relating to land acquisition containing pari materia provisions, shall be applied only prospectively, and the cases which have attained finality shall not be reopened.
Cases which have attained finality ಇದೆಯಲ್ಲ ಈ ಬೇಸ್ ಮೇಲೆ ರೀಓಪನ್ ಮಾಡಂಗಿಲ್ಲ.
Yes,
ಬಟ್ ಪೆಂಡಿಂಗ್ ಕೇಸಿಗೆ ಅಪ್ಲೈ ಆಗ್ತದೆ.
my humble submission is whether it
Even
my humble submission is because we are the acquiring authority. After all, the mandate of the Honorable Court has to be to the persons who are to obey the law. Now, if we are to pay 80% at the time of taking possession and obey the mandate of Delhi Airtech, we cannot do it if the judgment is rendered, it's sort of retrospective operation of a civil law.
ಅಲ್ಲ ಹಂಗ್ ಬರಲ್ಲ.
Now, how do we comply with the, yes,
I understand your difficulty.
Yes.
Because that amounts to enforcing law
retrospectively?
retrospectively. It is like that only. Law is declared where things have been already accomplished, put to rest. To use the words of Shakespeare,
Yes.
rest in silence.
Yes.
Rest in silence because proceedings are concluded. Pending proceedings ಗೆ apply ಆಗಂಗಿಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ ಅವರು. Pending proceedings ಗೆ the very doctrine of prospective overruling ಇವೆಲ್ಲ ಬರ್ತದಲ್ಲ.
Yes.
ಅದು pending proceeding ಗೆ apply ಆಗೇ ಬಿಡ್ತದೆ. Unless court says this law will be applicable effect from this date ಅಂತ ಹೇಳಿದ್ರೆ ಮಾತ್ರ.
Yes.
ಬಟ್ ಅಷ್ಟೇ ಹೇಳಿಲ್ಲ ಅವರು.
Yes.
ಮುಂದಿನದಕ್ಕೆ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅಂದ್ರೆ
Yes.
ಶಲ್ ನಾಟ್ ಬಿ ರೀಓಪನ್ಡ್ ಅಂತ. ಅಂದ್ರೆ ಕೇಸಸ್ ಈಗಾಗಲೇ
Finality.
ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ
I board on.
ಆ ಅರ್ಥದಲ್ಲಿ ಅಂತ ಅನಿಸ್ತದೆ. ನೀವೇನು ಒಪ್ಪಬೇಕು ಅಂತಿಲ್ಲ ನಾವು ಹೇಳೋದಕ್ಕೆ. ಒಂದು ರಿಫ್ಲೆಕ್ಷನ್ ಅಷ್ಟೇ. Subject to what Mr.
Yes.
ಒಳ್ಳ
Then, my lords, last paragraph in Delhi Airtech.
One second. Learned Panel Council drawing attention of board to para 26 of Delhi Airtech submits that law declared in the said decision is specifically stated to be prospective in operation, and therefore the case of the petitioners being anterior petitioners involving accusation anterior to that, comma, cannot be governed by that law, full stop.
Then, my lord,
However, court notices the entire paragraph, text of entire paragraph, which gives scope for arguing that it is prospective so far as cases which have already been heard and decided, in the sense that they cannot be reopened on the basis of such a declaration of law. And further, the cases that are still pending are governed by the law declared in Delhi heretic.
then, my lords, last paragraph, which is the operative portion.
Ah.
In the result, we pass the following order. Number one, the provision contained in section 11A of Act 1894 shall be applicable to cases in which the acquiring authority has not complied with the requirement of subsection 3A of section 17 of the Act 1894 by tendering and paying 80% of the estimated compensation before taking possession. Since possession in such cases cannot be considered to be taken in accordance with law and the vesting is not absolute. So here my humble submission is, my lords, last operative portion, again, their lordships point out the twin requirements. 11A has to be complied and 17(3)A has to be complied. If both are not done, then only it will be a lapse. So otherwise it will be difficult to, because if Honorable Supreme Court in Indore has said once vesting takes place, title is divested.
Now, 1 second, I will examine your proposition now. With due respect.
Yes. No, my lords, I am a student of law.
I am also.
Yes.
I am
I
kindergarten
don't need
student of
any
law.
respect.
I
Yes.
understand. No, just consequence to
Yes.
contemplate. Matai.
Yes.
Doctrine of lapse enacted in 11A
Yes.
operates on its own
Yes.
on the efflux of time,
Yes.
certain things having not been done. Mr. AG.
Yes.
It appears to be that.
Yes.
way. Whether proceedings are legal or not is one thing. Whether proceedings have lapsed by operation of 11A is another.
Yes.
Do you agree with this
Please,
proposition?
my lords, I bow down.
11A may not be applicable, but still acquisition may be set aside.
Yes. I bow down.
There are such cases. actually.
Yes, my lords. Yes.
But why?
But our only humble submission is, in any event, this case will not inure to the benefit of the petitioners. I bow down to your lordship's observation that dehorse section 11A, if the proceedings are vitiated.
Otherwise
by-
vitiated.
Otherwise vitiated, court has the power under.
Power to invalidate.
Yes, yes. But this judgment, since it imposes a twin requirement for lapsing, it will not avail to the benefit of the petitioners.
In other words.
Yes.
For the purpose of lapsing,
Yes.
11A has to be read with 17(3)A also.
3A also.
ಬರೀ 11A ಆದ್ರೆ ಆಗುದಿಲ್ಲ.
ಇಲ್ಲ.
17(3)A ಬೇಕಾಗ್ತದೆ. ಅದ್ರ ನಾನ್ ಕಂಪ್ಲೈನ್ಸು ಬೇಕಾಗ್ತದೆ.
That's all my proposition, my lord. My humble understanding of the judgment. Then just a few words on equities, my lords. Number one,
ಕಿರಣ್ ಏನ್ರ ಹೇಳೋದಿದೆಯಾ?
Nothing.
my lords,
ಇದ್ರ ಮೇಲೆ ಹೇಳಿ ನೀವೇ ವಾಟ್ ಎವರ್ ಯು ವಾಂಟೆಡ್ ವಿಸ್ಪರಿಂಗ್ ಇನ್ ಟು.
No, my lord, I'll
You
adopt
can
in-
whisper to us also.
No, my lord, I adopt what he is saying, my lord. It cannot be read in isolation. Both has to be read.
Because the other provisions are not applicable at all ಅಂತ. 17(3) ಇದ್ದಾಗ.
Yes,
17(3)A
yes,
read with 4 ಇದ್ದಾಗ. Rest of the provisions will not be applicable at all.
yes, and
Whereas 11A speaks of rest of the proceedings also.
yes,
Therefore, if that rest is removed,
yes,
it has to be construed this way ಅಂತ ನಿಮ್ submission.
that's
All.
my lords, just a few last words on equities. Kindly see, it is a large extent of 272 acres. No doubt the petitioners have been vehemently contending that they are using it for orphanage, etc., etc. It is the equivalent of 250 football fields. We have made a rough calculation. Each football field equal to 1.3 acres. Large extent of agricultural land, which is being held by a trust in the middle of Bangalore city. Secondly, my lords, admittedly 65 acres possession has been taken. So far as we are concerned, as the acquiring, the person for whom the acquisition is made, the beneficiary, we have made all payments which have been demanded by us by the land acquisition officer within time. Subsequently, the petitioners themselves approach the honorable court and they obtain stay orders. And now they say that the matter is lapsed because there is a delay in the acquisition proceedings. No doubt, my lords, I bow down to your lordship's observation that the standard is for the land loser. Of course, he is losing his land and a very low standard has to be applied. But still, and the standard is to be enforced strictly against the acquiring authority. But still, your lordships would kindly see, in fact, it is a win-win for the petitioners. Their real contest was with regard to the land reforms case, because there they were at the stage of virtually losing the entire 272 acres for a pittance under the land reforms proceedings. And 3 times the land reforms authorities had held that this is excess land. You yourself have made a declaration that this is excess land.
But it is struck down by.
Now it is struck. Now,
ಅವಾಗ
no,
ಈ
at that
argument
point in
available
time. So the last letter I sign off on, my lords, is their own letter where they have said, we are ready to hand over possession, subject to you complying with the agreement. You give us that amount, we are ready to hand over possession. This is where the petitioners stand. And therefore, my lords, my humble submission is the petition is misconceived. In any event, they will get huge compensation. And this is a huge public purpose as borne out by, as argued by Mr. Additional Advocate General.
One other aspect before senior counsel.
ಹೇಳಿ.
Annexure E in writ petition 3884 of 1999 may be seen, my lord. That is the objections under 5A, my lord.
5A.
5A.
Correct.
So the objections, if your lordship kindly sees.
Other day you read it, na?
Yes, one of the objections is that it causes unemployment to the trust. Now, my lord, when a property,
ಅದೇನ್ ಗೊತ್ತಾ?
that's all,
See,
All I want
all
to say
types of
is-
contentions will take.
will be taken.
Because
I-
sometimes judges ಇದನ್ನ ತಗೊಂಡಿಲ್ಲ ನೀವು, ಈ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿಲ್ಲ, ಆ ಕಂಟೆನ್ಷನ್ ಹಂಗೆ ಹೇಳ್ತಾರ ಅಂತ ಅವ್ರು ಏನ್ ಮಾಡ್ಯಾರ, ಕಂಪ್ರಹೆನ್ಸಿವ್ಲಿ ಏನೆಲ್ಲ ತಗೋಬೇಕು ತಗೊಂಡಾರೆ. ಯಾವ್ದಾವ್ದನ್ನ ನಾವು ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕು ಬಿಡ್ಬೇಕು ಅನ್ನೋದು ನಮ್ಮ ವಿವೇಚನೆಗೆ ಬಿಡುವಂತ ವಿಷಯ.
And the, since the land is being acquired for the benefit of the farmers, my lord, and the trust holds the property in fiduciary capacity, they are not to be equated with the ownership of a private individual. Like me owning a personal property and a trust owning a property is quite different, my lord. The trust, though the property will vest with the trustees, but they hold it for the beneficiaries.
Correct.
And here, the beneficiaries are the villages, even as per the objects of the trust itself. And what is the total extent of land that they own is about 400 acres or 369. They're still left with large parcel of land to enforce or achieve their objects of the trust. It is not that they'll be denuded completely and the objects of the trust cannot be implemented at all, is not the case at all. They'll be still left with large parcels of land and their objects of the trust can be achieved.
Learned AAG lastly submitted that there is difference between a private person holding private property and a public trust holding private property. So this difference should inure to the benefit of acquisition. Semicolon. Even otherwise, the trust would retain still a large chunk of land if the acquisition is upheld, and therefore equities operate in favor of the trust itself.
And one other last note,
Ah.
that there's a writ petition filed by 270 farmers who wants the yard to come up in this place. That itself will disclose that it is for a public purpose and the villages are also going to be benefited.
So that will be very dangerous
The
proposition.
villages, now, my lord,
One last point.
as I,
Because ನಾನು ಒಂದು ಲ್ಯಾಂಡ್ ಎಕ್ವೈರ್
I got it.
ಪ್ರಯತ್ನ ಮಾಡುವಾಗ
it could-
ಒಂದು 100 ಜನರಿಗೆ ನನ್ನ ಅಪೋನೆಂಟ್ ಒಬ್ಬ ನಾನು ಕೋರ್ಟ್ ಫೀ ಕೊಡ್ತೇನೆ, ಒಂದು 10,000 ರೂಪಾಯಿ ಆಗ್ತದೆ, ನೀವು ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕ್ರಿ ಅಂತ ಹೇಳಿ ಅದ್ರ ಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ.
just to show public purpose.
First, he also points out that 270 farmers had filed
Writ petition number.
WP number. ಯಾವ WP ಅದು
No, no, this is-
ನಂಬರ್ ಸೊ ಏನಾಗ್ತದು WP ಗೆ?
I'll just point out.
ಅಲ್ಲ ಅದಕ್ಕೆ ಅದು ರಿಸಲ್ಟ್ ಏನು?
Result is it, what the- what happened in the review petition? which is
I will
filed.
just furnish that.
I'll just
number.
point out that.
That will be very ಹಂಗಾಗೋದು. That may be-
No, it's I understand, your lordship.
Okay. Mr. Holla?
My lord,
Ah.
first of all, the argument of the learned advocate general, additional advocate general, this is a public trust, therefore, my lord, we can take it. I can only say this, government must give land for, my lord, this kind of a trust, which is, my lord, in the name of, my lord, for propagating Gandhiji's and Vinoba Bhave's principle. On the contrary, what are they trying to do? Take away, my lord, the land of the trust, which is meant, my lord, to propagate, my lord, today, my lord, I know Mahatma Gandhi and Vinoba Bhave, they must be, my lord,
Mr.
turning in
Palla.
their grave.
Submits. ಅದೇ ಯಾವ ರೂಲ್ ಟ್ರಸ್ಟಿಗೆಲ್ಲ ಲ್ಯಾಂಡ್ ಕೊಡ್ಬೋದು ಅನ್ನೋ ಬಗ್ಗೆ ರೂಲ್ ಇದೆಯಲ್ಲ ಯಾವ್ದು? ಜಸ್ಟ್ ಹಂಗೆ ಜಸ್ಟ್ ಹುಡುಕಿ ನೋಡ್ಕೊಡಿ.
ನಾನು ಕೊಡ್ತೀನಿ ನಾನು. I'll give it to you.
Holla submits that under the extant land grant rules, there is a provision for allotment of land to the public trusts subject to certain conditions. Semicolon. That being the position, the contention of learned AG that since land belongs to the public trust, comma, the court should be little slow in interfering with the challenge to the acquisition process is untenable.
Land grant rules.
He also points out that the subject trust has been formed for effectuating the Gandhian principles and Acharya Vinoba Bhave's principles.
In fact, I can only.
ಅಲ್ಲಿ ಒಂದು ಎಂತದ ಪ್ರಾವಿಷನ್ ಇದೆ ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್
I'll give you a lot. ನಾನು ನೋಟ್ ಹೇಗೋ ನನಗೊಂದು ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ದೀರಿ.
ಅದ್ರಲ್ಲಿ ಹಾಕ್ಬೇಡಿ.
ಅದ್ರಲ್ಲಿ ಹಾಕೊಡ್ತೀನಿ, ಯಾಕಂದ್ರೆ ಇವರದ್ದು ಏನು ಹೊಸದೆಲ್ಲ ಬಂದಿದೆ ಅದನ್ನೆಲ್ಲ ಸೇರಿಸಿ ಕೊಡುವ, ಅದು ಏನ್ ಮಾಡ್ತಾರೆ ನೋಡೋಣ ಅಂತ ಹೇಳಿ ನಾನು ಇಟ್ಕೊಂಡಿದ್ದೆ. ನಾನು ಕೊಡ್ತೀನಿ, 3 ದಿವಸದಲ್ಲಿ ನಾನು ಕೊಟ್ಬಿಡ್ತೀನಿ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಇನ್ ಗಾಂಧಿನಗರ್, ಮಹಾತ್ಮ ಗಾಂಧಿ ಇಸ್ ಮಲಾಡ್ ಆಶ್ರಮ್, ಅದನ್ನ ತಗೊಳಕ್ ಹೊರಟಿದ್ರು. There was a huge public protest. Thereafter, my lord, they gave it up. All that I would say is this. This is a case where government must not go out of its way to, my lord, encourage, and then, my lord, today, Mahatma Gandhi has fought for our freedom. We enjoy, my lord, all that freedom. We have forgotten him. We have forgotten Vinoba Bhaveji, my lord, who went right across, my lord, the entire length and breadth of this country to, my lord, ensure there is equality. There is, my lord, the equitable distribution of wealth by, my lord, saying Bhudan Madi.
ಭೂದಾನ ಆಕ್ಟ್ ಇದೆ, ಭೂದಾನ
ಹೌದು ಹೌದು
ಭೂದಾನ ಯಜ್ಞ
correct
ಇದೆ.
ಆಗ್ತಾ ಇದೆ.
Yes.
In the background of this, for the state to say, I will acquire it and I will give you 15% interest. My lord, please look at this, my lord. 1965, when my T. Krishna was the advocate general here. T. Krishna, my lord, of the great fame,
Great
was the advocate general. He purchased, my lord, a plot. How much? 100 by 120. 18,000 rupees. He told my father was his good friend. He said, please come here. It was, my lord, in Sadashiv Nagar, right, my lord, diagonally opposite Rajkumar's house. Today, Rajkumar is there. 18,000, my lord, 1.5 rupees a square foot. My father said, illa, alli dacoits kaldarella bartare. Nanu, we were in a rented house with toilet outside. My lord, we continued there for 30 long years.
ನಿಮ್ ತಂದೆ ಯಾರಿಗೆ ಡಕಾಯಿತರು ಅಂತ ಹೇಳಿದ್ರು?
Our ಹೆದರಿಕೆ ಜಾಸ್ತಿ. He is, my lord, too timid a person, your lordships have seen. My lord, very studious. That's what, my lord, he was. And very principled. ಅವರನ್ನು ದುಡ್ಡು ಮಾಡಲಿಲ್ಲ, ನಾನೇ ತಗೊಂಡ್ರೆ ಇದಾಗುತ್ತೆ. ಟುಡೇ 18,000 ನಾನು ಅವಾಗ ತಗೊಳ್ತಾ ಇದ್ದೆ, 35 ವರ್ಷ ಆಯಿತು. I will pay 15% interest. ಅಂದರೆ 18,000 on 15% interest will work out to, my lord, 1 lakh rupees or 2 lakhs rupees. Today, that property is worth 45 crores. What is it that my learned friend is saying? Oh, 15% interest ಸಿಗುತ್ತೆ, ಅವ್ರಿಗೆ ದೊಡ್ಡ ಗಂಟು ಸಿಗುತ್ತೆ. ಏನ್ ಗಂಟು ಸಿಕ್ಕೋದು? They are, my lord, this is an acquisition, my lord, 25 years back. 1999, my lord, is this notification. And for what? For a market yard? They themselves said, we do not want this market yard. We are building it, my lord, in another place. My lords may recollect, there was a challenge, my lord, to the Srigandha, my lord. The farmers came and said, we want it here. Please acquire this land. They came and said, no, we don't want this because we are setting up market yard somewhere else, and they've set it up. Today, farmers are entitled to directly sell also. They need not go through the APMC. It is in this background that, my lord, to say, oh, 15% now ಕೊಡ್ತಾ ಇದೀವಿ, that will be, my lord.
Mr. Holla submits the contention that even if there is violation, even if the land is acquired in violation of section 17(3)(a) read with 4, comma, the landowners would be entitled to interest, higher interest, would not do any justice to the landowner.
Because, my lord, my lord, the notification is of the year 1999.
More particularly because of the devaluation of rupee in the long lapse of time.
So he said,
Ah.
just taken this and the Xerox. That's all. All right.
ಅಲ್ಲಿ ಇನ್ನೊಂದು ಕೋರ್ಟ್ನೆ ಕರೆದಂಗೆ ಕಾಣ್ತಾರೆ ನಿಮ್ಗೆ.
ಇಲ್ಲ. My lord, once I am here, I have to, my lord, fully concentrate.
Said that.
Then, my lord, my learned friend spoke of put karab. First of all, my lord, there is no put karab. Even if it is so, 19, my lord, I don't want to unnecessarily burden, keep on burdening. 86, 2 Karnataka Law Journal, 184, Division Bench, ILR 2009, Karnataka.
Court corrupt company.
Belongs to, my lord, the owner. Does not belong to, my lord, the private part.
ಅಲ್ಲ ಅದು
To the
ಯಾವ
government.
ಕೋರ್ಟ್ ಖರಾಬ್ ಅನ್ನೋದ್ರ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗ್ತದೆ. ಎ ಇದ್ರೆ ಓನರಿಗೆ ಬರ್ತದೆ, ಬಿ ಇದ್ರೆ ಯೂಸೇಜ್ ರೈಟ್ಸ್ ಇದೆ.
ಇದರಲ್ಲಿ
Though it belongs to-
ಇದರಲ್ಲಿ
It's not
ನಾನು
case that-
ಹೇಳ್ದಾಗೇನೆ,
The B,
Your case is not that it is a court corrupt.
it is B corrupt.
not with the
B.
greatest, no,
Corrupt which
no,
belongs,
no.
Anyway, why
I
did
tell
you
your lordships,
Why did you notify that?
no, it comes within, it's a, it is
with
located.
the greatest respect to my learned friend, it was an A corrupt. They converted, my lord, they changed, my lord, to be corrupt, my lord. After I filed, my lord, the writ petitions and, my lord, challenged it, my lord, before this honorable court in a contempt petition.
Mr. Holla submits the land,
Necessary, my lord, I'll produce all the documents.
the a kharab land, and therefore contention of other side that it is B kharab is not true. And even otherwise, once having notified the same for acquisition, a contra contention cannot be taken up. A judgment ಯಾವ್ದೋಯ್ತಲ್ಲ ಒಂದು ಯಾವ್ದು?
ಕೊಡ್ತೀರಿ.
ಇವ್ನು
ನಾನು ಕೊಡ್ತೀನಿ.
ಇವ್ನು
ನಾನು ಅಂದ್ರೆ
ಆನಂದ್ ಭೈರರೆಡ್ಡಿ ಸಾಹೇಬ್
ಅವಾಗ್ಲೇನೆ ಇಷ್ಟು ಕೊಟ್ಬಿಟ್ಟಿದೀವಿ ನಾವು ಜಡ್ಜ್ಮೆಂಟ್.
ಇಲ್ಲ.
I was hesitant, honestly. ಪಾಪ.
You are entitled.
ಅದ್ ಸರಿ,
ಯಾಕಂದ್ರೆ
ನಾವ್ ಇಷ್ಟು ಹಾಕ್ಬಿಟ್ಟಿದೀವಿ ಎಲ್ಲ ನಾವು 3 ಜನ
ನೀವು ಒಂದೇ ಒಂದು ಕಂಡೀಷನ್ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಕೈಗಾಡಿನೂ ಕೊಡ್ಬೇಕು ನಮಗೆ. ಯಾಕಂದ್ರೆ ನಾವ್ ಎಲ್ಲೆಲ್ಲಿ ಹೋಗ್ತೀವಿ ಅಷ್ಟು ತಗೊಂಡೇ ಹೋಗ್ಬೇಕು ಈಗ ರಸದಲ್ಲಿ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಐ ಆಮ್ ಕ್ಯಾರಿಯಿಂಗ್ ದೀಸ್ ಥಿಂಗ್ಸ್ ಫಾರ್ ಸ್ಟಡಿಂಗ್ ಅಂಡ್ ರೈಟಿಂಗ್ ದಿ judgment.
I understand. That's only your greatness.
No, sir, it's our duty. Then nothing like great at all. Although I was misled by you at the time of elevation. Anyway, that happens, nothing. Yes.
ಇಲ್ಲ, my lord. I can only say this. Some of us couldn't because of certain circumstances in which we were placed. ಅಷ್ಟೇನೆ, ಅದಕ್ಕಿಂತ ಹೆಚ್ಚು ಹೇಳೋದಿಲ್ಲ.
I only say you should thank God. That much we will say. Heartily I say this. Really, this seat is not that pleasant seat.
It's all right, I understand. But then, my lord,
it extracts
correct. Lot of
Blood.
time.
blood, sweat.
Correct. I know that. But then,
Hari work ಇರ್ತದೆ.
but then, my lord, today, in the 3 limbs of the state, even a common man, if you ask him, which of the 3 limbs, my lord, executive,
Naturally, he will point out
Legislature
this
or-
feeling itself.
that is because of the judges we have.
ಬಟ್ ಒಂದು ಸ್ವಲ್ಪ ಕೆಟ್ಟ ಅನಿಸ್ತು ನಂಗೆ ಒಂದೊಂದು ಸಾರಿ. ಐ ಶುಡ್ ಟೆಲ್ ದಿಸ್. ಐ ವಾಸ್ ವೇಟಿಂಗ್ ಫಾರ್ ದಿಸ್ ಅಪರ್ಚುನಿಟಿ. ನಾವು ಜಡ್ಜ್ಗಳು ಎಷ್ಟು ಕೆಲಸ ಮಾಡ್ತೀವಿ ಅನ್ಕೊಂಡು ತಿಳಿಯುವುದೇ ಇಲ್ಲ ನಿಮ್ಮ ಹೊರಗಿನವರಿಗೆ.
Correct.
ಅವ್ರು
ಅದು
ಏನ್
ಮಾತ್ರ-
ಅನ್ಕೊಂಡಾರ ಅಂದ್ರೆ ನಮ್ಗೆ ಇಷ್ಟು ಫೆಸಿಲಿಟಿಗಳು, ಇಂಥ ಕಾರು, ಇಷ್ಟು ಪೊಲೀಸರು ನಮ್ಮನ್ನ ಕಾಯ್ತು, ಏನ್ ಮಾಡೋಣ ನಾವು ತಗೊಂಡು. ಎಷ್ಟು ಕೆಲಸ ಅಂದ್ರೆ
ಗೊತ್ತು ನನಗೆ.
ಸತ್ಯವಾಗಿ ಹೇಳ್ತೀನಿ. ಒಂದ್ಸರಿ ನಾವೆಲ್ಲರೂ ಸೇರಿದಾಗ ನಾವ್ ಹೇಳ್ತೀವಿ, ಯಾರು ನಮ್ ಕೆಲಸ ಮಾಡಲ್ಲ ಹಿಂಗೆಲ್ಲ ಅಂತಾರಲ್ಲ, ಅವ್ರಿಗೆ ಶಾಪ ಹಾಕಿಬಿಡ್ಬೇಕು ಅಂತ ಅನಿಸ್ತದೆ ಅಂತ. ಬಹಳ ಜಾಸ್ತಿ ಕೆಲಸ ಮಾಡ್ತೇವೆ ನಾವು. ಎಷ್ಟು ಅಂದ್ರೆ ಕಂಟಿನ್ಯೂಸ್ ನಮ್ ಕನಸುಗಳು ಸಹಿತ ಕೇಸ್ನವ ಬೀಳ್ತಾವ.
Correct.
ಬೇರೆ ಕನಸುಗಳು ಸಹಿತ ಬೀಳಲ್ಲ. ರಿಯಲಿ ನಮಗೆ ಒಂದು ಖುಷಿಯಾಗುವಂತ ಕನಸುಗಳು ಬೀಳ್ಬೇಕಲ್ಲ, ಅವು ಬೀಳೋದೇ ಇಲ್ಲ. ಇವು ಸಿರ್ವಾಯಿ, ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್, ಹಾಲ್ಡರ್ ಬರ್ತಾರೆ, ಕಿರಣ್ ಬರ್ತಾನೆ, ಕೇಸ್ಗಳು ಅಡ್ಡಾಡ್ತಿರ್ತಾವೆ. ಅಂದ್ರೆ ಅಷ್ಟೊಂದು ಅಕುಪಾಯ ಆಗಿ ಹೋಗ್ಬಿಟ್ಟದೆ. ನಮ್ಮ ಜೀವನ ಯಾವ ರೀತಿ ಆಸ್ವಾದಿಸ್ಬೇಕು, ಬೇಂದ್ರೆ ಇವರೆಲ್ಲ ಹೇಳಿದ್ರಲ್ಲ, ಖುಷಿಯಿಂದ ಇರು ನೀನು, ಬೇಂದ್ರೆ ಅವ್ರದ್ದೊಂದು ಮಾತು ಜಸ್ಟ್ ಹಂಗೆ ನೋಡ್ತಾ ಇದ್ದೆ. ಖುಷಿಯಿಂದ ಇರಲಾಕ ಏನು ಬೇಕ ಸಖಿ, ಹೂತ ಹುಣಸೆ ಮರ ಸಾಕ ಅಂತ. ಸಾಕಾಗಲ್ಲ, ಜಡ್ಜ್ಶಿಪ್ ನಿಂದ ಕೆಳಗೆ ಇಳಿಯಬೇಕ ಅಂತ ಅನಿಸ್ತದೆ. ರಿಯಲಿ
ಐ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಮಲಾಡ್.
ಪಡ್ಲಿಕ್ಕೆ ಆಗೋದೇ ಇಲ್ಲ, ಅಷ್ಟೊಂದು ವರ್ಕ್ ಇದೆ.
ಲೆಟ್ ಮಿ ಟೆಲ್ ಯು ಲಾರ್ಡ್ಶಿಪ್ಸ್, ಈಗ ನಾವು ಇಷ್ಟು ಜನ ನಾವು ಸೇರ್ಕೊಂಡು ಎಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ವಿ. ವಾಟ್ ವಿ ಡೂ, ಬರೀ ತಲೆ ಮೇಲೆ ಹಾಕಿದ್ವಿ. ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಕಾಫಿ ಕುಡ್ಕೊಂಡು ನಾವು ಆರಾಮಾಗಿ ನಕ್ಕೊಂಡು ಹೋಗ್ತೀವಿ.
ಹೋಗ್ಬಿಡ್ತೀರಿ
ನೀವು
ಹಂಗಾಗ
ಬೆಳಿಗ್ಗೆ ರಾತ್ರಿ ಹಗಲು ಇನ್ನೊಂದು ರಜೆದಲ್ಲೂ ಕೂತ್ಕೊಂಡು, ರಜೆದಲ್ಲಿ
ಓದ್ಕೊಂಡು
ರಜಾ ಅಂತ
ಬರ್ಬೇಕು.
ಹೇಳ್ತಾರೆ ಇವರು. ಮಲಾಡ್ ಎವ್ರಿಬಡಿ ಸೇಸ್ ಓ ವೆಕೇಶನ್ 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 ಅಲ್ಲಿ ನೀವು ಕೂತ್ಕೊಂಡು ಇದನ್ನ ಮಾಡ್ತೀರಿ.
ಇಲ್ಲ,
ದೇರ್ ಇಸ್ ನೋ ವೆಕೇಶನ್ ಫಾರ್ ಯು.
ನಮ್ಗೆ
ಐ ನೋ ದಟ್.
ಬಹಳ ಜನ ಏನ್ ತಿಳ್ಕೊಂಡ್ರು, ವೆಕೇಶನ್ ಅಂದ್ರೆ ಸ್ಕೂಲ್ ವೆಕೇಶನ್ ಟೈಪ್ ಇರ್ತದೆ ಅಂತ ತಿಳ್ಕೊಂಡಾರ. ನಮ್ಗೆ ಹಂಗಿರಲ್ಲ. ವೆಕೇಶನ್ ಅಂದ್ರೆ ನಾವು ಜಾಸ್ತಿ ಕೆಲಸ ಮಾಡೋದಿರ್ತದೆ ಎಲ್ಲ ಜಡ್ಜಸ್ಸಿಗೆ. ಕೆಲವರು 100 ಗಟ್ಟಲೆ ಕೆಲಸ ಮಾಡುವಂತ ಶಕ್ತಿ ನಮ್ಮ ನಾಗಪ್ರಸನ್ನ ಅವರೆಲ್ಲ ಭಯಂಕರ ಇತ್ತು. ರಿಯಲಿ ಐ ಟೆಲ್ ಯು, ಐ ಶುಡ್ ಟೆಲ್ ದಟ್.
And not only that,
ಆಲ್ಸೋ
ಅಂತ ಮಾಡಿದವರನ್ನ ನಾವು ಹಾಕಿ ಬಾಯಿಗೆ ಬಂದಿದ್ ಬೈತೀವಿ.
ಏನ್ ಬೇಕಾದ್
ಅದೇ ಪ್ರಾಬ್ಲಮ್
ಎಲ್ಲ ಮಾಡಬಾರ್ದು
ನಮ್ಮಲ್ಲಿ.
ರಿಯಲಿ ಆ ರೀತಿ ಕೆಲಸ ಆ ರೀತಿ ಕೆಲಸ ಮಾಡುವಂತವ್ರು ಸಿಗುದೇ ಇಲ್ಲ. ಎನಿವೆ, ಬಾರ್ ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ಸ್ ಓನ್ ಪರ್ಸೆಪ್ಷನ್ ಅಬೌಟ್ ಜಡ್ಜಸ್. ಬಟ್ ಬಹಳ ಕೆಲಸ ಮಾಡ್ತೀವಿ ಅನ್ಕೊಂಡು ನಾನು ಆನೆಸ್ಟ್ಲಿ ಬಹಳ ಕೆಲಸ, ನಮಗ್ ಪ್ರೆಷರ್ ಇರ್ತದೆ. ಎಷ್ಟು ಸರಿ ಅಂದ್ರೆ ನಿಮ್ಗೆಲ್ಲ ಬೈಬೇಕು ಅನಿಸ್ತದೆ. ಇವರೆಲ್ಲ ನಮ್ಗೆ ಎಷ್ಟು ಸಮಸ್ಯೆ ಮಾಡಿದ್ರಲ್ಲ ನೀವು. ಆ DLN ರಾವ್ ಅವರು, ಅವ್ರ ಕಂಡ್ರು ನನ್ಗೆ ಇನ್ನೂ ಸಿಟ್ಟಿದೆ. ಆಮೇಲೆ KG ರಾಘವನ್ನು, ಈವನ್ ನಮ್ಮ MR ನಾಯ್ಕು, ಇವರೆಲ್ಲ ನಮ್ಗೆ ಏನೇನೋ ಹೇಳ್ಕೊಂಡು ಎನಿವೆ ನಾವು 1.5 ವರ್ಷದ ಆರಾಮಾಗ್ತೀವಿ ತಿಳ್ಕೊಂಡೇವು. ರಿಟೈರ್ ಆದ್ಮೇಲೆ
ಇಲ್ಲ,
ಡು ನಾಟ್ ನೋ,
ಆಮೇಲೆ ಆಗೋದಿಲ್ಲ. ಆಮೇಲೆ arbitration
ಯಾವಾಗ ಇದೆ
ಬಿಡೋದಿಲ್ಲ
ಆಗುತ್ತೆ ಅಂತ.
ನಿಮ್ಮನ್ನ ಬಿಡೋದಿಲ್ಲ. ಆಮೇಲೆ ಆರ್ಬಿಟ್ರೇಷನ್ ಇಟ್ಕೋತೀವಿ.
I am really feel that way. When people say judges do not work, I get offended. I get hurt, immensely hurt. ನೀವೆಲ್ಲ ಬಾರ್ನವ್ರು ಹೇಳ್ಬೇಕು ಪಬ್ಲಿಕ್ಕಿಗೆ. ಪಾಪ ಮಹೇಶ್ ಅನ್ನೋನೊಬ್ಬನೊಂದು ವಿಡಿಯೋ ಮಾಡಿದ್ ನೋಡಿದೆ. ಜಡ್ಜಸ್ ಎಷ್ಟು ಕೆಲಸ ಮಾಡ್ತೀವಿ ಅನ್ಕೊಂಡು ಬಹಳ ಚಂದ. ರಿಯಲಿ
ನಾನು ಪಬ್ಲಿಕ್ ಅಲ್ಲಾಗಿ ಹೇಳಿದ್ದೀನಿ.
he has explained that. ನೀವೆಲ್ಲ ತಿಳಿಸಿ ಹೇಳ್ಬೇಕು. ಏನ್ ಗೊತ್ತಾ, ಜಡ್ಜಸ್ ಗಳಿಗೆ ತುಂಬಾ ವೆಕೇಶನ್ ಇದೆ ಹಿಂಗೆಲ್ಲ ಮಾತಾಡ್ತಾರೆ.
ವೆಕೇಶನ್ ಬಗ್ಗೆ ಹೇಳಿದ್ದೀನಿ. ವೆಕೇಶನ್ ಬಗ್ಗೆನೇ ಹೇಳಿದ್ದೀನಿ. ಜಡ್ಜಸ್ ವೆಕೇಶನ್ ಅಂತೀರಿ, ಅವ್ರು ಕೆಲಸ ಮಾಡ್ತಾನೆ ಪಬ್ಲಿಕ್ ಆಗಿ ಹೇಳಿದ್ದೀನಿ.
ಹೌದು, ಭಾರಿ ಕೆಲಸ, ತುಂಬಾ ಕೆಲಸ ಇರ್ತದೆ. ಅದನ್ನೆಲ್ಲ ನೀವು ನಿಮ್ ಕ್ಲೈಂಟ್ಸಿಗೆ, ಪಬ್ಲಿಕ್ಕಿಗೆ ನಂದೊಂದು ಮನವಿ ಇದೆ ನಿಮ್ಮೆಲ್ಲರಿಗೂ. ನೀವು ಅದನ್ನ ತಿಳಿಸಿ ಹೇಳ್ಬೇಕು ಜನರಿಗೆ. ಜಡ್ಜಸ್ ಹಂಗಿರಲ್ಲ, ತುಂಬಾ ವರ್ಕ್ ಇರ್ತದೆ ಅಂತ ನೀವು ತಿಳಿಸಿ ಹೇಳ್ಬೇಕು. ನೋಡಿ ಯಾವ ರೀತಿ ಡೆತ್ಸ್ ಆಗ್ತಾ ಇದೆ, ನೀವು ಜಸ್ಟ್ ಅನಲೈಸ್ ಮಾಡಿ ನೋಡಿ. ನಮ್ಮ ಜಡ್ಜ್ಗಳ ಡೆತ್ ಪೋಸ್ಟ್ ರಿಟೈರ್ಮೆಂಟ್ ಯಾವ್ಯಾವ ಕಾರಣಕ್ಕೆ ಡೆತ್ ಆಗ್ತಾ ಇದೆ ನೋಡಿ. ಸ್ಟ್ರೆಸ್ ಕಾರಣದಿಂದ ಡೆತ್ ಆಗ್ತಾ ಇದೆ. ಅಂಡ್ ಒನ್ ಆಫ್ ದ ರೀಸನ್ಸ್ ಫಾರ್ ಕ್ಯಾನ್ಸರ್, ನಮ್ಮ ಶಾಂತನಗೌಡ ಸಾಹೇಬರು ಬಲಿಯಾಗಿ ಹೋದ್ರು. ಒನ್ ಆಫ್ ದ ರೀಸನ್ಸ್ ಈಸ್ ಸ್ಟ್ರೆಸ್ ಲೆವೆಲ್ ಬಹಳ ಹೈ ಇತ್ತು ಅಂತ ರಿಪೋರ್ಟ್. ಬಹಳ ಸ್ಟ್ರೆಸ್ ನ ವರ್ಕ್ ಮಾಡ್ತೇವೆ ನಾವು. ಹಂಗಾಗಿ ನಾವು ತಪ್ಪು ತಳ್ಕೊಂಡ್ರು ನೀವೆಲ್ಲ ನಮ್ಮನ್ನು ಬಹಳ ಪ್ರೀತಿಯಿಂದ ನಡ್ಸ್ಕೋಬೇಕು. ಹೌದು, ನಾವು ಎಲ್ಲೋ ಒಂದ್ಸರಿ ಏನೇನೋ ತಪ್ಪು ಮಾತಾಡ್ತೇವೆ, ಏನೇನೋ ಕಾರಣಕ್ಕೆ.
ಅದು ಮಾತ್ರ ಅಲ್ಲ.
another thing.
ಅದು ಮಾತ್ರ
Still, you should be very, very kind to the judges.
Absolutely. Not only that, my lord, this also happens. You have to hold the scale even. It's not an easy job.
ಅಷ್ಟು ಈಜಿ ಇಲ್ಲ, not that easy.
ಎರಡು ಕಡೆ, especially my lord in matrimonial cases or matters my lord of this nature,
ಅದೇಂಕು ಮುಗಿದೆ.
ನಿಮ್ಮ psych my lord, psyche will, I mean, you will not be able to sleep for days together.
Only thing is, ನಮ್ಮವ ಮೆಟ್ರಿಮೋನಿಯಲ್ ಕೇಸ್ ಆಗಿಲ್ಲ ಅನ್ನೋದೊಂದು ಬಿಟ್ಟರೆ ಉಳಿದಿದ್ದೆಲ್ಲ
ಅಲ್ಲ. ಅದಕ್ಕೆ I have publicly said this also. In 50% my success is to my mother and my wife.
Yes.
ಅಷ್ಟೇ. ಯಾಕೆ ಅಂತಂದ್ರೆ ನಾವು ರಾತ್ರಿ 12:30 ಮನೆಗೆ ಹೋದ್ರುನು ಬಾಗಲ್ ತೆಗೆದು ಊಟ ಹಾಕ್ತಾರೆ. ನಾವೇ ಅಲ್ಲಿ ಆಪೋಸಿಷನ್ ಇದ್ರೆ ಹೋಗಿ ಅಲ್ಲೇ ಆಫೀಸಲ್ಲಿ ಮಲ್ಕೋ, ಯಾಕೆ ಇಲ್ಲಿ ಬಂದಿದ್ದೀನಿ ಅಂತ ಕೇಳ್ತೀವಿ ನಾವು. ಹೇಳಿದ್ದೀನಿ ನಾನು, ಇದನ್ನು ಪಬ್ಲಿಕ್ಲಿ ಹೇಳಿದ್ದೀನಿ ನಾನು.
ನಿಜ, ಬಹಳ ವರ್ಕ್ ಇರ್ತದೆ. ಎಸ್.
Then my lord, the other contention is of my learned friend is that my lord, there is a publication in the Chavadi. Therefore my lord, they produce a document. Please have a look at the document.
ಪಡಿ
ಅದರಲ್ಲಿ
So that memo was not filed on that day.
ಪಡಿ.
ಇಲ್ಲ, ಅದು
ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ,
ನಿಮಗ್
ಸಾಹೇಬ್ರಿಗೆ
ಕೊಟ್ಬಿಡಿ, ಅದು
ಕೊಡ್ಲಿಲ್ವಾ?
ಕೊಡೋಷ್ಟಿಗೆ ಸಾರಿ.
ನೋ ಇಶ್ಯೂ. ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಟ್ಟಿರಾ?
ನನಗೆ ಕಾಪಿ ಕೊಟ್ರು. ಹಾಗಾಗಿ ನಾನು ಇದನ್ನ ಬಗ್ಗೆ ಹೇಳಕ್ ಹೊರಟೆ. ಇದರಲ್ಲಿ ಅವ್ರ ಪೇಜ್ ನಂಬರ್ ಹಾಕಿಲ್ಲ. ಯಾವ ಪೇಜ್ ಅಂತ ಹೇಳಿ
ಏನ್ ಚಿಕ್ಕದಿದೆ,
ನನಗೇನು ಕೊಡ್ಲಿಲ್ಲ.
You can take it.
ನೋಡೋಣ. ಥ್ಯಾಂಕ್ ಯು. ಇದು ಬೇಡವಾ?
ಅಲ್ಲ, ಯಾವ್ದಾದ್ರು ಒಂದು.
ಹೌದು ಒಂದು. ಯಾಕೆಂದ್ರೆ
ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 1 ಕಿರಣ್
ಮಲಾಡ್ ಅಲ್ಲ,
The-
publication mallard is according to them document number ತ್ರೀ ಅಂದ್ರೆ ಪೇಜ್ 4 ಅಲ್ಲಿ ಬರುತ್ತೆ ನೋಡಿ, ಅವ್ರು ಯಾವ್ದೋ 3-4 ಪೇಜ್ ಇದೆ, ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಒಂದು ಇಂಕಲ್ಲಿ ಬ್ಲೂ ಇಂಕ್ ಅದು ಬ್ಲಾಕ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. 4.
ಹಾ.
ಇದು ಪ್ಲೀಸ್ ಕಮ್ ಟು ಮುಲಾಟ್, ಪರ್ಮಿಟ್ ಟು ರೀಡ್ ದಿಸ್. ಅಕಾರ್ಡಿಂಗ್ ಟು ಮುಲಾಟ್, ದಿಸ್ ಇಸ್ ಎ ಪಬ್ಲಿಕೇಶನ್ ಇಂದ ಚಾವಡಿ. ಬೆಂಗಳೂರು ವಿಶೇಷ ಭೂಸ್ವಾಧೀನಾಧಿಕಾರಿಗಳ ಕಚೇರಿಯ ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರ ರೂಬು ಈ ಕೆಳಗೆ ಸಹಿ ಮಾಡಿರುವ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಯಶವಂತಪುರ ಹೋಬಳಿ ಶ್ರೀಗಂಧದ ಕಾವಲು ಹೇರೋಹಳ್ಳಿ ಗ್ರಾಮಸ್ಥರುಗಳಾದ ನಾವುಗಳು ಬರೆಸಿದ ಮಾಜರ್. ದಿಸ್ ಇಸ್ ಅ ಮಾಜರ್, ನಾಟ್ ಮುಲಾಟ್ ಎ ಪಬ್ಲಿಕೇಶನ್ ಆಫ್ ದಿಸ್ ಮಾಜರ್. ಬೆಂಗಳೂರು ವಿಶೇಷ ಭೂಸ್ವಾಧೀನಾಧಿಕಾರಿಗಳ ಕಚೇರಿಯಲ್ಲಿ ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ಈ ದಿನ ಅಂದರೆ 11-10-1994 ಶ್ರೀಗಂಧದ ಕಾವಲ್ ಗ್ರಾಮಕ್ಕೆ ಭೇಟಿ ನೀಡಿ ಸದರಿ ಕಚೇರಿಯ ಆದೇಶದ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಡೇಟೆಡ್ 30-9-94 ಭೂಸ್ವಾಧೀನ ಕಾಯ್ದೆಯ ಕಲಂ 4(2) ಮೇರೆಗೆ ನೀಡಿರುವ ಸಾರ್ವಜನಿಕ ತಿಳುವಳಿಕೆ ಕ್ರಮವನ್ನು ತಿಳಿಸಿರುತ್ತಾರೆ. ಯಾರಿಗೆ? ಈ ವಿಟ್ನೆಸ್ಗಳಿಗೆ. ಅಲ್ಲಿ ಪಬ್ಲಿಷ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಲಿಲ್ಲ. ಸದರಿ ತಿಳುವಳಿಕೆಯಂತೆ ಶ್ರೀಗಂಧದ ಕಾವಲ್ ಗ್ರಾಮದ ಜಮನ್ಲಾಲ್ ಬಜಾಜ್ ಸೇವಾ ಟ್ರಸ್ಟ್ ನವರಿಗೆ ಮತ್ತು ಇತರೆ 5 ಜನರಿಗೆ ಸೇರಿರುವ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸೋಗಳಲ್ಲಿ ವಿಸ್ತೀರ್ಣದ ಜಮೀನನ್ನು ಕೃಷಿ ಉತ್ಪನ್ನ ಮಾರುಕಟ್ಟೆ ಸಮಿತಿ ಪರವಾಗಿ ಭೂಸ್ವಾಧೀನದ ಬಗ್ಗೆ ಬೆಂಗಳೂರು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಕಚೇರಿ ಸಂಖ್ಯೆ ನಂಬರ್ ಸೋನ್ಸೋದಂತೆ ಭೂಸ್ವಾಧೀನ ಕಾಯ್ದೆಯ ಕಲಂ 4(1) ಪ್ರಥಮ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿದಾಗಿಯೂ ಸದರಿ ಅಧಿಸೂಚನೆಯು 3/9/1994 ಕರ್ನಾಟಕ ರಾಜ್ಯಪತ್ರದಲ್ಲಿ ಹಾಗೂ 17/9/94 in this ಇದು ಚಾವಡಿ ಕಟ್ಟಿಸಿದ್ದಲ್ಲ, ಇದು ಮಾಸರ್ ಮಾಡಿರುವಂತದ್ದು. They don't say that my lord, this is my lord put up on the notice board of the ಚಾವಡಿ of the village. ಏನ್ ಬರ್ದಿದ್ದಾರೆ ಅಲ್ಲಿ? ಗ್ರಾಮಸ್ಥಗಳಿಗೆ ಬರೆಸಿದ ಮಾಸರ್. This is a ಮಾಸರ್, not a my lord a publication in my lord first paragraph last word.
Mr. Holla draws attention of the court to page 4 of AAG's memo dated 18/12/24 and tells that it is only a merger and by no stretch of imagination can be construed as a notice affixed to Chowdi, village Chowdi. Full stop. That being the position, reckoning of statutory period of 1 year, 1 year, within which the final notification ought to have been issued, cannot be from that day, but from the anterior days. Okay.
And my lord, if your lordships come to my lord the bottom second page ಅಲ್ಲಿ ಯಾರು ಇವರು, ಹೆಸರೇನು, ಅವರ ಕುಲಗೋತ್ರ ಏನು, ಅಡ್ರೆಸ್ ಏನು, ಯಾವುದೂ ಇಲ್ಲ. This kind of a master, my lord, I didn't want to unnecessarily burden, my lord. I'll put the citations also, my lord. I'll give you your lordships. Number of times.
Since merger does not mention
Name
the
and
name
address.
and address, names and addresses of
Witnesses.
the witnesses, comma, it cannot be construed even as merger.
Master. Our High Court Division Bench,
In support of this, he wants to cite a decision.
my lord, ಈಗಲೇ ಹೇಳ್ತೀನಿ,
Decision.
ಅದನ್ನ ನಾನು ತಮಗೆ ತಂದು ಕೊಡ್ತೀನಿ.
All. Yes. Next point.
The next, my lord, sorry,
Ahead.
1 minute, just 1 minute, my lord. Too many papers. ಒಂದ್ ನಿಮಿಷ ನೀವು ನಾನು ತೆಗಿತೀನಿ, ನೀವು ಏನು ಮಾಡ್ಬೇಡಿ ದಯವಿಟ್ಟು. ILR 2010 Karnataka 62,
ILR 2010 Karnataka
page
62,
62, para 27.
para 27.
And
Mahajar ಬಗ್ಗೆ
ILR 2017 Karnataka
ILR 2017 Karnataka
3489.
3489
The division bench judgment, my lord, paragraph 10.
DB para 10.
This, my lord, specifically holds. In fact, there are other judgments of the Supreme Court also, which specifically hold. Mazar, my lord, without names and letters of witness cannot be taken cognizance of, my lord, it is of no consequence.
Okay.
Then, my lord, therefore, my lord, this contention that, oh, there is a publication in the village chapter, on the face of it, my lord, is untenable. Therefore, my lord,
Therefore, reckoning has to be from other notices
correct.
at the
and,
most.
my lord, 1 year is over. That's why, my
newspaper
lord, what
publication.
happened, correct. What happened is, therefore, my lord, my learned friend, my lord, AG being a very astute lawyer, my lord, I must compliment him. He has, my lord, said, both ಎರಡನ್ನು ಒಟ್ಟಿಗೆ ತಗೊಳ್ಳಿ ಅಂತೇಳಿ. ಯಾಕಂತಂದ್ರೆ ಕಾಂಪನ್ಸೇಷನ್ 18 my lord, ಸೆಕ್ಷನ್ 7, my lord, ಸೆಕ್ಷನ್ 17 ನೋಟಿಫಿಕೇಶನ್ ಆಗಿರುವಂತ ಹೇರೋಹಳ್ಳಿ ಬಗ್ಗೆ ಮಾತ್ರ, ಇದ್ರ ಬಗ್ಗೆ ಕಾಂಪನ್ಸೇಷನ್ ಇಲ್ಲ. my lord, ಇದೆರಡನ್ನು ಕ್ಲಬ್ ಮಾಡ್ಬಿಟ್ರೆ ಅಲ್ಲಿ ಕಾಂಪನ್ಸೇಷನ್ ಇಲ್ಲಿದೆ ಅಂತೆಲ್ಲ ತೋರಿಸಬಹುದು ಅಂತ ಹೇಳಿ. My submission to your lordship says, please look at, my lord, my list of dates.
ನಮ್ದು ಇನ್ನೊಂದು ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಡ್ಲಿಲ್ಲ ನೀವು. ಸಪೋಸ್ ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿ 5 ವರ್ಷ ಆದ್ಮೇಲೆ only to test the proposition that it should be reckoned from the date of Chowdi ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ, ಅದರ ಪ್ರೊಬೇಟಿವ್ ಏನು, ಅದರ ಜಸ್ಟಿಫಿಕೇಶನ್, ಇಟ್ಸ್ ಎಥಿಕಲ್ ವ್ಯಾಲ್ಯೂ ಅಸೆಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಕೇಳ್ತಾ ಇದೆ. ಸಪೋಸ್ ನೀವು 5 ವರ್ಷ ಆದ್ಮೇಲೆ ಚಾವಡಿ ನೋಟಿಸ್ ಹಾಕ್ತೀರಿ, ಅವಾಗ ಅಲ್ಲಿಂದ ರೆಕಾರ್ಡ್ ಮಾಡಬೇಕು ಅನ್ನಂಗಿದ್ರೆ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಟ್ ಜಜ್ಮೆಂಟ್, ಕೃಷ್ಣಮೂರ್ತಿ ಜಜ್ಮೆಂಟ್, ನೀವು ಯು ಕೋಟೆಡ್ ದಟ್, ಅಲ್ಲಿ ಫುಲ್ ಲೆವೆಲ್ನಾಗ ಟ್ರೀಟ್ಮೆಂಟ್ ಆಗಿಲ್ಲ. ಅದು ಅಲ್ಲಿ ನೋಡುವಾಗ ಕಾನ್ಸಿಕ್ವೆನ್ಸಸ್ ಯಾವ ರೀತಿ ನೋಡ್ಬೇಕು ಅಂದ್ರೆ ಎಕ್ಸ್ಟ್ರೀಮ್ ಪೊಸಿಷನ್ಸ್ ಅಂತ ತೊಗೊಂಡು ನೋಡ್ಬೇಕು ಅಂತ ರೂಲಿಂಗ್ಸ್ ಇದಾವೆ. ಸಪೋಸ್ 5 ವರ್ಷ ಆಗ್ತದೆ, ಅವಾಗೂ ವ್ಯಾಲಿಡ್ ಆಗಿಬಿಡ್ತದೆ ನಿಮ್ ಕಂಟೆನ್ಷನ್ ಒಪ್ಪಿಟ್ರೆ ನಾವು. ಅದು ಒಂದು ಹೈಲೈಟಿಂಗ್ ಒನ್ ಆಸ್ಪೆಕ್ಟ್.
My lord, I agree, my lord.
ಈ ಕೇಸ್ನಲ್ಲಿ ಹಂಗಿಲ್ಲ ಇಸ್ ಅನದರ್ ಥಿಂಗ್.
Yes.
ಬಟ್ ಆ ಪ್ರಪೋಸಿಷನ್ ಏನು ರಿಯಲ್ ವರ್ತೆ ಚಾಲೆಂಜಬಲ್ ಇದೆ ಅನ್ನೋ ಫೀಲ್ ಬರ್ತದೆ. ಐ ಡು ನಾಟ್ ನೋ, ಐ ಮೆಟ್ ಟು ಕಾಂಟೆಂಪ್ಲೇಟ್ ಆನ್ ದಟ್ ಈಸ್ ಅನದರ್ ಥಿಂಗ್. ಚಾವಡಿಯಿಂದ ತಗೋಬೇಕು ಅನ್ನಂಗಿದ್ರೆ ಮೊದ್ಲಿನ ನೋಟಿಸ್ಗಳನ್ನ ಇಗ್ನೋರ್ ಮಾಡಬೇಕು ಅನ್ನಂಗ ಆಗ್ತದೆ. ಆ ಇಗ್ನೋರ್ ಮಾಡಬೇಕು ಅನ್ಲಿಕ್ಕೆ ಏನು ಫಿಲಾಸಫಿಕ್ ಜಸ್ಟಿಫಿಕೇಶನ್ ಇಲ್ಲ. ಆ ಕೃಷ್ಣಮೂರ್ತಿ ಜಜ್ಮೆಂಟ್ ನಿನ್ನೆ 2 ಸರಿ ಓದ್ದೇನೆ. There is no philosophic justification for excluding those notices for reckoning of the period of limitation. By just in the village Chowdi notice ಮಾಡಿಬಿಟ್ರೆ the object of prescribing limitation can be defeated so easily. We have fixed Chowdi notice on such date and therefore count that. Why not to count from this notice ಅನ್ಕೊಂಡು discussion ಇಲ್ಲ judgment ನಲ್ಲಿ.
Sir, that decision is for with regard to the stay of disposition and not going ahead, or there is no impediment to pass awardment.
No, not that. Another judgment you cited.
This is M.I. Arun's.
Allah, ಇನ್ನೊಂದು judgment cite ಮಾಡಿ. Where it says from the date of Chowdi notice it should be reckoned.
That's the.
What is the then that will defeat, if that proposition is accepted, that would defeat enactment of limitation period even for issuing final notification. One, why it should be from Chowdi notice and why not from the first notice and reasoning ಇಲ್ಲ. First notice
Statute says that, if I can read it,
saying
the last date of such publication and giving of such public notice being hereinafter referred to as the date of publication of the notification.
if you read it literally, then the purpose for which you are prescribing the limitation would die. Because for doing that, they have not prescribed the period. That does not mean the Chowdi notice can be affixed anytime and therefore from that date, the period should be reckoned and I do not know. I have not formed any opinion. Just I was assessing the philosophical justification for that, the jurisprudential justification for that view.
Only the conduct of the state then will have to be looked into. If
In
there was an
this case, that
intention,
cannot arise because it's a very short period.
if there's
That's
an
another thing.
intention to defeat, my lord.
Yes.
Then all this Chavdi at a later point of time and then proceeding to pass. But here in
Ah.
this case,
Then, my lord, please look at, my lord, the dates. When was, my lord, the first notification, my lord, under section 4.1, 3/9/1994?
3/9/1994, next day it is published in newspapers.
ಅದಾಯ್ತು. ಅಲ್ಲ, 3/9 ಅಲ್ಲಿ ಪಬ್ಲಿಷ್ ಮಾಡಿದ್ದು. 2/9 is the notification.
3/9 is public.
3/9 publication. ಅದು ಮಾತ್ರ ಅಲ್ಲ. Chavdi notice is 11/10/1994 according to them. This is not a Chavdi notice at all, as I pointed out.
ಧನ್ಯವಾದ.
Assuming it is a Chavdi notice.
It is on 11/10.
11/10/94. When was the final notification issued? 10/10/1996.
11/10.
1994 to
94.
10/10/1996 is more than more than 1 year.
More than 1 year ಆಗ್ತದೆ.
ಹೌದು ನೋಡಿ,
ಇದಕ್ಕೆ 2 years ಇಲ್ಲ. ಇದಕ್ಕೆ 1 year is.
1 year. That's what I am trying to submit.
ಏನಿದೆ ಡೇಟ್? Just date.
11/10/1994, my lord, is the preliminary notification. Oh, sorry, 2/9/1994 is the preliminary notification.
Preliminary is
2/9/1994,
2/9/94,
published on 3/9 in that newspaper.
3/9/94,
10/10/1996 is the declaration of section 6.1, final notification.
10/10.
1996, published, my lord, in the newspaper on 31/10/1996.
ಅಲ್ಲ ಇದು ಅಜ್ಯೂಮಿಂಗ್ 10/10 ಇಟ್ಕೊಂಡ್ಬಿಟ್ರು
ಅಷ್ಟೇ.
2 years ಆಗಿಬಿಡ್ತದೆ ಅಂತ ನಿಮ್ಮ ವಾದ. ಅಲ್ಲಿರೋದು
1 year.
limitation ಎಷ್ಟು?
There was a stay, my lords. There was stay for 1 year, 1 day.
ಡ್ಯೂರಿಂಗ್ ದಟ್ ಪೀರಿಯಡ್ ಅಂತ ಆ ಕಂಟೆಂಟ್.
Yes.
yes,
Stay, which
say from 22/12/94 to
22/12/1995.
yeah, 94.
WP number 2888 of 94.
WP.
WP 28988.
988 of 94.
28988 ಏನು?
28988 of 94. Stay for 1 year, 1 day.
Stay was granted on 22nd of December 94. man.
20
of
2/12.
Yes, 94. Almost a month from village Chavdi.
ಯಾವ್ದು
Okay.
ಇದು?
Let us.
Then, my lord, the second submission that has been made is that the award, my lord, is required to be passed within 2 years.
Yes.
There was a stay order in, my lord, 6880 of 1997. Therefore, they could not. I, my lord, leave it at that. I don't want to, my lord, say that, because even if a stay is granted, my lord, that's the proposition of law, my lord. That even if a stay of disposition is granted, courts have held, my lord, that, it is, my lord, it,
Come in the way of
correct,
this
correct,
one.
correct.
So
it-
that discount is permissible.
Then, my lord, the next contention is, there is a deposit and it is admitted. ಅದಕ್ಕೊಂದು ಜಡ್ಜ್, my lord, ಅವರ ಒಂದು ಕಂಪೈಲೇಷನ್ ಅಲ್ಲಿ, ಪ್ಲೀಸ್ ಕಮ್ ಟು, my lord, ಇನ್ನೊಂದು ಕಂಪೈಲೇಷನ್ ಹಾಕಿದ್ರು. 2 ಕಂಪೈಲೇಷನ್ ಹಾಕಿದ್ರು ಅವತ್ತು. 2ನೇ ಕಂಪೈಲೇಷನ್ ಅಲ್ಲಿ, ಪ್ಲೀಸ್ ಕಮ್ ಟು, my lord, page 15.
Of compilation dated
18/12/2024.
18/12/2024. ಹಾ.
ಪ್ಲೀಸ್ ಕಮ್ ಟು, my lord, ಇದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 8 ಬರುತ್ತೆ. ಒಂದು LIC
ಅವತ್ತು-
ನಂಬರ್ ಅಂತ ಬರುತ್ತೆ.
ಅವತ್ತೇ 2 ಹಾಕಿದಾರಾ?
2 ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅಲ್ವಾ? 5 2
No, only one.
ಅಲ್ಲ ಅದು ನಿಮ್ದಾಯ್ತು ಮೋಸ್ಟ್ಲಿ. ಅವ್ರು ನೀವು ಒಂದು ಹಾಕಿರನು?
ನಾವೇನ್ ಹಾಕಿದ್ವಿ?
ಮತ್ತೆ ಇದ್ಯಾರು ಕೊಟ್ಟಿರೋದು? LIC ನಂಬರ್ ಅಂತೆಲ್ಲ ಹಾಕೊಟ್ಟು.
That is our mem.
ಹೌದು.
Yes, yes.
ಸೊ 2
Correct,
ಹಾಕಿದ್ದೀರಾ
correct.
ಅವರು?
Two mem.
2 ಹಾಕಿದ್ರು ಅವರು.
ಅದೊಂದು ಕೊಡಿ.
ಅವರಿಗೆ ಮರ್ಸೋಗ್ಬಿಟ್ಟಿದೆ.
18/12
Compilation of judgments and condemned.
ಅಲ್ಲ,
18/12 ನಿಮ್ಮಲ್ಲಿ ಕಾಪಿ ಇದೆ ಒಂದು
ಅವರೇ ಕೊಟ್ಟಿದ್ದು ನನಗೆ.
ಕೊಡಿ. ಇದು ಈ ಕಂಪೈಲೇಷನ್ ಜೊತೆಗೆ ಇಟ್ಬಿಟ್ರಿ. ಈ ಡೇಟ್ ಒಂದೇ ಡೇಟಿಗೆ ಇರೋದು.
ಮಿಲಾಡ್
18/12 ಇದು ಮತ್ತೊಂದು 18/12. ಅದು ಎಷ್ಟು ಇದು ಪೇಜಸ್ ಇದೆ ಅಂತ ಹೇಳಿ.
ಇದರಲ್ಲಿ ಒಟ್ಟು ಪೇಜಸ್ 16 ಇದೆ.
16.
ಮೆಮೋ ಅಂತಿದೆ ನೋಡಿ.
ಆಗೋತಾಯ್ತು.
ಕಾಪಿ ಆಫ್ ದ ಜಡ್ಜ್ಮೆಂಟ್ ಇನ್ WP 12.
ಎಸ್ 18/12 ಇದು ನಂಬರ್ 1 ನಂಬರ್ 2 ಅಂತಂದು.
ಮಿಲಾಡ್, ತಾವು ಹೇಳಿದ್ರಿ ನಮ್ ಕಷ್ಟ ನಮ್ಗೆ ಗೊತ್ತು ಅಂತ ಹೇಳಿ ನಾವು ಹೇಳ್ತೀನಿ. I'll tell you, my lord. Despite, my lord, having the assistance of three here, and my learned advocate general, my lord, having, wonderful companion there, my lord, to help him. I mean, young instruct, my lord, lawyer who's very efficient to instruct him. ನಾವು ಮೇಲೆ ಕೆಳಗೆ ಪೇಪರ್ ಇರೋದಿಲ್ಲ. ತಮಗೆ when you sit there alone, ಇಷ್ಟೊಂದು ಕೊಟ್ಟಾಗ ನೀವು ಎಲ್ಲಿಂದ ಹುಡುಕ್ತೀರಿ?
Actually ತ್ರಾಸ ಆಗ್ತದೆ.
I know that. ಇದರಲ್ಲಿ, my lord, please come to running page, my lord, 15. 15. ಅಲ್ಲ, ಸಾರಿ, 8. ಎರಡನೇದು ಕೊಟ್ರಲ್ಲ, 18, 12 8. LIC ನಂಬರ್ 1 ಅಂತ ಬರುತ್ತೆ.
Correct. 1 of 2002.
ಇದು ಯಾವುದರ ಬಗ್ಗೆ ಸ್ವಲ್ಪ ನೋಡಿ. It is not in respect of ಶ್ರೀಗಂಧದ ಕಾವಲ್, it is in respect. ಅದಕ್ಕೆ ಹೇಳಿದ್ ನಾನು, my learned friend, my lord, is very astute. I must compliment him. ಇದನ್ನ ಎರಡು ಸೇರಿಸ್ಬಿಟ್ಟು, ಇದು ಹೇರೋಹಳ್ಳಿ ಬಗ್ಗೆ ಮಾತ್ರ, not in respect of ಶ್ರೀಗಂಧದ ಕಾವಲ್. That is, my lord, section 17 notification, not section 4. Please come to, my lord, this order proceeding with the signature presiding officer, reference received under the special land acquisition officer, dated so under section 18, in respect of the acquisition land measuring 32 acres 5 guntas of Herohalli village.
So there is no, in fact, only ಈ ಲ್ಯಾಂಡಿಗೆ ಅಷ್ಟೇ ರೆಫರೆನ್ಸ್ ಕೇಳಿದ್ ನೀವು.
Correct.
ಬೇರೆದಕ್ಕಿಲ್ಲ.
ಇಲ್ಲ, section 17 ಬಗ್ಗೆ ಮಾತ್ರ. And I'll point out how, my lord, it has absolutely no relevance as far as ಶ್ರೀಗಂಧದ ಕಾವಲ್ is concerned. And ಶ್ರೀಗಂಧದ ಕಾವಲ್ ನಮಗೆ ಬೇಡ ಅಂತ ಇವರು ಹೇಳಿ ಹಾಕಿದ್ದಾರೆ.
Shri Holla draws attention of court to page 18 of memo number 1 dated 18/12/2024 filed by the AAG, and tells that the reference under section 18(1) of 1894 Act was confined to Herohalli land,
which is a subject matter of section 17 notification.
which is subject matter of acquisition under section 17(3)(a),
Of the
and not the
ಶ್ರೀಗಂಧದ ಕಾವಲ್
land in Srigandha Kaval.
relating to, my lord,
Comprised in
388.
WP number,
First is, my lord, 37140.
ಅಲ್ಲ, Srigandha Kaval, the
ಶ್ರೀಗಂಧದ ಕಾವಲ್ is 3884 of 1999.
comprised in WP 3884 of 1999.
Then my learned friend also, my lord,
Therefore, the contention that once request is made for compensation, inclination is shown for compensation, comma, the right to challenge acquisition goes, is not applicable, at least to this land is concerned.
one. Secondly, I'll point out again one more. Argument is, my lord, based on, my lord, my learned friend, the AG's argument, my lord, based on Nandakishore's compilation. Please come to, my lord, a compilation which, sorry, so sorry, my lord.
No problem. Wait, understood now.
I will
understood.
try and give, my lord, one note.
ಹಾ, ಒಂದ್ note ಮಾಡಿ,
It's my.
ಯಾವುದು ಪೇಜ್ ನೇಷನ್ ಹಾಕಿ,
ಕೊಡ್ತೀನಿ, ಖಂಡಿತ.
ಯಾರ್ ಫೈಲ್ ಮಾಡಿದ್ದು ಅಂತಾನು ಹೇಳಿ,
ಕೊಡ್ತೀನಿ.
ಯಾಕಂದ್ರೆ ತುಂಬಾ ಆಗಿದೆ.
I know, I know, I know. That's why I said.
ಅಲ್ಲ, ಏನಿಲ್ಲ, ಬೇರೆ ಇಂಜಸ್ಟಿಸ್ ಆಗ್ಬಾರ್ದು ಅಂತ.
Correct. ಅದು ಮಾತ್ರ,
ಇಂಜಸ್ಟಿಸ್
ಅದು ಒಂದು.
ಸ್ಟೇಟಿಗೂ ಆಗ್ಬಾರ್ದು, ನಿಮ್ಗೂ ಆಗ್ಬಾರ್ದು. ಸ್ಟೇಟ್ ಏನೋ
My lord,
ತಡ್ಕೊಂಡಿದ್ದು.
please come to,
Individuals ಗೆ
ನೋಡಿ,
ಯಾವ್ದದು?
19/7/2022 ಅಲ್ಲಿ IA number 1 of 22 ಅಂತ ಹಾಕಿದ್ದಾರೆ ಇವರು, ನಂದಕಿಶೋರ್ ಅವರು. ಅದನ್ನ ಅವ್ರು ತೋರಿಸಿದ್ರು. Argument.
ನಿಮ್ದು ಇದನ್ನ ಮಾಡಿ ಕೊಟ್ಬಿಡಿ, ಒಂದು ರೈಟ್ ಅಪ್ ನಲ್ಲಿ ನೀವೇನ್
ಕೊಡ್ತೀನಿ,
ಹೇಳ್ಬೇಕು ಅಂತೀರಿ ಅದನ್ನ ಹೇಳ್ಕೊಟ್ಬಿಟ್ರೆ,
ಕೊಡ್ತೀನಿ.
ನಿಮ್ ಪ್ರಪೋಸಿಷನ್ ಜಸ್ಟ್ ಹೇಳಿ ನಂಗೆ. ಜಸ್ಟ್ ನೋಡಿ.
ವಿಶ್ವನೀಡಂ ಟ್ರಸ್ಟ್
ಹಾ.
ಒಂದು ಲೆಟರ್ ಕೊಟ್ರು, ಸೇಯಿಂಗ್ ದಟ್ ಇನ್ ರಿಸ್ಪೆಕ್ಟ್ ಆಫ್ ಹೇರೋಹಳ್ಳಿ ವಿಲೇಜ್ ಆರ್ ದಟ್ ಲ್ಯಾಂಡ್, ಐ ಆಮ್ ಅಗ್ರಿಯಬಲ್ ಟು ಮೈ ಲಾರ್ಡ್ಸ್ ಕಾಂಪನ್ಸೇಷನ್ ಪ್ರೊವೈಡೆಡ್ ಯು ಗಿವ್ ಮಿ ದಿಸ್. ದಟ್ ಈಸ್ ಗಿವನ್ ಬೈ ವಿಶ್ವನೀಡಂ ಟ್ರಸ್ಟ್, ಹೂ ವಾಸ್ ಮೈ ಟೆನೆಂಟ್, ನಾಟ್ ಬೈ ಮೀ. ಅಂಡ್ ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಅವರು ಒಂದು ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಬಜಾಜ್ ಟ್ರಸ್ಟ್ ಅಂತ ಒಂದು ಲಾಸ್ಟ್ ಅಲ್ಲಿ. ಬಟ್ ದ ಲೆಟರ್ ಹೆಡ್ is apparent that it is ವಿಶ್ವನೀಡಂ ಟ್ರಸ್ಟ್ which has given it.
ವಿಚ್ ಇಸ್ ನಾಟ್ ಲ್ಯಾಂಡ್.
No, it is, my lord, a tenant of mine.
Mr. Holla, drawing attention to,
You are referring to this.
ನೋಡಿ,
ಯಾವ್ದದು?
That is annexure R16.
16.
Exer R16
Yes, my lord.
in
IA number 1 of 2022.
A number 1 of 2022
Dated
filed by
APMC, that is
PMC on
19/7/2022.
19/7/2022, tells that the said representation for accepting the compensation was not given by the petitioner landlord trust, but by the tenant,
Vishwanidam Trust.
namely Vishwanidam Trust.
Vishwanidam International Sarvodaya Center.
Vishwanidam International
Sarvodaya
Sarvodaya Center.
Which is the tenant of my lord, the trust.
And therefore, that cannot be held against the landowners.
And that also, my lord, relates to my lord Herohalli land, village.
That apart,
The said
said
represent,
representation relates to Herohalli land
not my lord,
and not
Srigandhad Kam.
land in Srigandhada Kav. Okay,
Then
ಇದನ್ನ ಮಿಸ್ ಮಾಡ್ತಿದ್ವಿ ನಾವು.
This says,
last.
for Jamnalal Bajaj
Correct,
Seva
that's what I'm
Trust,
said.
it
Last,
is not on Vishwanidam.
No, who is he?
No, it says some Jamnalal Bajaj Seva Trust, Dr. Ramesh Sharma, Chief Executive Officer. They must
Lord.
clarify, my lord,
Chief
that-
Executive Officer of what?
officer of the trust.
my lord,
That is the signature. They have not clarified here to say that he is nowhere associated with Jamnalal Bajaj Trust at all.
No, that apart, no, not like that. A trust can be represented in law
by trustees.
only by the persons whom the trust deed authorizes, not by anybody else.
So they must place records to this extent. my lord.
Hmm.
If a seal is affixed and signature is
Seal
made.
is not affixed with the greatest
See,
respect,
for
my learned friend.
Jamnalal Bajaj Seva Trust,
It's
it
not
says
a seal.
Dr. Okay,
Please take my lord, the document itself, my
please
lord.
take the document.
Please have it.
Yes.
Now,
Take
let's
the-
be very clear about it.
Then they
Let's
must
not-
place records to show that he is
Let
not
us
part
see.
of the trustee of the
Let us see.
Jamnalal Bajaj
I'll
Trust.
come to it. I'll show everything. I've never said, I also said
Because
that.
again, this is new argument.
New argument ಅಲ್ಲ, ಇವ್ರು ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ನಾನು answer. ಇದನ್ನ ಹೇಳಿದ್ರ?
That he is
It
not
is-
part of. How do I believe, my lord?
No, it's your, he's
Argument.
No, my lord.
your brother has given.
I
that-
have noted this, my lord.
My
Their
lord.
arguments, I have got, my lord.
My lord,
what they
one
have
humble
argued.
submission. In any event,
ಅಲ್ಲ,
my
ಇದು
lords,
ಸರಿಯಾಗಿದೆ.
they took part in a meeting dated 24/9/1999. Admittedly, they agreed to hand over possession if a certain sum was paid to them.
No, even
Admittedly,
assuming-
they have filed their writ for that money.
That's all right. Assuming that, yeah, Mr. Holla is saying that this is not, he is not our representative, because he would have said it in his petition. Had you produced it earlier, you produced it only at the later stage, date is also given. To that he is replying, because based upon that you are structuring your argument. Then he is entitled to say what is what.
He argued it.
But our
Your
only submission,
contention-
humble submission,
I
my lord,
understand.
yes,
But-
that they have never objected to acquisition per se.
Well-
Let them show one letter.
Panel counsel for APMC submits, regardless of authenticity of this representation of Vishwanidam, comma, the trust people themselves participated in the meeting held on
24/9/1999.
24/9/1999, which you cancelled subsequently, which was cancelled
Unilaterally
subsequently.
was cancelled by APS,
Okay, so and so, bracket nulli.
by the
The
state.
proceedings of this meeting were cancelled subsequently on
6/1/2000
6/1/2000.
by the state.
Bracket by the state, bracket company. All.
And that also relates only to Herohalli land, not my lord. Discretionary. ಅಲ್ಲ ಇದನ್ನು ಯಾವ್ದು ಕಾಂಪನ್ಸೇಷನ್ ಇನ್ನೊಂದೇನೋ ಮೀಟಿಂಗ್ ಆಯ್ತು ಅಂದ್ರಲ್ಲ ಅದನ್ನು ಅಷ್ಟೇನೆ.
Even participation of the trust people in the meeting in question related to Herohalli land alone and not to Srigandhada Kaval land. First of all, learned AG at this juncture interjects to tell that petitioners have not stated anything about the said representation for now disowning it. Okay, bracket complete. Okay.
I don't disown it, they disowned it.
No, no, ಅವ್ರು ಹೇಳೋದು. ಅವ್ರು ಈಗ ಡಿಸೋನ್ ಮಾಡಲ್ಲ, ನೀವು ಡಿಸೋನ್ ಮಾಡ್ಲಿಕ್ಕೆ
ನಾನಲ್ಲ.
you should have stated in your petition ಅಂತ, but you had no idea about that.
Not only
After
that,
they produced it, you are telling that.
not only that. They disowned it, my lord, not me. My lord, please look at it. APMC said, I am not giving now. Your, the land is, my lord, being acquired by, my lord, under the Land Reforms Act, is getting you free of cost under the Land Acquisition, Land Reforms Act. Therefore, we are not disowning this. I did not disown, they disowned.
Sir, the court is saying about this letter, not about the proceeding.
ಅಲ್ಲ ಅವ್ರು ಸಾಹೇಬ್ರು ಹೇಳೋದು ಈ ಇದರ ಬಗ್ಗೆ, ನಾಟ್ ದಟ್ ಲೆಟರ್ ಆಯ್ತದು. ಡಿಸೋನಿಂಗ್ ಮಲಾಟ್ ದಿ ಕಾಂಪನ್ಸೇಷನ್ ಅಲ್ವೇ ತಾವ್ ಹೇಳ್ತಾ
ಅಲ್ಲ,
ಇರೋದು.
ಅಲ್ಲ,
ಹಾ.
a letter, ಕಿರಣ್
ಲೆಟರ್
ಆ letter ಬಗ್ಗೆ
ಐ ಸಾರಿ, ಮೈ
ಅಲ್ಲ,
ಅಪಾಲಜಿ,
ಸಾಕು.
ಮೈ ಅಪಾಲಜಿ.
No problem.
ಓ
No problem.
ಸಾರಿ.
Yeah, fine.
Then, my lord, compensation tagondru, or my lord, some portion of the compensation which was also returned admittedly. Compensation ಕೇಳಿದ ತಕ್ಷಣ they, my lord, lose their right to, my lord, acquisition, my lord, challenging the acquisition. With regard to this, 3 contentions, my lord, I am canvassing before your lordships, which I had already submitted. One is, I, my lord, had already filed a writ petition, got an interim order, and, my lord, the letter, my lord, the meeting, everywhere I have said, this is without prejudice to my rights. Without prejudice to my rights, in respect of which I have already filed a writ petition, and, my lord, I am only coming here. I will continue to, my lord, challenge that acquisition. This is what I have stated. Please come to, my lord. Even the letter of that Vishwanidam also says the same thing. That Vishwanidam, my lord, is said, he'll take compensation. But then it is without prejudice to, my lord, to the writ petition, my lord, which was already filed, where an interim order is granted.
Mr. Hulla tells that even the letter of Vishwanidam was without prejudice to prosecute the pending writ petitions,
Where interim orders have been passed,
wherein interim orders were granted.
and specifically stating that even though we have come before you to take compensation, nothing prevents us from
From
challenging the
prosecuting
acquisition.
that one. And therefore, that would not take away the right to challenge the acquisition.
Then, my lord, as a broad proposition, they relied upon Justice Mohan's judgment, saying that once you take a compensation
You
or
cannot say.
agree to take, you lose your right.
No, he said, even if you show inclination
Inclination.
also,
My lord,
because you read that
One
judgment.
day, one day.
Correct.
one day. Honorable, my lord, this court, I'll just, ನಿಮಿಷಮ್ಮ, ಏನು ಮಾಡ್ಬೇಕು? ದಯವಿಟ್ಟು ನನ್ನ ಕರೀರಿ.
ನಿಮ್ಗೂ ಇಷ್ಟು ಪೇಪರ್ಸ್ ಎಲ್ಲ ನೋಡಿ.
ಇಲ್ಲ. ಅದೇ ನಾನು ಹೇಳಿದ್ದು. ನಮಗೆ ಇಷ್ಟೊಂದು ಇದು ಇದ್ದೂನು, we get confused. And, my lord, we start searching. ಪಾಪ ತಾವು ಒಬ್ಬರೇ ಕೂತ್ಕೊಂಡು ಎಂತದು ನೋಡೋದು. And, my lord, I understand the agony, the travails of a judge. How, my lord, difficult it will be. ನಾವು ತಂದು ಪೇಪರ್ ಅಲ್ಲಿ ತಂದು ಹಾಕ್ತಾ ಇರ್ತೀವಿ. ತಾವು ಅದನ್ನೆಲ್ಲ ಶೇಖರಣೆ ಮಾಡಿ, ಅದು ಎಲ್ಲಿದೆ ನೋಡಿ, ಇದನ್ನ ನೋಡಿ,
ಪ್ರಾಸಿನ ಕೆಲಸ ಇಷ್ಟ
ಹಿಡಿದು ಹೋಗ್ಬಿಡುತ್ತೆ. I know that.
ಅದು ಹಿಡಿದಿಲ್ಲ ಅನ್ನೋದೊಂದು ಖುಷಿ ಅಂತ ನಾವು ಅನ್ಕೊಂಡ್ವಿ.
No.
ಎಲ್ಲಿ ಹಿಡಿದ್ಬಿಟ್ಟು
It is only your grace. ಅಷ್ಟೇ, ಇನ್ನೇನು ಹೇಳಕ್ಕಾಗಲ್ಲ. ನೋಡಿ, ಕೋರ್ಟ್ ಮಾಸ್ಟರ್ ಅವರೇ. ಅಂಡ್ HMT ಕೇಸು ಕೊಡ್ತೀನಿ ನಾನು, ಅದನ್ನೂ ಕೊಡ್ತೀನಿ. ಥ್ಯಾಂಕ್ ಯು.
HMT ಅಲ್ಲಿ ಅಬ್ದುಲ್ ಹಮೀದ್ ಅಂತ, ಸೈಯದ್ ಖಾದರ್ ಅದು.
ಅಲ್ಲಲ್ಲ,
ನಾನು ಅಬ್ದುಲ್ ಹಮೀದ್ ಅಂತ ಹೇಳಿದೆ, ಸೈಯದ್ ಖಾದರ್ ಅಂತ ಜಸ್ಟ್ ಐ ನಾವು ರಿಮೆಂಬರ್.
my lord, please come to my lord, page 1, 1992, 1 SCC 114. ಇದರಲ್ಲಿ paragraph 4 ಬನ್ನಿ ಸ್ವಾಮಿ. ಹೆಡ್ ನೋಟೇ ಓದಿ. ಫಸ್ಟ್ ಲೆಟ್ ಮಿ ರೀಡ್ ದ ಹೆಡ್ ನೋಟ್. ಬೋಲ್ಡ್ ಹೆಡ್ ನೋಟ್, page 1 ಬನ್ನಿ.
In the officer was accepted, there was no contract between the parties and appellant was entitled to withdraw his offer.
Statement of the owner amounted to an offer in terms of the contract, which the landowner was entitled to withdraw at any time before its acceptance. Where no lump sum award compensation made and offer was withdrawn by the landowner before compensation was awarded after long lapse of time held, landowner was entitled to question the land acquisition. Paragraph 4 ಅಲ್ಲಿ ಅದನ್ನೇ ಹೇಳುತ್ತೆ. page 3 ಬಂದ್ರೆ, this is what they have said. Paragraph 4, my lord.
In our view.
In our view, learned single judge and division bench of the High Court of Andhra Pradesh were with respect clearly an error in dismissing the writ petition and the appeal filed by the appellant on the ground that the appellant had stated that he was willing to accept the acquisition provided the lump sum compensation was awarded to him. Statement of the appellant amounted to in law to no more than an offer in terms of the contract act. The said offer was never accepted by the land acquisition officer to whom it was made, leave alone making the lump sum compensation, award of lump sum compensation. No award at all was made by the said officer awarding compensation to the appellant till November 1917. Idರಲ್ಲಿ award ಆಗಿಲ್ಲ. When the aforesaid offer was withdrawn by the appellant or even till writ petition was filed, till the offer was accepted, there was no contract between the parties and the appellant was entitled to withdraw his offer. There was nothing inequitable or improper in withdrawing the offer, as the appellant was in no way bound to keep the offer open indefinitely, etc. Here, what has happened is there are two things, my lord. First, I, my lord, made an offer, they accepted it. They paid me some pittance. Then, my lord, I returned it. DD, they accepted it. So, my lord, both places, offer and acceptance. Same thing, my lord, here. Merely because, my lord, and my offer was without prejudice to my right to, my lord, challenge the acquisition which was already pending. And this judgment, my lord, clearly holds, even though you may have made an offer If it is accepted, my lord, it is not accepted, it does not end there. Or if it is accepted, my lord, when I returned, my lord, my DD, they gave me a DD for 2.5 lakhs or 2.5 crores. That DD, my lord, I returned to them. They accepted that DD.
You had not encashed the amount. It was there with you for 14 years.
They had
Correct. ಆಮೇಲೆ ಅದನ್ನ ರಿಟರ್ನ್ ಮಾಡಿದೆ. ಅದನ್ನ ತಗೊಂಡು ಅದನ್ನ ಎನ್ಕ್ಯಾಶ್ ಮಾಡ್ಕೊಂಡ್ರು. Why what happened was, when, my lord, they said, well, we get it free. ಅಲ್ಲಿ ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲ ಬರುತ್ತೆ. So we are now disowning it. That's why, my lord, the disowning, my lords may recollect, my lord, your lords have noted also. They disowned the whole thing.
Mr. Valla tells that his clients earlier taking rupees 2.5 crore,
2 point, ಎಷ್ಟಿದೆ ರೀ amount ಹೇಳಿ.
2 crore plus
2.537.
2.37 crore would not prejudice their right to litigate as to the legality of the acquisition proceedings, more particularly when the amount being returned was accepted by the other side.
And my lord, when we made that offer or my lord, that when we said give us compensation, it was specifically without prejudice to our right to contest. Writ petition was already pending,
First.
interim order was there.
Therefore, there was no concluded contract with regard to this event as observed by the apex court in para 4 of its judgment in Nutakki Shesharatnam 1992 1 ACC 114.
Then, my lord,
Yes.
my writ petition was pending. There was an interim order. I specifically told them that, my lord, I am doing it, my lord, without prejudice to my right to contest, my lord, continue the challenge to the acquisition. That also, my lord, is on in writing. Therefore, my lord,
Nothing will bar you from doing that. Got up.
therefore, my lord, ಅಲ್ಲ ಇದು ತಮ್ಮ ನೋಟಲ್ಲಿ ಬೇಕಾದ್ರೆ ಅದೊಂದು ಹೇಳ್ಬೇಕಾಗತ್ತೆ ತಾವು ಅಷ್ಟೇ.
ಬರ್ಕೊಳ್ಳಿ. ಅಲ್ಲ ಅದು ಬಂದಿದೆ. I have said that because this is subject to your reserving right to litigate.
And my lord, writ petition was pending and interim order was already there.
First off, when the amount was received and
When I
when it
offered,
was paid back,
when I offered, my lord, to receive the amount,
when the landowner offered to receive the compensation, his writ petition was very much pending
interim order was
and
there.
interim order was also operating. First off,
And my lord,
he had reserved his right to continue the litigation without prejudice.
Correct.
Okay.
Second judgment, my lord, please come to my lord, page 5. This is Mohan's judgment. Please come to my lord, paragraph 7. At my lord,
DB.
yes, ma'am, DB.
Ah.
ಇದರಲ್ಲಿ paragraph 7, my lord, my lords get that at running page 20.
To the effect,
This was, my lord, only to show there was a writ petition file which got dismissed. Last 3 lines ಬನ್ನಿ. ಇನ್ನೇನು ನಾನು ಜಾಸ್ತಿ ತೋರಿಸಲ್ಲ.
last 3 lines.
Last, my lord, para 7 ಅಲ್ಲಿ page 20 ನಲ್ಲಿ ಬಾಟಮ್ ಅಲ್ಲಿ
Hence start
laid down this court in Krishnamurti Sounds.
VT Krishnamurti.
In that case,
case,
division bench
division
held that the
bench
petitioners
is
cannot approbate and reprobate. Besides, there are judgments of this court which are conclusive that the acquisition is valid, though not for reasons urged in these appeals. Once, therefore, the validity of the acquisition has been upheld, appellant cannot try to attack those judgments categorically by a case of fraud on power. Idu, my lord, by then, my lord, writ petition had already been dismissed. So, my lord, this contention was canvassed. Please come to, my lord, running page, paragraph 8.
Paragraph 8.
Allene, page 21.
We will now take up.
They take up the important question which almost baffles us, whether this is a case of fraud on power. We have already referred to section 4.1 of the notification wherein the public purpose is stated to be wit for golf cum hotel resort near Bangalore Airport, Bangalore. Though section 4.1 notification proposed to acquire 39 acres, 27 guntas in the final declaration in the section 6.1, 2 acres, 23 guntas came to be left out, and the extent was shown only 37 acres, 4 guntas. We do not think that the acquisition as such would be challenged as not for public purpose. It is one of the axioms under the law of eminent domain that when a cross section of the public or even individual is benefited by so-and-so, then, my lord, they are entitled to. But what is more important is a second writ petition was filed. Please come to my lord, last 3 lines. There is a purpose of our saying so because one other defense is put forth, last 5 lines in paragraph 8.
Last 5 lines in paragraph.
Paragraph 8. 6 lines. There is a purpose in our saying so because one other defense put forth by the learned counsel of the Tourism Development Corporation was that there was concluded judgment upholding the validity of the acquisition. Therefore, the appellants cannot be allowed to attack the same collaterally. Then possession taken, all that, my lords get that next subparadali. Core of the matter is that the cause of action for challenging the validity of the acquisition arose so and so when 2 means of transfer deeds, etc., etc. Now, please come to my lord. Paragraph 10. At running page. Last page.
30.
Yes. Lastly, what remains to be seen is what is the effect of fraud. My lord, fraud on power would be, my lord, if section 17(3)(a) mandates, my lord, they must deposit 80%. If they don't,
That's fraud on power.
Power.
That's an contention.
my lord, idರಲ್ಲಿ ನೋಡಿ. What remains to be seen is what is the effect of fraud? Does it render the entire acquisition bad, or is it to be held to be bad only insofar as these appellants are concerned? We are of the view that if fraud unravels everything, it cannot be valid in part and invalid in some other parts. We need not go to that extent, etc., etc. More important is compensation was, my lord, paid. Paragraph 9 ಬಂದ್ರೆ ತಾವು ಹಿಂದಿನ ಪೇಜಲ್ಲಿ ಸಾರಿ ಅದೇ ಪೇಜಲ್ಲಿ ಸಾರಿ ಮಲ
ಅದು ಲಾಸ್ಟ್ 29.
ಎಸ್ ಮಲ ಅಲ್ಲೇ ಪೇಜ್ 30 ಬನ್ನಿ.
30.
ಅದು ಪ್ಯಾರಾಗ್ರಾಫ್ 30 ಸುಮಾರು ಅದು ಉದ್ದದ ಪ್ಯಾರಾಗ್ರಾಫ್
Correct,
ಸ್ಟಾರ್ಟ್ಸ್
correct.
ವಿತ್ ಸ್ಟಾರ್ಟ್ಸ್ ಮಲ ಆಕ್ಚುಲಿ ಅಟ್ ಪೇಜ್ 23 ನಿಂದ.
Very long paragraph it is.
ಹೌದು, ಬಟ್ ಲಾಸ್ಟ್ ಅಬೌವ್ ಪ್ಯಾರಾ 10 ಅಲ್ಲಿ ratio of this
Ratio of that case fairly applies here.
nor again in our consider opinion the previous decision upholding the validity of the acquisition would be of any value because,
Anyway, because
as we have
as
observed earlier,
yeah.
cause of action arose only in 23(3) and 24(3) when the
When the
transfer came to
transfers
be
came to
effective
be effective
and on
on
subsequent days.
subsequent days.
Therefore, when in ignorance of this transaction, if compensation had come to be accepted, we should not put that against those landowners. That question does not arise in this case. We shall relegate the parties.
No, so and so. What you ultimately say is the
Merely because
whatever we had taken
is of
no consequence
Consequence.
because our right to litigate was retained intact.
correct. And honorable my lord, this honorable court has held if there is a fraud on power, which my lord in this case, my lord,
Allah submits that where the law prescribes payment of 80% of compensation for invoking section 17(3)(a), comma, taking the land without making that payment itself amounts to fraud on statutory power, and therefore acquisition proceedings are vitiated. In support of that, he presses into service the coordinate bench, the division bench decision in Mrs. Behroj, Behrojde, Behroj Ramyar Bata, Batha versus SLAO. ILR 1991 Karnataka 3556.
then my lord, HMT case ಅಲ್ಲಿ ನೋಡಿ court master
95 Supreme Court.
95 2 SCC ಅದರಲ್ಲಿ
They directed return of
ಲಾಸ್ಟ್
the
ಅಲ್ಲಿ
land.
ಅಷ್ಟೇ they have directed refund of the return of the compensation. Sorry, 1 minute.
Restored to the respective landowners.
Correct.
Para 24.
Correct. Sorry, my lord, I gave you a lot, my lord. I think, my lord, sorry, my apologies. my lord. This is-
Proposition head.
ಇಲ್ಲ, ಕೊಟ್ಟೆ.
No,
HMT.
this I was citing. In fact, I cited this decision in this case to answer his contention that once validity of acquisition is faltered, land has to go back. Our contention, no, it need not go back. Once possession is taken, title will vest unimpeachably. Only right remaining with the landowner is to get the compensation ಅಂತ ಅವ್ರು ಹೇಳಿದ್ದು.
Correct.
ಅದನ್ನ ಕೌಂಟರ್ ಮಾಡ್ಲಿಕ್ಕೆ ನಾ ಇದನ್ನ this decision I had cited.
25 ಒಂದು ತಗೊಂಬಂದಿದ್ದು. My lord, this was, I had cited, my lord, earlier. ಇದನ್ನ ನಾನು ಕೊಟ್ಟಿದ್ದೆ ಜಸ್ಟಿಸ್ ನರಸಿಂಹ ಅವರದಲ್ವೇ?
ಯಾವುದು?
ಇದು ನಾನು 2024 ಅಲ್ವಾ ಕೊಟ್ಟಿದ್ದು?
ಅಲ್ಲ, ಇದು 95 ಟು SCC.
95 ಆದ್ರೆ ಅದರಲ್ಲಿ my lord ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ
ನಾವು ಹೇಳಿದ್ದೇನೆ ಅದರಲ್ಲಿ ಇದೆ ಅನ್ಕೊಂಡು.
ಕಾಂಪನ್ಸೇಷನ್ ವಾಪಸ್ ಕೊಡ್ಸಿದ್ರು.
ಕರೆಕ್ಟ್.
ನಾನು ನಿಮಗೆ 2 ಕೊಟ್ಟೆ. ಒಂದೇ ನಿಮಿಷ ಕೊಟ್ಟೆ. 2 ಕೊಟ್ಟೆ ನಿಮಗೆ. ಇಲ್ಲ, ನಾನು ಕೊಟ್ಟೆ.
ನೀವ್ ಹೇಳಿದ್ದು
ಹೌದೌದು.
ಸಪ್ತ ತತ್ವಗಳ ಮೇಲಿರುವಂತದ್ದು PS ನರಸಿಂಹ ಅವರದ್ದು ಜಡ್ಜ್ಮೆಂಟ್.
ಅಲ್ಲ, ಅದ್ ಬೇರೆ. ಇದರಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ 24 ಸ್ವಾಮಿ. ಅಷ್ಟೇ.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಇದರಲ್ಲಿ
HMT
HMT ಇದರಲ್ಲಿ
ಹಾ.
ರೀಫಂಡ್ ಆಫ್ ಕಾಂಪನ್ಸೇಷನ್
ಕೊಡ್ಬೇಕು ಅಂತ ಅನ್ಕೊಂಡು ಮಾಡಿದ್ರು ಅಷ್ಟೇ.
ಅಂದ್ರೆ ವೈ my lord I am citing this is ಕಾಂಪನ್ಸೇಷನ್ ತಗೊಂಡ ತಕ್ಷಣ ಲ್ಯಾಂಡ್ ಎಕ್ವಿಷನ್ ಆಫ್
ಇಲ್ಲ ಅಂತ ಅದು ಅವ್ರ
ಚಾಲೆಂಜ್ ಕ್ಯಾನ್ ಸ್ಟಿಲ್ ಬಿ ದೇರ್.
ಹಾ, ಆ ರೀತಿ ಅಂತ
ಅಷ್ಟೇ.
ಮಿಸ್ಟರ್ ಹೊಳ್ಳ citing para 24 of HMT versus Syed Khadar submits that where compensation is accepted, still the validity of acquisition was faltered by the apex court with a direction to restore land subject to repayment, refund of compensation amount
ರಿಸೀವ್ಡ್ ಬೈ ದಿ ಓನರ್,
by the landowner.
ಲ್ಯಾಂಡ್ ಓನರ್.
Received by the landowner. Full stop. Therefore, he tells that there is no thumb rule to the effect that once compensation is accepted, in no circumstance acquisition can be set aside. Okay.
Then my lord, I had cited my lord this earlier, that 2024 latest judgment of Justice Narasimha.
Correct.
Not may recollect my lord.
ಅದು ನಾವು ಸಪ್ತಪದಿ ಅಂತ ಹೇಳಿದ್ರೆ
Correct. ಅದು ಕೊಟ್ಟಿದ್ದೆ ನಾನು ನಿಮಗೆ, ಇನ್ನೊಂದು ಕೊಡ್ತೀನಿ.
anyway,
ಅದರಲ್ಲಿ they have
7 principles ಲೇಟ್ ಡೌನ್ ಮಾಡಿದ್ದಾರೆ ಅವರು.
My lord, ultimately, my lord, why did they, my lord, set out those principles? 3.1, please come to my lord, running page. 10, ಅಂದ್ರೆ ಮೇಲ್ಗಡೆ ಚಿಕ್ಕದಾಗಿ ಒಂದು ಬರುತ್ತೆ, ಮೇಲ್ಗಡೆ ಸ್ವಾಮಿ 10 ಬರುತ್ತೆ, 10 ಪೇಜ್ ನೋಡಿ. 2ನೇ ಲೈನ್ ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಪೇಜ್ಗಳು ಬರುತ್ತೆ. ಪಾರಾ 30.1 ಬನ್ನಿ, 30 ನಂತರ 7 ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಅಂತ ಮಾಡಿದ್ರು.
ಅದೇ ಅದನ್ನೇ ನಾನು ಹೇಳಿದ್ದು, ಸಪ್ತಪದಿ.
ಕರೆಕ್ಟ್. ರೈಟ್ ಟು ನೋಟಿಸ್,
ರೈಟ್ ಟು 1, 2, 3, 4.
Correct. Right to notice, right to be heard,
right to be heard,
right to reason decision,
right to be reasoned decision, duty
Duty
to
to acquire
acquire
only
only for public purpose, right of
restitution of fair compensation, right to efficient and expeditious process,
Correct.
right to conclusion.
Correct.
ಇದು 24 ವರ್ಷ ಆದ್ಮೇಲೆ, 25 ವರ್ಷ ಆದ್ಮೇಲೆ ನಾನು ಲ್ಯಾಂಡ್ ಎಕ್ವೈರ್ ಮಾಡ್ತೀನಿ, which my lord they had said, my lord, they don't want it.
ಅಲ್ಲಿ 30.5 ಬನ್ನಿ.
Correct.
Compensation has always been considered to be an integral part of the process of acquisition.
Absolutely. Otherwise, my lord, what will happen is, my lord, I have always said this, ಆ ಲ್ಯಾಂಡ್ ಓನರ್ ಪಾಪ ಅವನಿಗೆ 25 ವರ್ಷ ಆದ್ಮೇಲೆ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ರೆ ಆ ಲ್ಯಾಂಡಿಗೆ, he will, my lord, it's sufficient for him to bury himself ಅಷ್ಟೇ.
ಅಲ್ಲಿ 30.5.3.
Correct.
Our courts have not only considered compensation is necessary, but have also held that a fair and reasonable compensation is the sine qua non
Correct.
for any acquisition process. Mr. Holla draws attention of the court to paragraph 30.5 in Honorable Justice PS Narasimha's case, that the Kolkata Municipal Corporation versus Bimal Kumar Shah, 2024, SEC online, SC 968.
Then, my lord, Indore, should I continue or come back at 2:30? Subject to your lordship's convenience.
ಹೇಳಿ, ಮುಗಿಸ್ಕೊಳ್ಳಿ. ಇದು ಒಂದೇ ಅಲ್ಲ ನಮ್ಗೆ.
ಇನ್ನೊಂದು 4 ಪಾಯಿಂಟ್ ಹೇಳೋದೇ
ಹೇಳಿ.
ಆಯ್ತು, 15 ನಿಮಿಷ ತಮ್ಮ ಕೊಟ್ರೆ ನನಗೆ
ಇಲ್ಲ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಅಲ್ಲಿ ತಮ್ಮ ಊಟಕ್ಕೆ ತೊಂದರೆ ಆಗಬಾರ್ದು ಅಷ್ಟೇ, ಏನು ಇಲ್ಲ ಅಂದ್ರೆ ನಾ ಮಾಡ್ತೀನಿ.
ಮಧ್ಯಾಹ್ನ ಬರ್ತೇನೆ.
ಇಲ್ಲ ಇಲ್ಲ ಈಗಲೇ ಮಾಡ್ಬಿಟ್ಟು
ಹೇಳಿ.
ನನಗೇನ್ ತೊಂದರೆ ಇಲ್ಲ ಪಾಪ.
ಇಲ್ಲ ನಂಗೂ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಹಾಗಿದೆ
ಮಧ್ಯಾಹ್ನ ಸ್ವಲ್ಪ ಏನೋ ಒಂದು
ಆಗ್ಬೋದು
ಕಾರ್ಯಕ್ರಮ ಇದೆ.
ಆಗ್ಬೋದು, ನಾನು ಮುಗಿಸ್ಬಿಡ್ತೀನಿ.
ಆಯ್ತು.
ಮಿಲಾಡ್,
ಹಾ.
ಇಂದೋರ್ ಬಗ್ಗೆ ನಮ್ಮ
ಪ್ರೊಫೆಸರ್
AP ಪ್ರೊಫೆಸರ್ ಹೇಳಿದ್ರು.
ಹಾ.
Please look at Milord Indore. What were the question that arose in Milord in Indore?
ಅದನ್ನ ಕವರ್ ಮಾಡಿರಿ ನೀವು.
ಅಲ್ವೇ, ನಾನೊಂದು ನೋಟ್ ಅಲ್ಲಿ ಕೊಡ್ತೀನಿ.
ಕೊಡಿ. ಅಲ್ಲ ಅದನ್ನ ಕವರ್ ಮಾಡಿರಿ, ನಾ ಬರ್ಕೊಂಡಿನಿ.
ಹೌದು,
ಅದರಲ್ಲಿ
Correct.
what issue arose in that
ಹಾ.
case was this.
ಹೌದು,
It did not much relate to the ratio laid down in ಇದರ ನೆಕ್ಸ್ಟ್ ಏನ್ ನಮ್ಮ ಡೆಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಬರ್ತಲ್ಲ ಅದ್ರಲ್ಲಿ ಇರುವಂತದ್ದಕ್ಕೂ ಇದಕ್ಕೂ ಬೇರೆ
ಅದು
ಬೇರೆ
ಮಾತ್ರ ಅಲ್ಲ, ಡೆಲ್ಲಿನಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ Milord issue arose.
ಇದೇ ಇಶ್ಯೂ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ. ಈ
Correct.
ಇಶ್ಯೂ ಡಿಡ್ ನಾಟ್ ಅರೈಸ್ ಇನ್ ಇಂದೋರ್ ಅನ್ನೋದು ಯಾವ ಸಬ್ಮಿಟ್.
ಅದು ಒಂದು. ಎರಡನೇದಾಗಿ their contention, Milord, his contention is both Milord 11A and Milord 17 Milord 3A must be considered together ಅಂತ. Though that is not Milord the proposition. Please come to Milord paragraph 17 of that AirTech ಅಲ್ಲಿ ಡೆಲ್ಲಿ AirTech ಅಲ್ಲಿ in paragraph Milord
ಅಲ್ಲಿ ಒಂದು ಸ್ವಲ್ಪ ಕನ್ಫ್ಯೂಷನ್ ಇದೆ. ಯಾಕಂದ್ರೆ
ಹಾ.
ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ನಲ್ಲಿ ಅವ್ರು ಹೇಳುವಾಗ ಒಂದು ಕಡೆ ಎರಡನ್ನೂ ಮಿಕ್ಸ್ ಮಾಡಿಬಿಟ್ರು ಅವರು.
that
ಆ
is-
ರೀತಿ ಮಿಕ್ಸ್ ಮಾಡೋದು ದಟ್ ಲಿಟಲ್ ಇಟ್ ಗಿವ್ ಸಮ್ ಸ್ಕೋಪ್ ಫಾರ್
ಅದೇ ಆರ್ಗ್ಯುಮೆಂಟ್. ನಾವು ಲಾಯರ್ಸ್ Milord, we are always Milord.
ಕರೆಕ್ಟ್. ಇಂದೂರ್ನಲ್ಲಿ
ಹ್ಮ್.
ಸಾರಿ ಡೆಲ್ಲಿ ಇದರಲ್ಲಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಅದ ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಲ್ಲಿ
ಹ್ಮ್.
ಬೋಪಣ್ಣ ಸಾಹೇಬ್ರು ಎರಡನ್ನೂ ಮಿಕ್ಸ್ ಮಾಡ್ದಂಗೆ ಕಾಣ್ತದೆ. ಬಟ್
Provision contained
ಅದು ಒಂದೇ ನೋಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ನಾವು.
ಇಲ್ಲಿ ಮೇಲ್ಗಡೆ
ಒಳಗಡೆ ಏನ್ ಹೇಳಿದ್ರೆ
ಹಾ.
ನೋಡ್ಬೇಕಾಗ್ತದೆ.
ಅದನ್ನ ಅಷ್ಟೇ ತಾವು
ಕರೆಕ್ಟ್.
ಇನ್ನು ಅದಕ್ಕೆ ನಾನು ಹೆಚ್ಚು ಹೇಳೋದು.
ಗೊತ್ತಾಯ್ತು.
ಯಾಕೆ ಅಂದ್ರೆ ಸ್ಪೆಸಿಫಿಕಲಿ Milord they held that if 80% compensation is not paid, ಹೋಯ್ತು ಅಂತ ಹೇಳಿ.
ಎವ್ರಿಥಿಂಗ್ ಗೋಸ್ ಅಂತ ನಡುವೆ
And all of them must coalesce with each, I mean, all of them Milord, any one of them.
ಒಂದ್ ಪ್ಯಾಕೇಜ್ ಅಲ್ಲಿ ಏನೇನ್ ಹೇಳಿದಾರೆ ಅಷ್ಟನ್ನು ಮಾಡಿದ್ರೆ ಮಾತ್ರ
Correct.
ವ್ಯಾಲಿಡಿಟಿ,
Correct.
ಅದರ್ವೈಸ್ ಇಲ್ಲ ಅನ್ನುವಂಥದ್ದು ಆ ಇಂಪ್ರೆಷನ್ ಕೊಡ್ತದೆ ಅಂತ ನಿಮ್ಮ ವಾದ ಇತ್ತು. ಅದನ್ನ ನಾನು ನೋಟ್ ಮಾಡಿ.
Then Milord, the ಇದು ಮಾತ್ರ ಮುಗಿಲಿಲ್ಲ. 2021 ನಲ್ಲಿ ಜಸ್ಟಿಸ್ Milord ಜೋಸೆಫ್ ಇನ್ ನೋಡಿ
ಯಾವ್ದು?
ಒಂದ್ ನಿಮಿಷ ಕೊಟ್ಟೆ. ಇದು ನಾನು ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೆ. ಜಸ್ಟ್ Milord
ಹಾ.
ಕೊಟ್ಟೆ. ಕೊಡ್ತೀನಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ಇನ್ನೊಂದು ಅಡಿಷನಲ್ ಈಗ ಸೇಮ್ ಥಿಂಗ್. ಪ್ಲೀಸ್ ಕಮ್ ಟು Milord paragraph 37 onwards. This is under 17 itself.
ಹಮೀದ್ ಅಲಿ ಖಾನ್
ಹೌದು,
ಇನ್ಸೈಟ್ ಮಾಡಿದ್ರಿ ನೀವು.
ಮಾಡಿದ್ದೆ ನಾನು.
ಹಾ.
ಜಸ್ಟ್ Milord ಬಿಕಾಸ್ ಇವರು ರಿಪ್ಲೈ ಹಾಕಿ ಅದು ಹಂಗೆ ಹಿಂಗೆ ಅಂತಂದ್ರು.
ಹಾ.
Just to reiterate, please come to Milord para 37 to 40.
37 to 40. ಹಾ.
ಇದರಲ್ಲಿ ಪ್ಲೀಸ್ ಕಮ್ ಟು para 38.
ಅನಾಲಿಸಿಸ್ ಅಂಡ್ ಫೈಂಡಿಂಗ್ಸ್ ಅಂತ.
ಅದೌದು. ಆಮೇಲೆ para 38 ಬನ್ನಿ. 5A Milord, here 5A is Milord dispense with. 5A Milord is an of the act guarantees a right to a person interest in the property, which was the only statutory safeguard to stave off a compulsory acquisition of his property. Power under section 17(4) is discretionary. Being a discretion, it must be exercised with due care. It is true that if there is relevant material, however meager it may be, and the authority has, without being guided by extraneous consideration, applied his mind and taken a decision, then the court would adopt a hands-off approach. In the ultimate analysis, as with any other decision, balancing of conflicting interests is inevitable. Authorities must remain alive and alert to the precious right
Created in favor of the citizens.
which is not meant to be a mere so and so. It is true, decision of this court appear to convey conflicting signals. However, there is a certain element of consensus on the fundamental principle. Dichotomy essentially has to be resolved by carefully attending to the facts of each case. Decision of the bench or the judges in Gabate, so and so, so and so. Then, Milord, paragraph 40. In other words, on appreciation of evidence made available by all the parties, it is open to the court to conclude no occasion arose for resorting to power under section 17(4).
Which indeed must be read as an exception to the general rule.
Acquisition of the property is made after affording an opportunity to the person adversely affected to demonstrate that the acquisition was unjustified. Then, Milord, paragraph 16, ಅದನ್ನೇ ಹೇಳಿದ್ದಾರೆ, reiterate ಮಾಡಿದ್ದಾರೆ.
Yes.
Paragraph 60 to 63, last page. If my lords come to Milord, fourth line, para 62 ಬನ್ನಿ. Sorry, 5 Milord is, they said, fair ಇದು, disputed questions ಅದ್ರ ಬಗ್ಗೆ ಎಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು, para 62, It
We
is
may notice another aspect.
huh,
This appeal arises so and so.
so and so, while issuing notice so and so,
There,
therefore the leave was granted so and so.
after 12 years,
Ah.
the case is
Finally being disposed of. In the meanwhile, Land Acquisition Office repealed right to fair compensations. Therefore, there is no question of the matter being considered for an inquiry being held under 5A. Why, my lord, I am citing this is, ನೀವು ಅದನ್ನ ಈಗ ಇನ್ನೊಂದ್ಸಲ ಮಾಡ್ಲಿ, ಅದು ಬರೋದಿಲ್ಲ. 17, my lord, 17 is a very drastic power.
That itself is an exception to general rule.
And
Therefore,
5,
strict adherence to that.
ಒಂದು, they, my lord, can, my lord, either, my lord, come up with the emergency provision and not dispense with 5A or dispense with 5A. Either dispense ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. 5A is dispense with. ಅದಕ್ಕೆ it is still more extraordinary. In fact, ಇದು ನಾವು ಪುನಃ ಜಡ್ಮೆಂಟ್ ಬೇಡ. ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಮಲಾಡ್ ರೈಟ್ ಇಸ್ ಆರ್ಟಿಕಲ್ 5A is equivalent to the constitution right ಅಂತಾನೆ ಹೇಳಿದ್ದಾರೆ.
ಇದೆ.
Therefore,
Part of 300 capital A ಆಗತ್ತೆ process ಅದು.
correct. Therefore, my submission is, in the light of this mallard judgment, which is after Indore and mallard Delhi airtake, this mallard, there is no application of mind at all, mallard, for emergency provision.
Yes.
ಓಪನ್ ರಿಮಾಂಡು ಲಿಮಿಟೆಡ್ ರಿಮಾಂಡ್ ಬೇಕಾದ್ರೆ ಇನ್ನು 2 ನಿಮಿಷ ಮಾಡ್ತೀನಿ ನಾನು. ಇಲ್ಲದೆ ಇದ್ರೆ ಬೇಡ. ಮಲಾಡ್ ಲಾಸ್ಟ್ಲಿ ಐ ವುಡ್ ಓನ್ಲಿ ಸೇ ದಿಸ್ ಮಲಾಡ್. I will not say anything more. Here is, my lord, a charitable organization under the Bombay Public Trust Act, which, my lord, caters to, my lord, the weaker sections of the society, orphanages, old age homes. In fact, my lord, I have gone and stayed there, my lord, during my college days for the social service camp in this very campus. They, my lord, are doing human service for the society. If, my lord, their land is taken away, and then, my lord, equity, my lord, lies in favor of, my lord, the petitioner before your lordships, and, my lord, in favor of quashing the acquisition. Not, my lord, after 24 years. Maybe, my lord, there was a stay order, but then Shri Gandhat Kaval, my lord, they said, we don't want it. My lords may recollect. Shri Gandhat Kaval, my lord, APMC said, I don't want it. Therefore, my lord, 388 for WP has to be, my lord, allowed on its own. As far as, my lord, the other section 17(4), that 37199 is concerned, section 17, my lord, my submission is judgment, my lord, of Delhi airtake and, my lord, Hamid Ali, all of them, my lord, fully support us. Therefore, on equity, my lord, this is a case where acquisition, my lord, has to be quashed. And ensure that, my lord, Mahatma Gandhi and, my lord, Vinoba Bhaveji do not, my lord, turn in their grave. That's all that I can say. Ultimately, my lord, the state has to be more generous. It can't, my lord, act like a dialogue, is all that I can say, my lord. More than that, I don't want to say anything more. Trustee. Correct, trustee.
Skylark of Merchant of Venice.
Please, my lord.
Skylark of Merchant of Venice.
Ultimately, my lord, see what they are wanting to do. Acquire this, my lord, as of 1999. That, my lord, a pittance.
Yes.
Huh? My lord, that compensation is concerned. We are filing a memo, my lord, saying that we don't want the compensation. We are deleting that prayer.
Lord, to this we would object because after concluding.
Anyway, he is.
I asked myself.
ಎಲ್ಲ ಮುಗಿದ್ಮೇಲೆ ಈಗ
ಎಲ್ಲ ಮುಗಿದ ಮೇಲೆ
ಅವ್ರು ಕೊಡ್ಲಿ ಕನ್ಸಿಡರ್ ನಾವು ಮಾಡ್ತೇವೆ ಬಿಡಿ, ನೀವ್ ಯಾಕೆ ತೆಲಿಗೇಶನ್?
ಎಲ್ಲ ಮುಗಿದ ಮೇಲೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ರು, ಎಲ್ಲ ಮುಗಿದ ಮೇಲೆ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಕೊಟ್ರು, ಎಲ್ಲ ಮುಗಿದ ಮೇಲೆ 4 ಸತಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು.
Lord, we may be permitted to file short synopsis.
even I will file.
ಎರಡು ಸೈಡ್ನವರು
Including my lords on the point.
ಸ್ವಲ್ಪ ಬ್ರೀಫ್ ಆಗಿರ್ಲಿ.
brief.
ಬಟ್ ಅದ್ ಹೆಂಗಿರಬೇಕು ಅಂದ್ರೆ ಇಟ್ ಶುಡ್ ಟೇಕ್ ಮೀ ಟು ಪರ್ಟಿಕ್ಯುಲರ್ ಥಿಂಗ್ಸ್ ಅಲ್ಲಿ
Documents,
Ha.
reference to
Page
the
numbers.
documents.
ಆ ರೀತಿ ಮಾಡಿ.
With page numbers.
Lord, one other request, Lord. If
How-
we can produce the original file, my Lord.
ಯಾವ್ದಕ್ಕೆ
The
ಕೊಡಿ.
pertaining- I'll file it along the memo also.
ಒರಿಜಿನಲ್ ಅಂತ ಕೊಡೋ ಬದ್ಲಿ
ಹಾ.
ಹಾ ಕೊಡಿ
Because your lordship had
ಕೊಡಿ
mentioned earlier.
ಕೊಡಿ. ನಂಗೆ ಇವತ್ತು ಬೇಗನೆ ಕೊಡಿ ಅಷ್ಟೇ.
I'll have
ಸ್ಟಾರ್ಟ್
to
ವಿತ್ ಇನ್
find-
2-3 days.
Yes.
ಒಂದ್ 3-4 ದಿವಸದಲ್ಲಿ ಕೊಡಿ.
ಕೊಡ್ತೇನೆ.
ಅಥವಾ 27th ಕೊಡ್ತೀರಾ?
ಆಗ್ಬೋದು. 27
ಅವತ್ತು ಸಿಟ್ಟಿಂಗ್ ಇದೆ ನನ್ನ perhaps. I feel like
Yes,
that.
all right.
27th ನಂಗೆ ಕೊಡಿ.
ಆಗ್ಬೋದು.
Yes.
ಅದಾದ್ಮೇಲೆ ನಾ ಸ್ಟಾರ್ಟ್ ಮಾಡಿ. ಇನ್ ದ ಮೀನ್ ವೈಲ್ ಜಸ್ಟ್ ಐ ವಿಲ್ ಲುಕಿಂಗ್ ಟು ಈ ಪ್ಯಾರಾಗ್ರಾಫ್ ಇದೇನು ಮೆಮೊ ನೀವು ಕೊಟ್ಟಿದ್ದು? ಮಿಸ್ಟರ್
Yes,
ಹೊಳ್ಳ
yes,
ಹ್ಯಾಸ್
sir.
ಫೈಲ್ಡ್ ಎ ಮೆಮೊ. ಕೌನ್ಸಿಲ್ ಆನ್ ರೆಕಾರ್ಡ್ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ಎ ಮೆಮೊ.
ಪ್ರೇಯರ್ ಇಲ್ವಾ? ಒಂದ್ರೊಳಗೆ ಪ್ರೇಯರ್ ಇರೋದು, ಇನ್ನೊಂದ್ರೊಳಗೆ ಆ ಪ್ರೇಯರ್ ಇಲ್ಲ, ಕಾಂಪನ್ಸೇಷನ್.
ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ
Lord, then opportunity has to be provided.
ಯಾವ್ದಕ್ಕೆ? ನೀವು ಅದನ್ನು ಮಾಡ್ಕೊತೇನೆ ನಾನು.
We object to it
That-
ಅಷ್ಟೇ.
That it's an afterthought after.
Mr. Holla has filed a memo to the effect that
My lord, can I give one citation for my lord's consideration? my lord?
And then
2000 volume 6.
ಅಲ್ಲ ಅವ್ರ ಪ್ರೇಯರ್ he does not want to press ಅಂತ ಹೇಳ್ತಾರೆ.
Lord, after having argued, my lord,
ಕರೆಕ್ಟ್.
and
ನಾ ಪ್ರೇಯರ್ ನಾನು ಐ ವಿಲ್ ನಾಟ್ ಪ್ರೆಸ್ ದ ಪ್ರೇಯರ್ಸ್ ಅಂತ ಹೇಳ್ತಾರಪ್ಪ. ನಿಮ್ದು ಅದಕ್ಕೆ ಅಬ್ಜೆಕ್ಟ್ ಮಾಡ್ರಿ.
that's all.
ಬರ್ಕೊಳ್ಳಿ. ಮಿಸ್ಟರ್ ಹೊಳ್ಳ by filing memo dated 2012-2024 submits that his petitioner does not press the alternative prayer for an order to make the payment of compensation. First, this is vehemently opposed by learned AAG appearing for the state and learned senior panel counsel appearing for the APFC, saying that having argued the matter tooth and nail, at this stage they cannot make such a prayer. First, they also say that it is only an afterthought and therefore should not be permitted.
2000 volume 6, my lord, page 1. It specifically holds, merely because you ask for an alternative prayer, it does not mean that you can't be get. ಬೇಕಾದಷ್ಟು judgment ಇದೆ. ನಾನು
All
ಸುಮ್ಮನೆ
that I
judgment.
can say, my lord, now the effect is seen now, my lord. What is the impact of that prayer is seen by them now.
No, my lord, I'll withdraw that.
That is all I'm
I'll
trying
withdraw
to say.
that.
Nothing more than
It is
that,
of-
my lord.
It is of no
Impact of
consequence.
that prayer. Really.
ಅದು ಯಾವ್ದ್ರಲ್ಲಿ? It is, my lord, under 30, my lord, that hero, ಆಮೇಲೆ in the Herohಳ್ಳಿ land ಇದ್ದು. Not, my lord, in respect of ಶ್ರೀಗಂಧದ ಕಾವಲ್ ನಾವು compensation
ಅಲ್ಲಿ
ಕೇಳಿಲ್ಲ.
ಮೆಮೊ relates to Herohಳ್ಳಿ land and not
Both.
land in
17, my lord, even if I take compensation, my lord, it's of no consequence. ಅಷ್ಟೇ. Grateful, my lord, for the abundant
Thank you.
indulgence that you all have shown, your lordship
ಸರ್,
has
ನಾವು
shown to all of
ಏನಾಗ್ತದೆ,
us.
ನಾವು ಇಂಥದ್ರಾಗೆಲ್ಲ ಹಂಗ್ ನೆಗ್ಲಿಜೆಂಟ್ ಆಗಿರ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ರೈಟ್ಸ್ ಆಫ್ ದಿ ಸಿಟಿಸನ್ಸ್ ಇರ್ತದೆ. ಸ್ಟೇಟಿಗೆ ಏನಾದ್ರು ತಪ್ಪು ತಡ್ಕೊಂಡಿತ್ತು, ಬಟ್ ಸಿಟಿಸನ್ಸ್ ತಡ್ಕೊಳೋದು ಹೆಂಗೆ ಭಾಳ ಡಿಫಿಕಲ್ಟ್ ಇರ್ತದೆ. ಹಂಗಾಗಿ ನಾವು ಅವಸರ ಮಾಡೋವಲ್ಲ ಇವೆಲ್ಲ, ಎಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಸುಮ್ಮನೆ ಏನೋ ಒಂದು ನೀವೊಂದು ಹೇಳಿದ್ರಿ, ಅವ್ರೊಂದು ಹೇಳಿದ್ರಿ, ನಾವೊಂದು ಹೇಳಿದ್ರಿ, ಹಂಗಲ್ಲ. ಇಲ್ಲಿ ದೇ ಹ್ಯಾವ್ ಕಮ್ ಕಂಪ್ಲೇನಿಂಗ್ ದಟ್ ಅವರ್ ಲ್ಯಾಂಡ್ ಈಸ್ ಬೀಯಿಂಗ್ ಟೇಕನ್, ವಿ ಆರ್ ಅಗ್ರೀವ್ಡ್ ಬೈ ದಟ್. ಫೇರ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಆಗ್ಬೇಕ. ಜಜ್ಮೆಂಟ್ ನಾವು ಹಿಂಗಾರ ಬರಲಿ ಹಂಗಾರ ಬರಲಿ, ಅವ್ರಿಗೆ ಏನ್ ಅನ್ಸಬೇಕು.
ಸರಿ, ಕರೆಕ್ಟ್.
ನಾವು perhaps your clients are also here, they should feel ಜಡ್ಜ್ ಪೂರ ವಾದವನ್ನು ಕೇಳಿದಾನೆ ಮತ್ತು ವಾದವನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿ ಜಜ್ಮೆಂಟ್ ಬರ್ದಾನೆ. ಇಟ್ ಮೇ ಬಿ ರಾಂಗ್, ಹೊರಡ್ರೆ ಇದ್ರ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕ್ರಿ. ಅಥವಾ ಮಿಸ್ಟರ್ ಗೌರ್ಮೆಂಟ್ ಮೇ ಸೇ ನೋ ಮಿಸ್ಟರ್ AG ಯು ಪ್ರಿಫರ್ ಅಪೀಲ್, ಇವನ್ KPMC ಮೇ ಸೇ ಯು ಫೈಲ್ ಅಪೀಲ್ ಆನ್ ದಿಸ್ ಅಂತ ಹೇಳಂಗಿರ್ಬೇಕು. ಏನು ನಾವು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದು ಯಾವುದನ್ನು ಕನ್ಸಿಡರೇ ಮಾಡಿಲ್ಲ ಅಂತ ಅನ್ಕೊಂಡು ಅವ್ರು ಹೇಳ್ಕೊತ ಹೋಗೋದು ಬೇಡಾಗಿದೆ ನನಗೆ ಅಷ್ಟೇ. Duly, honestly we'll consider and
then the parents patria principle also I had, my lord, enunciated. That's in fact ಅಲ್ಲಿ ನಾನು ಇನ್ನೊಂದರ್ಥ ತರುವಾಂತ ಮಾಡ್ದೆಲ್ಲ ಜಡ್ಮೆಂಟ್ ಹುಟ್ಟಾಕಿದ್ದೆ, ಬೇಡ ಅಂತ ಹೇಳಿ ನಾನು ಮಾಡ್ಲಿಲ್ಲ. ಅದು ಈಗಲೇನೆ ನಾವು ಸುಮಾರು ಕೊಟ್ಟಿದ್ವಿ ಅಲ್ಲಿ.
argued both they were very efficiently.
ಯೂರಿಸ್ ಸೆಕೆಂಡಮ್ ಅಲ್ಲಿ ಹಾಲ್ಸ್ಬರೀಸ್ ಅಲ್ಲಿ ಹಾಲ್ಸ್ಬರೀಸ್ ಅಲ್ಲಿ ಸುಮಾರು ಪೇರೆಂಟ್ಸ್ ಪೇಟ್ರಿ ಬಗ್ಗೆ ತುಂಬಾ ಇತ್ತು. I thought I'll bring it, but then I didn't want to, my lord. ಈಗಲೇ ನಾವು ಸುಮಾರು ಕೊಟ್ಬಿಟ್ಟಿದ್ವಿ.
That puppy you have done both sides. Appreciate. I learnt some new vistas of equation law. So clarity ಎಲ್ಲ ಬಂತು ನಿಮ್ದೆಲ್ಲ ಕೇಳಿದ ಮೇಲೆ.
Grateful, my lord.
Grateful, thank you so much.
My lordship, may I mention one
ಏನು
one writ petition may be listed on the 2 to 6th of January.
January 2 to 6
of January. 6th actually
6th of January.
6th of January.
ಹೆಂಗಿರ್ತದೆ, DB ಇರ್ತದೆ ಅವಾಗ. ಯಾವಾಗ ನಾವು ಕೊಡ್ತೀವಿ ಅವಾಗ ಮಾಡ್ಕೊಡ್ತೀವಿ.
No, my boss.
Ah.
Thank you, my lord. Obliged.
Wish you all the best and enjoy vacation.
Please.
Mr. Ola, enjoying vacation is also very important. Okay.
Please.
Okay.
Wish you a happy
Thank
vacation,
you.
my lord. And also to the
Thank you
court masters,
so
my lord,
much.
who work so hard like your lordship.
Thank you so much. Okay.
Thank you, thank you.
ಸರ್ ಯಾಕೆ ಏನು ಇತ್ತು? Your appeal. Come.
I represent the person who seeks review of the order. Well, the Honorable Supreme Court has
That expansion of remarks.
expunging, he is there.
I appear for the officers, two of the officers. We had moved an IA in 22, but because the bench changed, it was passed by an earlier bench. The other honorable member of the bench had superannuated. Therefore, the reconstituted bench is sitting today, my lords.
No,
But
I
the
think
issue is,
if my lord grants the relief I seek, that will also be covered.
ನೋಡೋಣ, ಇದು ನಾವು ಓದಿಲ್ಲ. ಏನಾಯ್ತು ನಮ್ಗೆ ನಿನ್ನೆ ಬಂತು ಎಲ್ಲ. We'll fix a date.
my lord, may I mention, my lords?
ಹಾ.
I will not make any reference to the merits of the case.
Expansion now we may not do that easily.
My lords,
Many aspects ನಾವು consider ಮಾಡಿವಿ. Supreme Court order ನೋಡಿದ್ವಿ ನಾವು.
my lords,
It is for you to seek expansion at the hands of this court. Then you can go come here ಅನ್ನೋ ರೀತಿಯಲ್ಲಿ ಬರ್ತಾರೆ.
please.
ನಮ್ಗೆ ಅಷ್ಟೊಂದು ನಮ್ಗೇನು, ಯಾಕಂದ್ರೆ ನಾವು ಆ ಆರ್ಡರ್ಸ್ ನಲ್ಲಿ ಒಂದ್ ಸೆಟ್ ಆಫ್ ಆರ್ಡರ್ಸ್ ನಲ್ಲಿ ಹಿಂಗ್ ಕೊಡೋದು ಕಾಂಪನ್ಸೇಷನ್, ಇನ್ನೊಂದ್ ಸೆಟ್ ಆಫ್ ಆರ್ಡರ್ಸ್ ನಲ್ಲಿ ಈ ರೀತಿ ಕೊಡೋದು.
ಇಲ್ಲ, ಇಲ್ಲ.
ಹಂಗಾಗಿ we may not agree as of
No,
now.
I will not go into the merits of it, my lords.
Ha.
That the learned senior will argue that matter.
Not
because
today. We have a function.
There
now.
are references to that. My lords, my career prospects are being affected, my lords,
ಹೌದು.
because for 2 years I have kept the IA pending, my lords.
ಅದು ಅದೇ
Consider-
ಅಬ್ಜೆಕ್ಟ್ಗೆ ಇದು ರಿಮಾರ್ಕ್ಸ್
ಅಲ್ಲಲ್ಲ,
ಕರಿಯರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಶುಡ್ ಬಿ ಮಾರ್ಡ್ ಅನ್ನೋದಕ್ಕೆ ಅದನ್ನ ಮಾಡಿರ್ತೇವೆ ನಾವು.
ಅಲ್ಲಲ್ಲ, for
ಬರೀ ಅಬ್ಜೆಕ್ಟ್ ಅದು.
my lords, but the Honorable Supreme Court
ಹಾ,
gave me an opportunity to make an appeal.
ಎಕ್ಸ್ಪ್ಲೇನ್ ದಟ್ ಅಂತ ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಒಂದು ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ರಿ. ಇವತ್ತು ಬೇಡ. ಕರಿಯರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಹಾಳಾಗ್ಲಿ ಅನ್ನೋದಕ್ಕೆ ಆ ರೀತಿ ಮಾಡ್ರಿ. ದಟ್ ಇಸ್ ದಿ ಆಬ್ಜೆಕ್ಟ್.
My lords,
The very object of making it is that one only, not for anything else at all.
my lords, not on that aspect. my
Ah.
lords. If ultimately your lordship were to think that I must be in the dock, I will have to suffer the consequence. I am referring only to the prospects which are affected because due to the administrative exigencies, for 2 years, nearly 2 years, the IA was pending, my lords.
ನಂಗ್ ನೆನಪಿದೆ.
Therefore,
I remember every paragraph.
Grant me leave to, but they, in the memorandum of review petition,
Ha.
I have referred to certain matters which were considered by Supreme Court. The Honorable Supreme Court said, please place it before the High Court ಅಂತ ಹೇಳ್ತಾರೆ. ಅದನ್ನ ಕೊಡ್ತಾ ಇದೀನಿ.
ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಮಾಡೋಣ. All these matters. ಯಾವ್ದ್ರಲ್ಲಿ?
short date.
ಫಸ್ಟ್ ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಮಾಡೋಣ ಅಂತ ಯಾವ್ದ್ರಲ್ಲಿ ಆಗಿಲ್ಲ ಇದ್ರಲ್ಲಿ
ಇಲ್ಲ,
ನೋಟಿಸ್ ಮಾಡಿ ನಿಮ್ಮಿದ್ರಲ್ಲಿ
ಆಗಿದೆ ಅಂತ ಕಾಣುತ್ತೆ.
ಆಗಿಲ್ಲ.
ಅಲ್ಲ ಕೊಟ್ಬಿಡು.
ಅಷ್ಟ್ issue
ನಾಟ್ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಂತ ಸಾಕು ಅಷ್ಟೇ.
ಅಷ್ಟೇ. ಇಶ್ಯೂ ನೋಟಿಸ್ ಇವೆಲ್ಲ ಇದು ಅಷ್ಟು ಅದಕ್ಕೆ ಇದು ಸೇಮ್ ಇದೆ ಏನೋ. ಓಕೆ. ಶ್ರೀ ಶಾಂತಿಭೂಷಣ್ ಲರ್ನಿಡ್
ಇಲ್ಲಿ
ಕಲಬುರ್ಗಿ ಅವರು ಬರ್ತಾರೆ.
ಫಾರ್ ವಾಂಟ್
DAG
ಇಲ್ಲ,
DSG
DSG.
DSG of Kalburgi bench is requested to accept notice for first respondent. Second ಯಾರಿದ್ದಾರೆ? ಅಲ್ಲಿ AG. ಅಲ್ಲಿ ಮೋಸ್ಟ್ಲಿ ಇವರು ಯಾರು ಮಾನವೇಂದ್ರ ರೆಡ್ಡಿ ಅಪಿಯರ್ ಆಗ್ಯಾರನು ಅಂತ.
ಅವನೇಂದ್ರ
ಹಾ,
For railways, I think.
ಕರ್ನಾಟಕಕ್ಕಲ್ಲ,
It's a railways.
ರೈಲ್ವೆ ಸಿಗದು.
ಇಲ್ಲ ರೈಲ್ವೆ
ಆ,
1 and 2.
ಆ,
One is the beneficiary.
ಹಾ.
Deputy Commissioner is the acquiring authority. State of Karnataka
Right,
he
definitely.
has
See,
authorized.
Senior panel counsel Shri Manvendra Reddy is requested to accept notice for Respondent Union of India. ಫಸ್ಟ್ ಅಲ್ಲಿರೋ AAG ಇದ್ದಾರಲ್ಲ, ಯಾರಿದ್ದಾರೆ ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬಿಡಿ. ಅವರು ಇದ್ದಾರಲ್ಲ, ಅರ್ಚನಾ ತಿವಾರಿ ಅವರು, ಈಗ ಜನ ಎಲ್ಲ ಗೊತ್ತಿಲ್ಲಲ್ಲ ನಮ್ಗೆ. ಹಾ, learned AGA is requested, AGA
2 and 3.
Kalburgi bench is requested to accept notice for respondents 2 and 3. 2 and 3. First off,
Copies to be served and acknowledgement to be filed.
review petitioners to file a copy of the petition on the learned advocates appearing for the respondents 1 to 3. 1 to 3 and file acknowledgement in the
Yes, sir.
registry. First, ಅಲ್ಲಿ ಒಂದ್ ಕಡೆ ಮೇಲ್ಗಡೆ ಬರೀ heard learned senior advocate Mr. SP Shankar for the review petitioners. Okay.
And the earlier judgments referred to are filed ಅಂತ ಅಪ್ನ ಕೊಡಬೇಕು. If my lord permit, otherwise I'll have to file it in the counter.
Petitioners or review petitioners are permitted to file the judgment and material which they want to bank
Refer
upon,
to and the review petition.
bank upon in support of the review petition in the registry. Okay.
The last working day, ಅದರಿಂದ ಕೆಲಸ ತುಂಬಾ ಇರುತ್ತೆ.
No problem.
The lordship speaks a short date, my lords.
Then post this matter, when this combination sits,
Any Friday, my lords, may be convenient.
Friday night, ಬೇರೆ ದಿವಸ ಬರೋದಿಲ್ಲ.
Can it be 10th of January?
IA disport of.
Yes, please.
ಇದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಆಗೋದು ಬೇಡ ಇದ್ರಾಗ
ಇಲ್ಲ.
ಬೇಡವಾ?
That is only between your lordship and.
And the court and the
Yes,
judges who made this, the order.
please. Can
Thank
it
you.
be on the
All the
10th?
best. Huh?
10th, my lords, can it
Huh?
be on the 10th of January?
Any day, whenever we sit single. But 10th ಅಂತ ಯಾಕಂತೀರಿ, next ಅದಕ್ಕಿಂತ ಮೊದಲೇ ಕೂಡಂಗಿದ್ರೆ ನಾವು
ಇಲ್ಲ, ಆದ್ರೂ reopen ಆಗದೆ.
That's first Friday, ಇರ್ಲಿ.
First
ಇರ್ಲಿ
Friday.
ಬಿಡಿ sir.
ಅದಕ್ಕೆ
ಆಯ್ತು.
whenever this.
Whenever the honorable bench sits.
Okay. Same ಅಲ್ಲ ಅಲ್ವಾ? ಕಾಲ್ ಎಲ್ಲದು ಸೇರ್ಕೊಂಡು ಕೇಳ್ಕೊಂಡು ಮಾಡಿಬಿಟ್ರೆ ಆಯ್ತು, ಸಪರೇಟ್ ಇರ್ಲಿ.
ಇದಕ್ಕೆ ಹಾಕಿದ್ರೆ because this is a special bench, it cannot change, my lords.
That's what.
So
ಬಿಡಿ ಸಾಬ್ರಿ. ಆಯ್ತು ಹೇಳ್ಬಿಟ್ರಾ? ಆಯ್ತಾಯ್ತು. ಅದು ನಮ್ ಕೈ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಬಿಡುದಿಲ್ಲ.
ಇದಕ್ಕೆ 2 ವರ್ಷ ಆಯ್ತು sir.
If the order is recalled,
Correct. Then I will.
you are saved.
Correct.
ಅದಕ್ಕೋಸ್ಕರ ನಾವು silently we should work for recalling the order and have prepared the ground.
ಇಲ್ಲ ಸರ್, grounds ಇದೆ.
ಇಲ್ಲ, then I can tell them, no, no,